All right, good morning, everyone. I'd like to call to order the Judiciary Committee public hearing for Friday, March 7th. We have 10 bills on our agenda today. This is our second substantive public hearing, so brief reminder of the ground rules. We have a strict 3-minute clock. Please be sure to limit your remarks to 3 minutes. If you've submitted written testimony, we do not need you to come up here and read us your written testimony. I'll repeat, please do not come up here and read us your written testimony. You can summarize key points if you'd like, but we already have it. It's in front of us on our laptops. If you're here testifying with someone else on the same bill, feel free to come up together. We'll limit you to 3 minutes, but we can certainly take questions from both folks. It'll help us move things along. We don't allow swapping of spots or orders. If you get skipped and time permits, we'll allow you to speak at the end of the hearing. We do have a relatively full list today. It is a Friday, so we'll ask folks to help us move it along. With that, we'll get started. First up will be Russell Blair.
Good morning, Senator Winfield, Representative Staffstrom, Senator Kissel, Representative Fishbein, members of the Judiciary Committee. My name is Russell Blair. I'm Director of Education and Communications at the State Freedom Information Commission. I'm here today to draw attention to Section 4 of Senate Bill 1436, an act concerning police data reporting requirements. This section would shield from public disclosure any record pertaining to a formal complaint filed against a police officer prior to such complaint being investigated and adjudicated by the proper legal authority. This section really deviates from the rest of this bill, which seeks to strengthen reporting of police data. Some of our concerns include, if an officer retires or resigns from a department while a complaint is under investigation and it's not adjudicated, the public may never know the circumstances that led to that. There could also be a concern if an officer transferred departments before such an investigation was concluded, would there be any disclosure of what prompted that investigation at the first department? And there also could be circumstances where a complaint is made and there is no investigation that is done. And, based on this language, potentially that department could withhold that complaint in its entirety. There's some questions too about, what does adjudicated mean? Who is the proper legal authority? Would this apply to complaints of criminal conduct? There's other statutes that require disclosure of, certain criminal records. Our Supreme Court has said when you accept public employment, you become a servant of and accountable to the public. So we think records reflecting somebody's performance as a police officer, there's an intense public interest in having access to those records. Just a few years ago, this legislature overturned union contracts that provided for withholding of certain personnel information relating to internal investigations. There is an existing law that allows for non-disclosure of information in personnel records that would be an invasion of personal privacy. So, depending on what the issue is, there is an exemption that deals with certain personnel records already. And just a couple of examples I want to highlight recently about the importance of having access to this information even before an investigation is concluded. Very recently, the city of Hartford was searching for a new police chief. They actually had a press conference and announced who their new police chief was going to be. And it turned out that police captain was under investigation in Philadelphia. There were 2 sexual harassment complaints that had been filed, and I actually read an article this morning that there's now a federal lawsuit that has been filed. That gentleman has since rescinded his acceptance of the city of Hartford's offer, but that's just one example. Another example, recently in East Lyme, their police chief was suspended and put on paid leave following his arrest on domestic violence charges. And the first selectman in that town actually spoke to the press a little bit about what was going on with that investigation. He was challenged on that, and he defended that and said that, preserving public trust in our police force requires a certain amount of information concerning an investigation be provided to the public. Be happy to take any questions that any members of the committee have.
Fishbein.
Thank you, Mr. Chairman. Good morning.
Good morning.
Taking this out of the police context, let's take a teacher. a teacher is accused of an illegal act in the course of their employment and they retire. What is the status of whatever investigative report or complaint in that scenario?
So I think the report would have to be disclosed unless, you know, the commission or a court determined it was an invasion of personal privacy. For personnel records, that is the standard. And what our Supreme Court has said is an invasion of personal privacy for a public employee means that it's information that would be highly offensive if it were to be released and that does not pertain to a matter of public concern. So if it doesn't meet that burden and it's a personnel record, then it has to be disclosed. So even if they retired, if there was a copy of a complaint in their personnel file, you know, that would be subject to disclosure unless it met that, you know, two-part test.
So the difference that's potentially created by this legislation is merely because the individual is a police officer.
Yes, exactly. This legislation would treat complaints against police officers different than complaints against other public employees.
So let's take it to the, public safety sort of situation. What about a firefighter? How is a firefighter treated? in this
It would be
realm?
the same. The personnel records statute, you know, that covers all personnel records of all public employees, state employees, you know, municipal employees, you know, anything in a personnel file. The standard is always has, you know, been invasion of personal privacy and based on that two-part test.
Now, those are municipal officials come under the auspices of state because municipalities are creatures of the state. What about a federal, like an FBI agent is accused of doing something in the course of their employment? How is that treated under FOI?
So if somebody were to request records about an FBI agent, those would be governed by the federal FOIA law. The federal FOIA law does have different exemptions. I'd probably have to do a little bit more research to see exactly, you know, what may apply. But if it was an FBI officer, you know, you would have to request it from the FBI and then it would go pursuant to whatever the federal FOIA exemptions are, some of which are different than, you know, what Connecticut has.
Okay, no, I appreciate that. I just trying to keep everybody in line, right? Public safety, employee of the government, law enforcement. So no, I appreciate it. So thank you, Mr. Chairman.
Thank you.
Further questions on this? Further questions? If not, thanks for being with us this morning. Next up will be Farrar Garland. Farrar Garland with us? Oh, okay, thanks.
Good morning, distinguished members of the Judiciary. My name is Farah. I am predominantly a disability and queer rights activist and have been for many years, but by necessity, my work is deeply intersectional. There would be no LGBTQ+ or disability rights without people of color standing with us, and I am proud to get to do the same in return, well, metaphorically. On that note, today I am here to speak in support of HB 7132. It is a common sense measure that will reduce racial disparities in traffic stops for non-safety related offenses. Being pulled over by an officer is the most frequent interaction that the public has with the police. And statistically, we know that Black and brown motorists are disproportionately stopped. We also know that looking at cases like Tyre Nichols, Philandro Castile, Duante Wright, and Anthony Vega Cruz, that these stops can sometimes turn deadly. I am confident that this is not the impression that any of us want for people to have of our law enforcement. HB 7132, which is based on recommendations by the Police Transparency and Accountability Task Force, which includes several police chiefs along with other members of law enforcement, would allow our cops to focus their efforts on dangerous driving behaviors instead of things like a single broken headlight, improper license plate display, or minor obstructions on the windshield like fuzzy dice. This bill, it just makes sense. It not only reduces potential pretextual stops of Black and brown drivers, but it would save lives in a wide variety of ways by, again, allowing our law enforcement to focus on actual dangerous driving instead of being bogged down in low-level infractions. For instance, one local study found that a single headlight, broken brake light, etc., accounted for 24,000 stops, but contributed to only 0.1% of crashes. Over in Newington, defective lighting violations were 40% of their traffic stops, but only one of those 1,608 stops that year actually resulted in the driver being charged with a DUI. After they shifted their enforcement priorities, they found a 250% increase in stops, resulting in DUI arrests. In 2020, our New Haven police chief reprioritized traffic enforcement to focus on dangerous driving after finding significant racial enforcement disparities. The next year, the department reported equipment and administrative offenses were reduced by 6%, accidents dropped by 15%, and crime by 5%. In conclusion, this common sense bill not only cares for your Black and brown constituents, but also has the statistics behind it to show that it will reduce crime as well. It seems like an easy win-win, which is why I am, once again, asking you to please support HB 7132. Thank you so much for your time
Thank you.
today.
Questions from the committee? Questions from the committee? Seeing Representative Fishbein?
Hey, Mr. Chairman, I just want to ask you, you said that a single headlight led to 24,000 stops?
Yes,
Was that a single headlight on one car?
yes. So that would be vehicles that have like a single headlight out. Yes,
Okay, so that's a little bit different. So you're talking about multiple vehicles allegedly with one headlight out led to 24,000 stops.
yes.
Not
So-
one headlight on one particular, somebody got pulled over 24,000 times.
No. This is not one
Okay.
person being stopped
Well,
24,000
I'm just
times.
listening to what you're saying. Of the 24,000 stops, do you have the racial disparity of those stops?
I do not have that information with me, but I can cite the study if you would like to reference back to it.
Yeah, what is that study?
Absolutely. So this is a study done by Ross, Jesse Kalinowski, and Kenneth Barone. It's testing for disparities in traffic stops, best practices from the Connecticut model, and 19 criminology in public policy. And that is from 2020.
Okay, so that's, you mentioned, was it Ken Barone?
Can you say that again?
One of the individuals that you mentioned, was that Ken Barone?
Kenneth Barone, yes.
Yeah, okay,
That was one of the folks on the study, yes.
understood. Okay, thank you. Thank you, Mr. Chairman.
Further questions or comments? Seeing none, thanks for being with us this morning.
Thank you.
Chandra Campanelli?
Good morning, gentle folks of the judiciary. My name is Chandra Campanelli. I am a registered nurse of 18 years. I hold dual board certifications, and I have had the privilege of touching over 10,000 patient and client lives. I have worked at the bedside, in the emergency room, in various clinics, and in private practice, specializing in harm reduction for people who utilize psilocybin therapeutically. I am speaking in emphatic support of decriminalization of possession of psilocybin, or HB 7065. For something to be deemed criminal, there should be established evidence that it has high risk of harm to self or others. In a study of adverse reactions to psilocybin published in the Journal of Psychopharmacology out of Oxford, it stated that out of 9,233 past users of psilocybin, only 19 reported to the emergency room. Those visits were primarily youth having used mixed substances, reporting anxiety. The symptoms were short-lived and self-resolving, meaning no intervention was needed. It doesn't even fall on the radar of comparison to reasons why people visit the ER each day. An article published by Johnson et al. In the Journal of Neuropharmacology in 2018 demonstrated psilocybin to have the lowest potential for abuse, dependence, toxicity, harm to self, and harm to others. It was measured against a host of narcotics, controlled substances, and pharmaceuticals, as well as cannabis and tobacco. The current research environment surrounding psilocybin has demonstrated efficacy in treating many diagnosed conditions and is being studied for many more. But here's the most important thing, the thing that you need to know. The benefits are widely reported for the walking well. This means people who have no medical diagnosis or illness. These benefits include increased health-related behaviors, improved mood, increased creativity, increased problem solving, and increased empathy, not behaviors associated with criminality. The evidence shows that not only is the risk of harm to self and society very low, but the benefit to self and society is quite high. Citizens who have this information at their fingertips are not waiting for legislators to catch up. They are utilizing psilocybin, and they are not criminals. They are Connecticut citizens, and it's extraordinarily unethical under multiple frameworks to felonize the use of psilocybin. My ultimate position is legal adult use. However, if step one is to stop making criminals out of citizens, then you should start by passing this bill. People who live otherwise lawful lives should not be criminalized for personal use of a substance that is natural, safe, and oftentimes assists in improving psycho-emotional and physical health.
Thank you.
I challenge you to set the tone that suggests Connecticut wants the best
Question.
quality of life for its citizens.
Thank you, ma'am. Questions or comments from the committee? Representative Fishman.
Thank you, Mr. Chairman. You mentioned felonizing. Where does that come from? Because my understanding is that what's before us doesn't felonize, and there's no ask to. So what I took from what you said was don't felonize the possession of psilocybin. I'm just trying to figure out where that's coming from.
You're right. It's not a direct argument against what's being presented because it's currently a felony. And
Okay, so you'd have a change.
yes,
Have you been, we heard a lot about this last session and the utilization and all of that. Have you been directly involved in the utilization of this product?
I show up for people who do utilize this substance. I help to keep them safe, and I help to teach them how to manage an emergency if one arises. People are using this substance.
I didn't say that people aren't using the substance. My question was your direct knowledge of individual. Have you been in the room with someone who has utilized this substance?
I have.
Okay. And we heard, are you aware of these trip monitors, I think they're called?
You're speaking such as in Oregon and Colorado, guides or facilitators,
No, I'm
things of that
talking about
nature.
Connecticut. We are in Connecticut, and were you involved in this last year?
I spoke up about it.
Okay. And we heard about trip monitors, I believe they were called, here in Connecticut.
Okay.
Are you aware of that process?
I am aware of it in the current framework that allows for research. Yes.
Okay. So we had at least one individual come to us and tell us that it was necessary to have an individual with them to monitor their trip, so to speak, to make sure they didn't harm themselves or perhaps someone else while they were under the influence of this substance. Are you aware of that?
I am aware of that. There are many different ways that people utilize this. One of those ways is very therapeutic and includes a trip monitor. Yes, I'm familiar with that.
Okay, and as you did tell us that you're an RN.
I am.
So, is there some sort of guidance medically with regard to the utilization of trip monitors when one is to use this substance?
And an argument can be made that if one is particularly prone to anxiety and has a fear of doing what some would call a full trip, that a trip monitor can be helpful. There's no established evidence that a trip monitor keeps one safer, but that's also because there's very low safety risk involved. It sounds prettier than what is necessary.
Well, what sounds prettier, having the trip monitor or the trip itself?
It's more publicly palatable to suggest that a trip monitor is necessary.
Okay, thank you. Thank you, Mr. Chairman.
Representative Tigliano.
Thank you, Mr. Chairman. Good morning. Just a quick question. Do people only use this substance under a controlled setting, or if you decriminalize it or legalize it as your ultimate goal, can they use it at any time?
So people are utilizing it in both uncontrolled and controlled settings. Obviously, folks have been using it recreationally for a very long time. Still, even with that, very, very low harm. But you can expect what you see, what exists now, which is people using it individually as well as in a controlled setting.
How long does the drug stay in your system, even after maybe some of the apparent effects have subsided?
There is no trace in your bloodstream after 24 to 36 hours. The psychedelic effects are typically gone between 4 to 6 hours. That's also dose dependent. A lot of folks engage in what is called microdosing, which is a very low dose that produces no psychoactive effect.
And so I'm gathering that you wouldn't recommend anybody operate heavy machinery or an automobile if they've either under the influence or if they've just recently taken it.
No, sir. I believe it should fall under the current DWI laws.
Is there any effective test a law enforcement officer could use to see if somebody is impaired by taking psilocybin and operating a vehicle?
I think there are certainly cues, but I don't know of any established scientific test
So an
that
officer would have no way to know, like, say a breathalyzer that they could do for alcohol, they would have no way to know if somebody's under the influence of psilocybin driving an automobile.
sans their judgment, such as in the case with cannabis, I would say no.
Okay, thank you, Mr. Chairman.
Representative Howard.
Thank you, Mr. Chair. Good morning, and I just want to, Representative Tigliano asked a few of my questions, but when you said it's palatable, I think I want to make sure I understood you about having a trip monitor. I think what you meant was folks are more likely to legalize it knowing that there's going to be trip monitors. Is that what you meant
I
by
think
palatable? I'm trying to understand what you meant by that.
I think that is what I
Okay.
meant by that, but I also think that folks are also very there's a lot of anxiety experienced by the folks who seek this medicine.
Got
And
it.
for those people, it can be a much comfortable and for that reason, safer experience with a trip monitor.
I understand. So yeah, more palatable for people using it as well, that they'll feel safer that if something bad happens, there's somebody there to make sure that they can call for help, so to speak.
Yeah,
Okay. And then you said that you're not aware of any scientific test for the levels, which I'm in agreement. I'm not aware of them either. Do you think that psilocybin impairs one's ability to drive?
yes.
All right. So when we legalized marijuana here in 2021, and I understand we're decriminalizing it and not legalizing it. That's an important distinction. But we also decriminalized marijuana right before we legalized it, right? So when we decriminalized or legalized marijuana in 2021, a lot of other things were going on too. And I'm not, it was right after COVID. There was quite an anti-law enforcement campaign going on in this country and specifically in the state. Traffic stops have plummeted. But my point is the fatality rate on our highway of crashes has increased significantly in the last few years. That's a fact. Nobody disputes that. A lot of questions as to why, and I think many of the things I just mentioned are spokes in the wheel. I'm not pointing to any one. Do you think that the legalization of drugs, without police officers, well, let me ask you this. Do you know if the police officers in this state have any training in recognizing individuals that are under the influence of psilocybin?
I don't believe they do. And I also believe that that is because there is such a low incidence of traffic accidents and violations occurring under the influence of psilocybin that it has not been worth the research. I think at this time it would be worth the research, but it hasn't existed because it wasn't necessary. Very different from alcohol. We knew without doing the research. We asked the questions, we did the research, we made the laws.
So that's interesting to me. So how can we know that, right? So in other words, if there's 1,000 crashes, say in the state of Connecticut this year, as an example, right? And our police officers have no training in recognizing people under the influence of psilocybin. There's no scientific test that we're aware of that tests for it. And under Connecticut law, the only time somebody has to submit to a blood test, for example, is if there's a fatality, right? But if you take that out, and even if I don't know if that can be tested for, I assume maybe it can. How can you know of those 1,000 accidents whether psilocybin was involved or not?
At this point, you can't know. And it begs certainly a lot of questions to be asked going forward. I do know that if you look into the research that has been done, people don't make the choice very often to choose because of the level of alteration that they have. And the level of alteration that they have can be very apparent to the onlooker. It would be very unlikely for a police officer to come in contact with somebody who's altered under psilocybin and not feel as though there is something off in this person based on the way they're speaking, answering questions, their eye movements and such.
And police officers in this state are trained on that?
To my knowledge, they haven't had a reason to be.
Okay, so my interest in this is the public safety part, because I've read a lot about this. We had a public hearing about this last year. A lot of folks came before us, and I imagine many on our list today will say, hey, this helps me with a lot of issues that I'm dealing with. I get it. And I'm a constitutionalist at heart, right? I mean, make decisions for you that don't affect me. I'm happy with that. But I have to drive on our highways, right? I have to drive an hour and 15 minutes and 63 miles to get here every day, and then the same thing home, right? So do you think that it would be responsible of the state to be prepared? Because I would argue that we were ill prepared to deal with marijuana and driving before we legalized it. And now we have a high fatality rate. Again, maybe in part because of that, maybe not, I don't know. Do you think it would be responsible of the state to get our police officers up to speed? The standardized field sobriety tests on alcohol are measured to a 0.10 standard scientifically. Some sort of testing measures that can be done on the side of the road to make sure that our public safety personnel are prepared for that first? Or are you saying, and I think I understood you earlier, it's not necessary because people under psilocybin, unlike alcohol, where they'll make a decision to drive, people under the influence of psilocybin that are impaired, their brain doesn't make that decision. So I know it's a long question, but where do you fall on that line? I want to understand because you have the background.
I don't think that training needs to occur prior to decriminalization. I think decriminalization is standalone. Again, folks under the influence of psilocybin are unlikely to choose to drive. And I don't think that training needs to be a priority insofar that it needs to be a priority for any other of the thousands of substances we put into our body each day that we have no idea how it impacts our mind and body and reaction time and other markers of harm and danger.
Right. So that would include like caffeine, nicotine, things that
Sure.
are legalized, but they're all intoxicants to a degree, or maybe not intoxicants, but their chemicals are putting in our body. That's your point.
Yes, sir.
Right. Yeah. And I don't disagree. So I thank you for coming. I thank you for providing the information with your experience and being here today. Thank you, Mr. Chairman.
Thank you.
Further questions? Just quickly, So psilocybin is currently legal in the state of Massachusetts, correct?
That's not correct.
No, I thought.
No, there are municipalities that have decriminalized, but their most recent efforts failed. It is not legal yet. It is legal in Washington and Colorado under a regulated medical model as well as it is decriminalized outside of that model.
Okay. What do you mean by municipalities in Massachusetts? There's certain municipalities that's legal in Massachusetts?
Yeah,
Okay.
places like Northampton and some of those surrounding areas.
Okay. Okay, thank you. Further questions? No. Thanks for being with us.
Thank you.
Anderson Curtis.
Good morning. Hello to the co-chairs of Judiciary, ranking members, and all the other members of the Judiciary Committee. My name is Anderson Curtis. I'm the Senior Policy Organizer at the ACLU of Connecticut. I'm here to urge you to support House Bill 7132, which focuses on traffic enforcement on genuine safety concerns rather than minor technical violations. We all want safer roads, but we also know that every traffic stop makes it safer. Not every traffic stop makes it safer. Right now, people are getting pulled over for broken taillights, slightly obscured license plates, things that studies show don't actually cause accidents. What these things do cause, though, is stress, fear, and far too often racial disparities in policing. The data is clear. Black and Latinx drivers in Connecticut are more likely to be pulled over for these minor infractions than white drivers, even though these stops have no meaningful impact on public safety. And, you know, there's a lot of data around this bill, whether police officers' time could be used better, chasing high-speed chases and DUIs. But I want to present some data today that may not be in these studies. For instance, my lived experience is data. So for me, a few years ago, I was pulled over in Vernon, leaving a friend's house. My vehicle was registered, insured. I have a current driver's license. I didn't have my seatbelt on. I was about to get onto the highway, and there was a safety check. So I got pulled over to the lane. I gave the officer my paperwork. And before he left the vehicle, I asked him, I said, am I going to be okay here? Because my trauma overwhelms my logic. Even though I have insurance, even though my car is registered, even though I have a driver's license, in those 5 to 10 minutes when the officer goes back to his car, my trauma takes over and I believe I'm going to go back to jail. And those 5 or 10 minutes feel like an eternity for me. And so that's the data that I want to present today. Sometimes people don't have the emotional intelligence, self-control, whatever, to handle themselves in that situation, and they panic. I'm not saying that makes it all right what they do when they panic, but they do panic because people are what? Human. And we all have flaws. We all have shortcomings. So all I'm trying to say is that, yes, there's data that supports that officers' time could be better used with other traffic safety things that do actually cause incidents, but also there's other things to consider when looking at bills, such as the human factor, what people actually go through when they're pulled over. And so if you don't have that experience, if you haven't been pulled over because your skin is a different color, you may not know that. And I'm just here to share that with you today. I just want to say this bill is simple. It makes the rules clear. It's not about outdated or things that we want to get rid of, right? But it's every traffic stop causes harm. I urge you to support House Bill 7132.
Thank you, sir. Questions or comments from the committee? Questions or comments? Senator Winfield.
I just wanted, Anderson spends a lot of time with us. I just wanted to thank him for continuing and to say that your point about the experience is important and something we should consider. I've been in a position where currently the chair of this committee, but I've been a face that folks have known, at least as it relates to these types of issues for a long time. And when I get pulled over, despite the fact that I've been told that there are not many people who are in law enforcement who don't know my face, when I get pulled over, I'm very concerned too. So I recognize the importance of your testimony. Thank you.
Thank you, Senator.
Thank you for being with us. Next up will be Amanda Walwin.
Hi, I'm here remotely today.
Go ahead, ma'am.
All right. My name's Amanda Walwin. I'm a state policy advocate with the Innocence Project. The Innocence Project is a national organization that represents wrongfully convicted clients across the country. We also work to enact state-level policy reforms that prevent and reveal wrongful convictions. Post-conviction DNA testing can prove innocence, but it can also identify the actual perpetrator of a crime, thereby delivering justice not only to the wrongly convicted, but also to the crime victim and the public. Of the first 375 exonerations based on DNA evidence, the true perpetrators were subsequently detected in 50% of those cases. These 165 people committed an additional 154 violent crimes, while an innocent person took their place in prison. We support House Bill 6983, which removes the incarceration requirement from the post-conviction DNA testing statute and adds an explicit right to appeal the denial of a motion for post-conviction DNA testing. Often, people who are wrongfully convicted are not able to demonstrate their innocence while they remain incarcerated. Luis Figueroa spent 11 years in prison for a 1995 rape that he didn't commit. In 2007, Mr. Figueroa was released on probation. Because he was no longer incarcerated, he could not petition the court for post-conviction DNA testing. However, he filed a FOIA request seeking evidence in his case. An assistant state's attorney reviewed his files and discovered an unseen 2009 report that excluded him as a contributor to the DNA evidence found from the attack. The state's attorney cooperated in Mr. Figueroa's exoneration, and their motion to vacate his conviction and dismiss the charges was granted in 2014, 19 years after he was convicted. Mr. Figueroa's exoneration happened in the face of systemic failures. Had the state's attorney who reviewed his files not noticed the report, recognized its exculpatory nature, and shared it with him, Mr. Figueroa may never have been exonerated, since even if a judge had believed that he may be innocent, that judge would not have been able to order the testing of any remaining DNA evidence. With this statutory change, judges will still serve as the gatekeepers to post-conviction DNA testing, ensuring that frivolous requests for testing are denied. This bill will simply permit them to grant testing in cases when they believe it could have probative value in a potential wrongful conviction. Additionally, while Connecticut currently has a practice of permitting an appeal of the denial of a motion for post-conviction DNA testing, we recommend codifying that practice into statute, as this bill does. We also recommend lifting the guilty plea bar on evidence preservation for all murder, felony assault, sexual assault, and robbery crimes. The vast majority of cases do not go to trial but are disposed by plea. However, we know that innocent people do plead guilty to crimes they didn't commit. In fact, in Connecticut, 20% of exonerees pled guilty, including Mr. Figueroa. Without reliable access to correctly preserved evidence, wrongfully convicted people will not be able to demonstrate their innocence. Like Mr. Figueroa, their exonerations will be left to chance. I've included recommended language for this provision in my written testimony and have been in conversation with the Connecticut Forensic Science Laboratory to determine how this policy could be implemented.
Thank you.
Thanks.
Questions from the committee. Representative Howard. All right, we're being polite. Representative Fishbein.
Thank you, Mr. Chairman, and thank you, Representative Howard. Thank you for coming here today. This is an area that certainly interests me. Your comments at the end about codifying an appeal, do you have proposed language with regard to that?
I do. It's in the bill, actually.
That's the last section, right?
Exactly.
Okay, so that's okay. You gave me the impression there was something missing from the bill.
Oh, no, the evidence preservation piece is not in the bill, and I'll include language there in my written testimony.
Okay. The area that I was concerned about in the language before us, in line 5, essentially, it appears in order, the gatekeeper here is that there's a conviction and a sentence of incarceration. And I think some of your comments went to this. You know, sometimes people are convicted of a crime or they plead guilty to a crime, and the sentence is probation. my reading of this language would be that that individual would not be able to get the DNA evidence. Am I missing something there?
You're not. We did not go that far in this bill draft. And certainly if that's something that you support, Representative Fishbein, we'd be happy to talk about expanding the language. I don't think that that would be, that we would have any problem with that. Yeah.
Okay, I'm just, on the other side, I'm concerned about if the judicial branch or perhaps law enforcement may have a storage issue or something like that, or an ability, I don't know how many
Mhm.
cases that would necessarily open this up to. But, I am very interested in this area. And that's all. So thank you, Mr. Chairman.
Representative Howard?
Thank you, Mr. Chairman. So as a follow-up to that, and good morning, I don't see your written testimony on this bill yet. Hopefully it'll pop up and I can look
Mhm.
at it. So I'm in agreement with actually probably the whole bill, but I understand the need that, just because somebody's not incarcerated anymore, they still need to clear it up, and we don't want people walking around convicted of crimes they didn't commit. But nothing in here, as I read it, would require any additional storage of DNA. Are you in agreement with that?
Yeah, that's correct. So the evidence preservation piece will be in my written testimony that will be submitted shortly. And we have been talking to the state laboratory about that.
So this is what's interesting to me, because is your written testimony going to suggest that there is longer retention of DNA evidence?
Not longer retention, but lifting the guilty plea bar. Right now, if someone has pled to one of these crimes, their evidence preservation is not the same as if they had been convicted at trial. And we know that people do plead guilty to crimes they did not commit.
No argument on that, but that does increase retention, though. That is an increase in retention time, isn't it?
Not in, well, not in time, but in the number of cases, yes. And that's something we're discussing.
Well, how would it not be? This is what I'm trying to drill down on. So I handle an evidence room at a police department. So if somebody gets arrested and there's evidence that's never introduced at court because they plea bargain out, evidence is either reported to the court, as I'm sure you know, on a JDCR 18 or JDCR 52. Then the court at the disposition day sends that JDCR 52 or that JDCR 18 back to the police department and says what to do with all of the evidence, which is destroy it and somehow return to the owner. If it's a firearm, it goes to the state, it gets destroyed. If it's drugs, it gets incinerated, et cetera, et cetera. But if under what you're suggesting on that guilty plea, that anything with DNA would have to be held at that point, which is
Yes.
a longer retention time, isn't it?
Yes. I apologize. Yeah, I misunderstood. Yes, you're correct. And so
Right,
it is
so-
something that we need to discuss with the uh, the the state lab and the law enforcement that's holding on to the evidence.
Right, and that was the key point, because we need to discuss it with law enforcement, not just the state lab. There's a bill in another committee right now where the lab is at their storage limits on certain things, actually that can contain DNA, and are sending them back to the police departments. But I think we just need to be mindful that police departments' storage of stuff is not digital data. These are rooms. We passed a bill here a few years ago that requires police departments to hold on to firearms indefinitely. That takes up space. It's important. So I just hope that that's considered going forward. And I'm glad to hear, because I heard you say you're going to talk with the state lab, but I'm glad now you said law enforcement as well, and I appreciate that.
Yeah, happy to do that. And, I can say that, we support the resources that would be needed to be able to make this happen.
And the last line of the bill as it exists I'm in agreement with, because it seems to suggest, and tell me if I'm misreading it, that once the denial once a court denies it, then there's no need to keep that DNA anymore. So that would be sort of if you would, the finish line for the retention of that DNA. Is that your reading of that too?
Well, what it would do would create a right to appeal which is something that happens in practice in Connecticut, but isn't actually codified. So there would be one more shot at the apple so that someone could go one level up and make an appeal of that motion or an appeal of that denial. But then that would be the final disposition.
Got it. So that would be the final. Okay, understood. Thank you. Thank you very much. Thank you, Mr. Chairman.
Thank you.
Further questions or comments? If not, thanks for being with us.
Thanks so much.
Catherine Saris.
She wants.
Good morning, honorable members of the committee. My name is Catherine Saris, and I am a performing artist and educator from Fairfield County, Connecticut. I firmly believe that all persons are created in the image of God and are endowed by their Creator with the inalienable rights to life, liberty, and the pursuit of happiness. Everyone, no matter how much we disagree or are uncomfortable, deserves to be treated with dignity. As I read the first section of SB 1380, I have grave concerns that in seeking to protect certain groups in our society from discrimination, we are instead opening the door to discrimination to certain other populations. I am a survivor of childhood sexual assault. I experienced traumatic, violative behavior between the ages of 5 and 10. And this caused my childhood self to believe that being a woman was a position of weakness, that it would subject me to greater sexual assault, and so I rejected my own body. If I had been offered puberty blocking drugs in my preteen years, I probably would have taken them. I experienced suicidal ideation beginning at the age of 7, and it was only as an adult later on that I realized that my feelings of self-hatred and self-rejection stemmed from my childhood trauma. Gender-altering drugs and surgeries were not available to me as a minor growing up in the 80s and 90s. I was not subjected to the lie by schools and society that told me that I was in the wrong body. Instead, the resources at my disposal were a loving family, good youth leaders at my church, and counselors. I thank God that I had people in my life who loved me enough to repeatedly remind me that I'm a girl, that being female was a good thing, and that my life is precious. If SB 1380 is passed, professional counselors, or according to the bill, persons working for the office of a counselor, could face criminal charges for offering alternative paths to healing for persons like myself, a child with gender dysphoria. There are many persons who previously adopted a sexual or gender identity that later in life proved not to answer their struggles. Many have found that actually it was healing from childhood trauma that has caused them to be restored to their true identity. And I have a whole book here of their stories, and you can check them out at changedmovement.com/stories. There is much documented damage from these experimental procedures and interventions known as gender-affirming care. I see the damage in my students, in the lives of my artistic colleagues, and in the bodies of some of my dearest friends. SB 1380, as written, will victimize children who have experienced trauma at a young age by limiting their paths to deal with their self-hatred, narrowing it to gender-altering drugs and therapies that fail to deal with the underlying causes.
Thank you, ma'am. Questions from the committee? Questions from the committee? If not, thanks for being with us.
Thank you.
Josh Britt.
We're gonna skip over Josh Britt and go directly to Nicole Mears, if that's okay.
Okay, so we're gonna skip Josh Britt. We're gonna go to number 8 on our list, which is
And
Nicole
Assistant Attorney General Josh Britt is moved with.
Demers. And if you could identify yourself for the record, sir.
Sure. My name is Assistant Attorney General Joshua Britt. Thank you.
Oh, so together. Okay, so you guys are coming up together. Got it. Perfect.
Senator Winfield, Representative Staffstrom, Senator Kissel, Representative Fishbein, and distinguished members of the Judiciary Committee. Thank you for the opportunity to testify in support of House Bill 7072. This bill is intended to fortify the Attorney General's ability to keep Connecticut markets competitive through the enforcement of the Connecticut Antitrust Act and federal antitrust laws. The Connecticut Antitrust Act expresses a very broad public policy. Connecticut markets serve our citizens best when they are truly competitive because competition incentivizes business to do many positive things. Among those things are to offer lower prices, enhance the quality of their goods and services, and continually strive to innovate and improve wages and working conditions. And those are just some of the benefits when we have a strong competitive market. At a high level, the Connecticut Antitrust Act outlaws harmful competition, anti-competitive practices, such as price-fixing agreements, market allocation schemes, and attempts to monopolize markets and maintain those monopolies. In order to enforce these laws, the AG is charged with investigating and civilly prosecuting entities that engage in these kinds of anti-competitive practices. With that in mind, the Attorney General is committed to protecting the citizens of Connecticut from harms of illegal anti-competitive conduct. And this bill, if passed, will strengthen and respond to changing markets by updating the enforcement tools provided to the Attorney General. Specifically, House Bill 7072 would strengthen the AG's abilities to scrutinize anti-competitive mergers and acquisitions, obtain disgorgement remedies in antitrust enforcement actions, and resolve antitrust enforcement investigations efficiently through assurances of voluntary compliance. These are meaningful additions to the Connecticut Antitrust Act, and this will allow the Attorney General to much more effectively and efficiently execute the charge he has been given. And he urges passage of House Bill 7072.
Thank you. Let me ask, have you guys had a chance to look at the testimony on this from the CBIA?
Yes,
Okay,
we have, as
So-
well Connecticut Hospital Association.
right. So they have concerns with section 2 of the bill as written that seems to suggest that private litigants who have not suffered actual harm would be able to bring a claim for disgorgement. I don't know if that's the intent of the bill or if that's just a drafting issue, but if you could comment on that.
I will, and I'd like to do so in 3 parts. And I would first like to bring everyone's attention to section 2. And I believe it's the second sentence where it reads, after saying you may sue for equitable relief, including restitution, disgorgement, and for injunctive relief, that in such actions, the court shall follow the rules and principles governing the granting of equitable relief. Currently, it says injunctive relief. We're looking to change it to equitable relief. So I do think that addresses much of the CBIA's and the Connecticut Hospital Association's concerns, while allowing the statute to be flexible because it imputes current case law into the section. So the court, which has great discretion and flexibility, would follow those rules and principles. With that, and the office is in support of it being flexible, although not commonly used, private litigants, it's been noted by often referred to as the Dean of American Antitrust Law, Herbert Hovenkamp, that theoretically private litigants who cannot quantify their damages should be able to seek disgorgement. It is not commonly done in antitrust. The CBIA and the Connecticut Hospital Association is correct. However, we do not have Supreme Court case law on it. We have Second Circuit appellate court, and it was addressing consumer protection, not an antitrust law specifically. So we do advocate that it's included and that flexibility remains. And I want to note why before also returning back to their point. And that is, markets are changing. And we have a lot of markets where people pay with their private information. They don't pay with monetary payment, right? And so sometimes it is very difficult to calculate damages. And in these changing markets, we should be flexible to respond to that. And I think this would allow that kind of flexibility. However, if the legislature in their wisdom determine that it's best to cabinet just to the Attorney General's office and not permit it to private litigants, that is certainly an understandable position.
Okay, I mean, I guess I'm just, I'm not a antitrust scholar, and I'm not up on the research on this, but I'm trying to picture how that would even work. So I'm a litigant. I can't prove my actual damages or harm, but I'm one of several folks who's been damaged as a result of some anti-competitive act. Am I allowed to disgorge all of the profits of the bad actor or just my commensurate percentage of it? And then how do I figure that out? How do you prove that? I guess just practically speaking, I don't see how you could kind of get there.
So let me take a step back. I feel like we could apply a similar question to many antitrust damage questions that you've just posed. But the court shall follow the rules and principles governing the granting of injunctive relief. So I think that that really gets to the heart of your question. We have case law. Plaintiffs aren't allowed to double dip when it comes to monetary payment of some sort. There's case law in this area. It's mostly focused in trade practice areas where private plaintiffs are allowed to obtain disgorgement. So I think that that's a bit of a red herring question, although I greatly appreciate it, but that's how I would respond to it.
Okay. Further questions or comments, Representative Fishbein?
Thank you, Mr. Chairman. Does the Attorney General in your office support the private right of contract?
I would assume so, yes.
Okay, with that assumption, let's move forward. I'm going to give you a scenario. Two companies, Pullman and Robinson, okay? Pullman wants to purchase 20% of Robinson. They put out a press release. We're buying 20% of Robinson. Under this language, can the Attorney General start to do discovery, ask for the contract, ask for their financials?
Are you referring to the analog to Clayton Act Section 7? Are we switching?
I'm in section 1, actually, where it says it's shall be unlawful for any corporation
Okay.
to acquire directly or indirectly the whole or any part of the stock or assets of another corporation where the effect of such acquisition would be to substantially lessen competition or tend to create a monopoly in any line of commerce. I'm talking about that. Where is the trigger?
So Representative Fishbein, you have then in fact moved from Section 2, which I was speaking with Representative Staffstrom, to Section 1. So looking at that section, our office is already able to enforce that language through Clayton Act Section 7.
Okay, so in the scenario that I gave you, Pullman is purchasing 20% of Robinson. They put out a press release.
Yes.
Under current law, you're saying that the Attorney General's office can demand that contract and the financials for those two companies.
No, I'm not saying that.
Okay, so I'm looking at what is proposed before us. We are making it unlawful for any corporation to acquire, so on and so forth, as I read, right?
But the so on and so forth is key. You said
Okay.
20%. It's not saying that. It's say where the effect of such acquisition may be to substantially, which I do want to know, we should have acquisition may be substantially to, that was our error. Substantially to lessen competition. We have.
Well, how does one ascertain?
That's an excellent question, because we would start with the US DOJ and FTC merger guidelines that were just updated in December 2023. Section 2 of those guidelines provide for a number of approaches. And the Herfindahl measurement, it's very, very particular. But if I can simplify it for all of us, knowing many of us here are attorneys, but there are presumptively anti-competitive, highly concentrated mergers that our office would look into, and we would use that as a guideline. And it's also not just a guideline. The courts very much adopt what is in the merger guidelines when they analyze cases. So what would the AG's office practically be looking at when we're going from, you know, from 3 to 4 firms to now only 1 to 2 in the state? That's when it becomes concerning. That's when entities can charge anti-competitive prices. That's when we get less choices, less innovation, and
That's not what this,
essentially less services, quality services.
okay, but that's not what this says.
But that's what it means.
I understand, but, you know, this is the Attorney General of our state asking us for the power to do certain things. And I mean, subjective, I don't know what substantial is, right? Because substantial to you could be substantial to me,
The
right?
case law explains that, and so do the merger guidelines to help us reach that. We already, with federal partners, can bring this cases just like this under Clayton Act Section 7, but you are getting to the heart of it very astutely, Representative Fishbein, because this allows us to use our investigatory power when we
Which I have a
believe.
lot of problems with.
But we can do that already with federal partners.
Well, I think there's an open question on certain areas that the AG's office has stepped into, and I don't need to get into that specifically here today. I'm just trying to ascertain, based upon a press release, Pullman is purchasing 20% of Robinson. What that allows the AG's office to then do to Pullman and Robinson, who are private entities, not involving the government. What does
Okay.
this language allow them to do?
So I want to answer that practically, okay? First, we would do research. Is the market highly concentrated? We're interested in addressing the incredible market consolidation that is going on in the state of Connecticut in numerous areas. That's what we're interested in doing. We're not interested in going after small service areas that have no great impact on Connecticut citizens. That would be a waste of our enforcement discretion. That would be a waste of our key resources. So we would first start with research and we would look into it. And if we found a presumptively high market concentration indicating this is leading to significant concerns, presumptively, we would probably start with an inquiry, talk to the parties, and then maybe if founded, follow up with a CID.
But what right do you, I mean?
What right
this
do we
language-
have? Because we're enforcing the antitrust laws.
Okay, I'm gonna step in. All right, we seem to be talking over each other a little bit, so let's make sure we finish the question before we start to answer and vice versa. Representative Fishbein, you have the floor.
Thank you. You know, I understand the AG's office is given a lot of power, but this doesn't say create a monopoly, just create a monopoly. It clearly says lessen competition, which businesses do all the time when they acquire their competitor, or, you know, or they just want to grow. So I understand, you know, some people don't want businesses to grow and some people are jealous of businesses, but I'm trying to figure out under why I would ever support making it unlawful for a corporation to acquire directly or indirectly the whole or any part of the stock or assets of another corporation where the effect of such acquisition may be to substantially lessen competition.
Do you want me to respond?
Sure.
Okay. So it says the acquisition may be substantially too. So it's going to substantially. Nobody doesn't want businesses to grow. Certainly the Attorney General's office is not business growing. That leads to a thriving state and community business, a community and business market. We already have this authority under Clayton Act Section 7. We can bring complaints and go through the discovery process pursuant to litigation. Here it would be, and I would think maybe sometimes preferable, they would prefer that we had the authority to investigate and, like we very often do, come to the conclusion, no concerns here. I do not think that our investigatory power is abused, but by any means, but here we are asking supporting an enactment of a section that allows the Attorney General's office to meaningfully enforce antitrust laws. Let me give you an example. The healthcare market in Connecticut. It is consolidated. I think we would all agree that it is highly consolidated. You just look at the numbers. Now, a tool to use before the consolidation happens, whether it's healthcare or any other markets, is a tool like Clayton Act Section 7. And we would like to have an analog, like many other states have this analog. For example, Washington, Idaho, Maine, and New Jersey, because we would like to address issues in their incipiency rather than after the damage is done, and it is much harder to address the conduct.
So Pullman and Robinson have issued the press release. The Attorney General's office decides we want to get information from these two private entities. And then we are going to review their let's say their contract, their financials, the bylaws, because that 20% may mean something substantial at the end of the day. And then ascertain whether or not we think that it was substantial enough to bring it to a court for litigation. Well, of course, before you even get there, you have the threats of harm by the AG's office, but potentially litigation. That's the process by which this legislation would permit.
No, I don't agree to that
Okay,
hypothetical.
Where do you?
Similar to many other antitrust investigations where we use our investigatory authority, we do research prior, obviously, to issuing one. We just don't issue CIDs willy-nilly. And if we believed that a merger was leading to a substantial consolidation in the market, substantially lessening competition, then there's a number of avenues. We could start with an inquiry. We could start just talking to the businesses about it. Depending on where that went, we may issue a CID, a subpoena. All the information they share is non-public and confidential. The investigation itself is non-public and confidential. And based on what we learn, we determine next steps. I want to point out we don't, because you used in your hypothetical threats by the AG's office. I reject that characterization. And after we looked at it and we issued the CIDs, we would work with the parties to obtain that information, and we would explain why, as the investigation progressed, we reached a decision, sometimes taking as short as 6 weeks, sometimes taking as long as 2 years. And to be frank, and of the ones that we've reviewed in the past 5 to 10 years, we're thorough, we're careful, and the goal is to enforce the antitrust laws carefully and enforce them thoughtfully. And I think the legislature's enactment of the notice of material change for both healthcare physician group practices and the cannabis businesses indicates their will for us to look at businesses who merge and what the effect is, and to, if necessary, bring an investigation. I can't think of why we would have those notice of material change statutes otherwise.
So based upon the press release and the inkling, you don't have any information before you. So you're sending letters to two private companies, Pullman and Robinson.
We probably wouldn't do that if
Well,
we had no inkling.
how would you be able to evaluate whether or not it's substantial without getting information? You have to get information. The only place you can get that from, for the most part, is from the entities.
No, we can conduct research and find out how many law firms are in the state of Connecticut, and there's many. So I don't think we would have a problem with that. But that's, based
But
on
you
my
wouldn't-
hypothetical.
You wouldn't know the terms. You wouldn't know the impact to the potential business.
But we're looking just at the market share concentration through this section. We're not looking at other anti-competitive conduct.
So it's your testimony here today that given this power, you will not ask private entities for information about their businesses.
No, of course, that's not my
Okay.
testimony. The section is to review acquisitions. They excuse me, the language is so specific, lessen competition or tend to create a monopoly. That's very specific. I think you're raising important questions, Representative Fishman, but it's not what the section is intending to address. And we have another section in our Connecticut Antitrust Act that says we look to federal law to help us interpret state law that is practically an analog. So we have an analog to Sherman Act Section 1 and 2. And so we look to federal law to help us interpret our sections. And the same would be here with this analog to Clayton Act Section 7.
So the press release says that the transaction is going to close next month. You start to do your research, you reach out to the businesses for certain information. What happens to that transaction if you haven't gotten the information, or you're still in the course of your investigation of whether or not it would substantially lessen competition?
Can I answer that question in two parts, may I?
Absolutely.
Okay, so first, based on the, I'm going to go to your very specific hypothetical. We probably would not do that because Josh and I and the other 7 individuals in our antitrust section would look and see how many law firms there are in Connecticut, and there's no way this merger is substantially lessening competition. And that's the end of the inquiry. But let's say it's not. There's only 3 law firms, and 2 of them are merging. We would then ask, because it would almost on its face, prima facie, rebuttable, but prima facie lead to substantially lessening of competition and leading to a monopoly. We would then issue a subpoena requesting information. And then likely the parties call, we talk to their attorneys, and sometimes we're able to work out conditions where mergers are able to go forward. In a merger that led to only 1 to 2 in the market, probably not. We would probably recommend blocking the merger.
So the question was, what happens to that transaction that's supposed to close in a month if you're in the middle of your investigation?
Similar to what would happen under Clayton Act Section 7 currently. And that would be that we would tell them we'd prefer you not close, but if they do so at their own risk because they may have to unwind the deal later on.
Thank you. Thank you, Mr. Chairman.
Thank you very
Further
much,
questions or
Representative
comments?
Fishbein, for those good questions. And I'm
Further
glad that you
questions
fleshed
or
it out.
Representative Howard?
Thank you, Mr. Chairman. Good morning. I came in at the beginning of your testimony. I apologize to step out for a minute, but I did hear you say that you could work with federal partners to do this already.
Yes, we can work with federal partners to do this already. We cannot do it as efficiently without federal partners. And so why that is for the very reason Representative Fishbein astutely keyed into the question. You will now have investigatory power to look into these mergers through the Connecticut Antitrust Act.
Okay, so it would be imperative that you work with your federal partners even still.
No, we would not need to work with our federal partners if this section was passed.
Okay, but there's federal law that does this already, that the federal government investigates, is that right?
Yes.
So if the Attorney General's office has that power to enforce it, would you still need to work with your federal partners if they're violating both laws?
No, we would not need to. We would not be required to. And that's a great question as well, because enforcement agencies have bandwidth, right? We only have so many resources. And so sometimes our federal partners will make the decision to go after certain or investigate certain anti-competitive conduct. And sometimes they won't. And state AGs increasingly over the past 10 years have stepped in to fill that void and investigate where the federal partners have decided not to or don't believe they should go after the anti-competitive conduct in both cases.
So the state should step in to prosecute those laws that may be federal violations too, even though because the feds just aren't keeping up.
This is how I would characterize it. I would characterize it this way. We would have the option to step in when our federal partners don't have the bandwidth or otherwise decide not to bring such an investigation or enforcement action.
Would you bring an investigation the feds already were if this bill passed?
I don't think that would be that would of course be the ultimate decision of the Attorney General, but I would not recommend that that's a wise use of resources.
If the federal government did an investigation and they didn't bring charges, but you still thought there was a violation of this passed, would you go for it then?
States could, they certainly could.
And would you request of the federal government whatever information they had that could help you?
We could use a common interest agreement to do so, depending on administrations that may vary the cooperation level that is received by either government
Understood.
agency.
I'm just trying to make sure we're not doing things twice. And my other
Oh,
two
we're
more-
definitely not doing things twice. And if I can hone in on that better for you,
Sure.
please. Okay. So
I find civil law fascinating. That was a joke.
Antitrust law fascinating or civil law?
Not
Okay.
sure.
So the reason we are not doing things twice is because although we have Clayton Act Section 7, we do not have investigatory power pursuant to the Clayton Act. We have an investigatory power pursuant to the Connecticut Antitrust Act. So we would like this section so that we could move pursuant to our investigatory power to learn more about our concerns, wasting the resources of bringing a complaint and dragging entities into court when we could have much more easily investigated first. And maybe even off-ramped and come to a resolution and not have to bring litigation.
All right. And then in line 16 of the bill, it says lessen competition or tend to create a monopoly. How do you determine tend to create a monopoly? Is there like a legal, and I was being facetious about civil law. I know criminal law pretty well. The civil laws, I'm learning it through this committee and I'm grateful for it. But how would you, is there case law on that? How do you define tend to create a monopoly? Who decides that?
There's a substantial amount of case law on that. And I would say that the two main resources are federal law, federal decisions, and also the DOJ and FTC merger guidelines. And the most recent ones were just released in December of 2023. I think hadn't been updated for about 10 years. They're updated periodically over the years. And Section 2 provides a number of approaches and how to calculate whether something is tending to create a monopoly. And to me, in layman terms, it's that example of, are we talking about now having 1 to 3 businesses in the market versus 4 to 6 versus 8 to 12? You know, that's the continuum. When you start getting down to 1 to 3 businesses in a market, I think we can all agree from just everyday experience, that's when super competitive prices are going to be able to be charged.
All right. And then the last
The
section.
other harms.
Okay, section 3, on line 47, section 3 talks about that the Attorney General can accept assurance of voluntary compliance, but in line 46, it says, thereafter, any evidence of violation of such assurance shall constitute, I always said prima facie, but you said that a different way, however you said it.
Prima facie, but I
Right.
think both work.
All right, shall constitute prima facie proof of violation of the applicable law. So am I reading that if I'm not a lawyer, which I'm not, does that mean that if the Attorney General says, hey, we think you're in violation, and I say, okay, I'm going to rectify the violation, and then I change my mind, or I think maybe the Attorney General was wrong, or I can make a case, I've basically already sort of admitted guilt in a way?
No.
As that's written?
No. It's a really good question. And first I want to point to assurances of voluntary compliance are commonly used. In fact, our state uses them also for civil rights and consumer protection violations already. We just want one specifically for antitrust. Other states, if I may, other states that also have assurance of voluntary compliance specifically for antitrust is Massachusetts, Maryland, and West Virginia. States that have these assurance of voluntary compliance for any civil enforcement, so very broad, are New York and California. They're very powerful tools because instead of reaching an agreement and having to enforce it just through contract law, We're doing it pursuant to the act. And so, yes, it almost has the effect of a court order. So you violate this and, we can use this as prima facie proof, rebuttable again, but that you violated, the Antitrust Act.
Well, prima facie is always rebuttable, right?
Of
But it
course.
just shifts the burden of proof, right?
Yes.
So that's my question. Do the other states have that same language too?
Oh, yes,
They have the same language?
yes, and we've cited the statutes.
Okay, thank you very much. Thank you, Mr. Chairman.
Thank you, Representative. Comment or question from members of the committee? Representative Benzino.
Thank you, Mr. Chair, and Attorney Demers. Thanks for joining us this morning. I've learned a lot from this discussion. I'll start with section 1. I just have 2 quick questions. I know in the previous lines of questioning, you were talking about investigatory powers at the outset of an antitrust action. I get why that would be a helpful tool for the office. I just want to kind of hone in on how that practice plays out now. So my understanding is basically when you have probable cause of antitrust related activity happening, you're limited to whatever public information is available. You talked about information on the market. You talked about information that you could look at that's available to everybody. And then beyond that, if you want additional information that is with concerning the private activities of a business, you have to basically file an injunction, seek discovery, and get that information through the court process itself, right? Is that kind of how it plays out if you want that additional information that you would get if subsection B of section 1 was passed?
So I think it would be helpful if I took a step back and just addressed some assumptions made in your question. So if we have a reason to believe that the Antitrust Act is being violated, we can issue voluntary requests for information. We can issue CIDs. We can conduct interviews, all of which is non-public and confidential, to learn more about, what's happening. And we usually, I would like to say, maybe a funnel approach, right? We like to start with talking to the parties, requesting voluntary compliance, and then moving to subpoena. More and more, I will admit, sometimes we just move to a subpoena because parties feel it's a waste of time. Well, you asked me and now you're asking it in a subpoena. We will also conduct interviews as we learn more and more information, right? And so just speaking to this section proposed, if we start to have real concerns that the effect of this acquisition will be maybe substantially to lessen competition or lead to a monopoly, that's when we would issue a subpoena to the entities involved and gather even more information.
Okay, I understand that.
Okay.
That's a helpful kind of overview of what's at your disposal right now. And just a quick question on section 2. I know we talked about that a little bit earlier, but you had mentioned that, so existing law under 3534, consumers and the AGO can seek an injunction. You had mentioned that it's very infrequent for individual consumers to seek an injunction as a form of relief. I'm just curious as to how infrequent, if you have anecdotal evidence on that.
Not as to injunctions, as to disgorgement, because private plaintiffs almost always can calculate their damages, their individual damages. But sometimes it, like in trade practice cases and other matters, not antitrust, it is much more commonly used. And as I said, theoretically, as Herbert Hovenkamp has noted in some of his treatises, it is so time consuming, so difficult, so almost impossible to calculate your damages. The appropriate equitable remedy that the court may determine in its discretion based on current case law could be the ill-gotten gains of the business. So what their anti-competitive conduct allowed them to gain. So it is a very narrow, unlikely remedy used by private plaintiffs. but certainly we appreciate the Connecticut Hospital Association and the CBIA raising a question about it. And, that is understandable. It could be cabined to just the Attorney General. However, I will note that I think the section where it says if the court issues an injunction or orders other equitable relief, no, excuse me, I'm sorry, one sentence prior. In such actions, the court shall follow the rules and principles governing the granting of equitable relief.
Okay, thanks for the clarity and thanks for your testimony today. I appreciate it.
Thank you.
Thank you, Representative. Comment or question for members of the committee? Comment or question? Seeing none, thank you very much for joining us this morning.
Thank you very much.
And next we have Nicole Hayes.
Yes, good morning. Can you hear me?
We hear you well. You may-
Wonderful, wonderful. Well, good morning, members of the Judiciary Committee. I am Nicole Hayes, Executive Vice President, also serving as Director of State Public Policy for the American Academy of Medical Ethics. The AAME subscribes to the traditional values of the Hippocratic Oath and serves as an ethical voice to speak to state government, media, the public, and other entities on bioethical issues facing the healthcare profession and to support policies that advance human flourishing in our nation. We oppose Senate Bill 1380, and I'll tell you why. I, along with our AME healthcare professionals and state directors in Connecticut and in states across the country, agree that every person is based with an inherent dignity, born with an inherent dignity. This requires that healthcare professionals care for patients based on that inherent dignity, not permitting them to decline to serve a person or patient based on their race, skin color, or sex, or any other protected characteristic. Senate Bill 1380, though, oversteps this by requiring ethical healthcare professionals to ignore biology, to ignore their medical training and their morals, particularly when it comes to caring for a patient struggling with gender dysphoria. Biological sex is assigned at fertilization and is not a fluid social construct that can be changed at will. Children who struggle with gender dysphoria should not be subjected to mutilating surgeries and experimental treatments, but treated rather with compassion, help, and understanding. By Senate Bill 1380, including gender identity or sexual expression or sexual orientation, it implies that an ethical healthcare professional who refuses to perform or recommend a mastectomy or a gender dysphoric patient would otherwise be discriminating against said patient, rather than being viewed as caring for that patient's well-being. Senate Bill 1380 assumes that the patient's whims are right and biology has it wrong. Senate Bill 1380 must be amended to allow for the conscience freedoms of Connecticut healthcare professionals to be protected who would otherwise be morally injured for going against their medical and scientific-based evidence and their values. It is critical that medical professionals have a well-functioning conscience and are not penalized for it. Healthcare professionals are called to heal and not to harm, to truly care for patients as a professional, not as a vending machine that capitulates to patient demands. Senate Bill 1380 would harm patients and cause moral injury to healthcare professionals by forcing them to perform for or refer for procedures and treatments that violate their ethics, scientific values, and scientific training and their values. I ask that you strongly consider the harm that would come to Connecticut's patients and healthcare professionals if Senate Bill 1380 is passed as it is currently written. Please vote no on Senate Bill 1380 and amend it to include healthcare conscience freedoms. Thank you.
Thank you.
Mhm.
Comment or question, Representative Howard.
Thank you. Thank you, Doctor, for being here.
I'm not a doctor, but I work with
Oh, I'm
many.
sorry.
That's all
I'm
right.
sorry. I apologize. Well, see
That's all
that
right.
I gave you a compliment. I hope you took it that way.
Thank you.
Sometimes people call me senator, and I tell them I didn't call them any names. But
Next.
in lines 4 and 5, I wanted to ask you or somebody in this field because I was concerned about that, right? And I think we're all in agreement that everything contained in Section 1, up to and including gender identity or expression, sexual orientation, should not ever prohibit somebody from getting the proper care from a physician or really anything else for that matter.
Correct.
But
Correct.
in this narrow context. But my question was going to be, and I think you answered, I want to make sure I understand. I was going to ask if a doctor feels that it's not medically appropriate as written or even medically dangerous as written, do you think that they would either be forced or be held accountable for not doing it?
They could be. I mean, this bill is very ambiguous and vague, and the fact that it does not in anywhere include healthcare conscience freedoms or protections. We need to see the language in there. Otherwise, you could just have to assume that the healthcare professional would be penalized for even using their best judgment if the patient demanded that this particular procedure or treatment was something that they wanted. So this needs to be included in the bill so that we can ensure that healthcare conscience freedoms are in fact protected for Connecticut healthcare professionals.
So if what you're asking then is to create, we use the word carve out here. I'm not really carve out's maybe the best term here, but create language in the bill that gives doctors an opportunity to make the point that, well, this was not medically appropriate. In my medical opinion, we should not be doing this regardless of what the person wants. Like, so if I walk into my
Correct.
doctor's
Correct.
office and say, you know, I want to not have one of my ears, can you please just cut it off?
Right.
The doctor can say, no, I'm not cutting your ear off for no reason. There's nothing wrong with it, right?
Correct.
That doctors can use their medical experience to say this is not appropriate. That's what you're asking. Am I correct?
That's what I'm recommending. Absolutely. Thank you for clarifying.
All right. Thank you very much. And thank you for being
you.
here. Thank you, Mr. Chairman.
Absolutely.
I have a question for you in response to your response to Representative Howard. Part of the bill says nothing in this section shall be construed to require the delivery of fetal health care, affect the professional standard of care, or interfere with public health planning. The professional standard of care doesn't matter. I guess what is your response to that being in the bill?
What we're saying is healthcare professionals are going to provide care, the care that is required of any patient. However, if there are medically inappropriate or inappropriate procedures or treatments that the patient is asking for, or if there are procedures that are being asked for that violate the conscience of that healthcare professional, there should be language in this bill that would protect them from performing or having to capitulate to the patient's whims that are not medically appropriate.
I'm going to leave the conscience alone for a second, but I want to get to the professional standard of care because your response to Representative Howard seemed to suggest that if there is a professional standard of care, this bill would require a violation of that, and the bill specifically excludes that.
So you're asking, a healthcare professional is going to carry out the care needed for that patient so long as it is medically appropriate. They're not ignoring their duty to care. They are, though, pushing back on a possible procedure that would harm.
I just want to clarify. So
yes.
In your conversation with Representative Howard,
yes,
what you suggested was that if there was a treatment that wasn't in line with the professional standard of care, given how this bill is written, one would have to provide it. This bill says that you would not have to do that. And so I'm trying to get how you.
Yes. Well, to be honest with you, this bill is still ambiguous and that we don't know what that. I work in a number of states and I've seen it in too many ways when the bill is ambiguous and not emphatically clear. One can assume that it's not necessarily clear in how it's defining professional because states are going to say, well, this is protected healthcare in our state. Gender affirming care is protected healthcare in our state. And so we're saying that for a healthcare professional that has a conscientious objection to quote unquote, what this state might be dictating as professionally care that might violate the doctor's conscience. This language is not in the bill and should be in the bill, that it clearly defines and allows for that healthcare professional to not be compelled, I should say, to perform a procedure that is against their conscientious values.
There are two different things, right? And I'm perfectly happy to have an argument about both, but a professional standard of care and one's individual conscience are two different things. And so I just want clarity because you are.
I would say, not to interrupt, just saying that.
I'll let you.
Sure, go ahead.
I will
absolutely
let you respond.
Okay, sure.
You are here representing and are the director of state public policy for medical ethics group. So
yes.
I'm trying to understand the position that the group holds and
Hippocratic values. So we're saying that it is the physician's duty to care and not to harm.
And I will let you respond.
Yes.
I just want to get the question out though. And so it seems to me, as I listen to you, two things are being conflated that are important conversations, but are separate things themselves, right? The individual's conscious, what they feel, think, have a personal perspective on religious, all that is one thing. And what is the professional standard is a separate thing. And you suggested that the professional standard that would exist would have no effect here. And I'm suggesting to you that the plain language of this bill suggests the opposite. So I'm trying to get clarity on how you got to the professional standard having no meaning here.
Well, again, I do not mean to conflate the two. We have seen often too many times where perhaps, for example, if gender transition procedures are legal in Connecticut, this would be in violation to someone who does not believe that this is the standard of care as a healthcare professional. That being said, we're saying that this healthcare professional who is of ethical mind, honoring the medical and scientific evidence that shows that those who undergo these treatments have even more higher rates of suicide ideation. They have higher rates of regret from their procedures. This would not be the professional standard of care in with regard to what the medical, the science, even those who are doing studies in the UK are showing us that this is not the professional standard of care. What I'm saying is that science and medical evidence based, and also in addition to their conscience, their values, their training, their expertise should be language included in this bill that even if this was made legal in Connecticut, that we need to see stronger language stipulated that this healthcare professional, Connecticut healthcare professionals would have the opportunity to be able to not be compelled to perform a particular procedure or treatment that would violate their conscience.
Thank you. Representative O'Day.
Thank you very much,
you.
Mr. Chair. Thank
Thank
you
you.
very much for your testimony. I was looking for it online. Did you submit any online testimony?
No, but I certainly can. I just knew I was giving it virtually, but I can certainly email you my testimony as well.
If you could please do that, I really would appreciate it. It would help us
Yes.
Immensely. Thank you very much. Thank you. Thank you, Mr.
You're
Chair.
welcome. You're welcome.
Thank you, Representative. Comment, question from members of the committee. Comment or question from members of the committee. Seeing none, thank you very much for joining us today.
Thank you. Thank you.
Mayor Justin Elicker.
Good morning, everyone. Good to see you all. Senators Winfield and Representative Staffstrom, the co-chairs, and all the members of the Judiciary Committee. Thanks for all your work. And I've certainly learned a lot about antitrust this morning. I'm testifying today, Justin Elicker, the mayor of the city of New Haven. I'm testifying today in strong support of SB 1284, an act concerning the illegal use of certain vehicles and street takeovers, and to express the need for a strong statewide commitment, a continued commitment to provide municipalities and communities across Connecticut with more tools to combat this persistent, growing and share challenge. I want to start by thanking you all for the past 4 years or so. You've consistently given us more tools to address illegal ATV, dirt bike racing, and now we're working on street takeovers. And the tools you've given us have been hugely helpful to us making progress on this issue. As you know, street takeovers and dirt bike riding and ATV riding on our streets is extremely dangerous, posing a risk not to the general public, but the participants themselves and our law enforcement. And we've seen many, many injuries, including people die across the state and in our city. And other dangerous activity associated with street takeovers, such as, when we do catch people, we oftentimes find firearms as well. We've done what we can and a lot in New Haven to combat street takeovers, illegal ATV and dirt bike riding, local ordinances that have increased the fines that you've allowed us to do through state statute, finding gas stations, a joint regional task force to coordinate and improve enforcement, deploying a lot of technology, including drones, stop sticks, and other methods. And we're making progress, but they still are a very, very difficult challenge because, as you know, state statute doesn't allow us to engage in high-speed chases. And so we have to use a lot of creative approaches. The bill SB 1284 gives us some additional tools. So first of all, They allow for consequences for those involved in street takeovers, including fines, the ability to impound municipalities to impound a vehicle until those fines are paid, and license suspension. And I'm happy to talk to you about the details of any of those, but they would be very, very helpful to us having some more consequences for people that are deliberately involved in this illegal activity. The second thing that it does is helps tighten up some of the dirt bike and ATV regulations. So currently, municipalities that impound a dirt bike or ATV are required to auction them off. The legislation broadens that to allow us to both auction them or destroy them. As you can imagine, we don't want to auction them because we think they'll just cycle back into the community. We'd like to destroy them. And we have a lot in storage and the numbers keep building. And then the second thing is currently the statute does not allow us to impound a vehicle, ATV or dirt bike, if it has a lien on it. And so the proposed change allows us to give the lien holder notice. And if the lien holder does not get back to us, we can then take and destroy that vehicle. I would respectfully request one potential change to the to SB 1284, and that's to expand the consequences. Currently, the proposal says that people's license could be suspended if they're involved in street takeover or street racing. That
One second. I'm just going to, just to be fair to everyone else, because I do want to hear the exception. I'm just going to formally ask you to explain that exception so that you're not just going past your time because you feel like it.
Sure. Which exception are you talking about, Senator?
The one you're in the middle of explaining, the exception in the bill that you need.
Oh, yeah. Yeah. So the current language proposed says that street takeovers, that you could have a consequence of a license suspension. ATVs and dirt bike riders, should they have a license, which many of them do, because frankly, many of them are adults, don't have that consequence right now. And so I'd respectfully request that we add that consequence if people are caught riding illegally ATVs and dirt bikes, so that they could potentially have their license suspended as well.
Okay, thank you for that. Are there comments or questions from members of the committee? Comments or questions? I don't see any. It's probably because we've heard this bill many times, and I think many of us would actually like to finish it this time. The part of what isn't in the bill, is that in your testimony?
I don't think you've received written testimony yet, but we're happy to share those details.
Okay, great. Thank you for joining us. We know you have a very busy schedule.
You as well. Thank you so much. Take care.
All right, Jared Ross.
Hello. Are you guys able to hear me all right?
We hear you well. You may proceed.
Thank you, Chair and members of the committee. Thank you for this opportunity to speak. My name is Dr. Jared Ross. I'm a board-certified physician and a senior fellow at Do No Harm Action, an organization that works to prevent discrimination in the provision and delivery of healthcare, as well as to protect children from harmful medical interventions. I'm providing testimony today in opposition to SB 1380. While I applaud the intent of SB 1380 to prohibit discrimination by healthcare providers, I'm concerned that the bill could be misused to compel doctors to provide dangerous medications or procedures to children suffering from gender dysphoria. We know that most, if not all, children dealing with gender distress have underlying health and mental health challenges. This includes depression, anxiety, eating disorder, autism spectrum disorder, or a history of physical or sexual abuse. While these children most certainly need compassionate talk therapy and possibly psychiatric medical care to address these challenges, we must protect them from the horrors of so-called gender-affirming care. Let's be clear, there is no strong evidence to support the use of medical interventions such as puberty blockers, cross-sex hormones, or surgical procedures to treat gender-distressed children. The more light we shed on this topic, the more we expose the lack of evidence supporting these procedures and the less defensible they become. The Cass Review, an exhaustive study of gender services for minors in the United Kingdom, found that the evidence supporting these treatments was very weak. Additional systematic reviews conducted by the health authorities in Finland, Sweden, and the state of Florida have come to the same conclusion. Moreover, several of the most often cited studies used to support the gender affirmation approach are rife with methodological flaws. In response to this paucity of evidence, multiple countries in Europe and South America have restricted minors' access to gender medical interventions. And while many claim that puberty blockers are reversible, the use of puberty blockers have been shown to cause decreased bone density and lasting effects on brain development, impairing learning, spatial memory, social behavior, and emotional processing. These irreversible procedures do nothing to address the underlying issues that these vulnerable children are facing. And several large studies in adults, including one released earlier this week, show worsening mental health outcomes after these procedures. We must ensure that children suffering from disabilities are not used as a pawn to promote an ideologic.
Thanks, sir. Your time has elapsed. Let's see if there are questions for you. Comment or question from members of the committee. Repo Day.
Thank you very much, Mr. Chair. Thank you, Doctor, for your testimony. I was looking for it online. Did you submit any online?
Representative, I didn't submit it online, but I am more than happy to do that.
Please, I beg of you to please submit it online. It sounded like you're almost finishing up. What were you staying there towards the end? I missed it.
Thank you, Representative. I was saying that we must ensure that these children who are suffering from disabilities are not used as pawns to promote an ideological anti-scientific agenda under the guise of preventing discrimination.
Sorry, what was the study that you made reference to, the most recent study? I think you said there was a recent study and I didn't hear it. If you said it, I apologize.
There was a recent study published earlier this week, and I will be happy to submit that along with my written testimony. I also cited the Cass review, an exhaustive study that was performed by Dr. Hilary Cass in the United Kingdom. It's an over 400-page study that summarized multiple studies that have been done across the world.
Thank you. I appreciate that. I definitely want to look at the studies. I have the same concerns that you do, but I'm not a doctor. So whatever studies you can provide us with, I promise you I will read. Thank you very much. Thank you, Mr. Chair.
Thank you. Comment or question from other members of the committee? Comment or question from other members of the committee? Seeing none, thank you very much for joining us. Simon Amaya Price.
That's me.
You may proceed.
Thank you. Good afternoon. Thank you for allowing me to testify virtually against SB 1380. I have also submitted written testimony. My name is Simon Amaya Price. Today, I sit in front of you as a 20-year-old man, but for 3 years, I thought I was a girl. I received my bachelor's degree in music from Berkeley last December with additional coursework at Harvard University in statistics. I remember being 14. I was sitting in my pediatrician's office, explaining to him that I was transgender and that my father wasn't affirming my new identity. So my pediatrician asked my father, and I was in the room, would you like a dead son or a living daughter? There is no other situation when a doctor is allowed to suggest suicide like this to a patient. Quite frankly, it's medical malpractice. If you ask parents of trans-identified kids and other detransitioners, you'll soon discover that this is a common lie used to manipulate parents into consenting to these procedures. Despite being referred to my local gender clinic 3 times by 3 separate doctors, the emotional blackmail and my gender dysphoria diagnosis, my father refused to take me to be medicalized, and I hated him for it at the time. But today, I am beyond grateful. And it's not just me. 3% of my generation identifies as transgender. Between the time I left after 10th grade and the time my class graduated, 1/6 of the boys in my class started identifying as trans, many of whom medicalized. My girlfriend is a detransitioner, and I can't do much more than pray that if and when we decide to have kids, that despite the double mastectomy, which precludes her from ever breastfeeding, and the 4 years of cross-sex hormones she was giving, starting from when she was a minor, that she is able to carry a pregnancy to term. The other side believes that if you don't give trans-identified kids puberty blockers, cross-sex hormones, and surgeries, that they will kill themselves. That is a damned lie, and I am living proof of that fact. I was not put on hormones, I was not operated on, and I have grown up to be a healthy and happy 20-year-old man. I have also talked to parents with detransitioner children who killed themselves after realizing they regretted what they had done to their bodies. What would you say to those parents? The other side of this issue has both psychological and economic incentives to support this bill. Imagine, if you will, having administered cross-sex hormones or puberty blockers, or referred children to have such procedures. What would you do if you were presented with evidence that what you were doing was not helping, but permanently harming your patients? I know I would have a very hard time accepting that. Transgender healthcare is a $4.4 billion industry. Though estimates vary, the lifetime cost of providing a trans-identified individual with hormones and surgeries exceeds $100,000 on average. What would you do if you were a hospital administrator or a doctor who made $1 million for your clinic for every 10 of these patients you treated? If you are serious about protecting families and the health of children, you must vote against this bill. Thank you very much. Happy to answer any and all questions.
Thank you. Representative O'Dea.
Thank you very much, Mr. Chair. And Simon, thank you so much for your testimony and your bravery to come before us with your own experiences. I tried to find your testimony, and I admittedly technology challenged, but if you did submit it, or if somebody knows where it is, if they could help me find it, I would appreciate it. If you,
it should be near the top under my first last name, which is Maya with an A.
Okay, I was looking under price. Thank you. Sorry.
Yeah.
And you had said that the cost, I know that there's some, I missed the numbers that you said during your testimony, the cost that, of the care that they were trying to have you go through. What was that?
Over a lifetime, it averages about $100,000.
Okay.
And that's a combination of surgeries and hormones.
Well, thank you so much for your bravery and your testimony here today, sir.
Of course.
Thank you, Representative O'Dea. Representative Veach.
Good morning, and thank you, Mr. Chair. Simon, I have to thank you for coming out and speaking. Am I to assume that you're here today to testify to people that are in the same situation that you were in? I mean, why are you here? Are you here to do just that?
I am here because I survived what I believe to be the worst example of medical malpractice we have seen since World War II. I survived, and now I'm here to end it. The same hormones we're giving young boys, like the ones they wanted to give me, were the same hormones they gave Alan Turing in Britain once they found out he was homosexual, to cure him of his homosexuality. That's why I'm here.
Well, I commend you for coming out and sharing your experience with us. And I'm truly happy that your father did not comply. Thank you. Thank you for your time. Thank you, Mr. Chair.
Thank you, and thank you for your testimony today. Oh, wait, sorry. We have one more question. You may proceed.
Thank you, Mr. Chair. Thank you, Simon, for your testimony. Can you just talk a little bit about the confusion, from your experience, when that started, and I am thankful for your father for him taking that stand. But can you just elaborate a little bit on that?
Absolutely. That's a good question. I was 14 when it really started. I had just moved to a new school. I had just lost a bunch of weight. In middle school, I was the target of near daily homophobic bullying, and I came out as bisexual in 8th grade. That was a very hard thing to deal with. I didn't know how to talk about it. I didn't know how to understand it. I didn't know it at the time, but I'm autistic, and that, of course, led to a number of social difficulties, not the least of which was my friend group leaving me in 9th grade, which is very traumatic when you're a young kid and that feels like your whole life. You really do feel like you're dying, because in the evolutionary context, that would lead to you being eaten by like a tiger or something like that. I was also sexually assaulted on a school trip by an older boy the fall of 9th grade, which led me to seek help. I was introduced to the gender unicorn in my health class, which presents gender identity, gender expression, sex, romantic attraction, sexual attraction on separate spectra. And our teacher asked us to place ourselves on each one of these spectra. Additionally, I joined the Gay Straight Alliance at my school, in which we regularly watched YouTube videos by the YouTuber ContraPoints, who is a transgender male to female transitioner. And this is how I learned about gender dysphoria and a very clear series of steps that I could take to remediate the pain I was feeling.
Okay, thank you very much for that. And we appreciate you coming in today. Thank you very much. Thank you, Mr. Giroux.
Thank you, Representative. Comment or question from other members of the committee? Comment or question? If not, I just want to say that I recognize that in many ways we can find ourselves in a bill, but there was a comment about what folks are trying to do here. So let me make sure that we are clear about what is being attempted here. I did not put this bill in this year, but I did put the bill in I believe the first time that we did it. And it was a conversation about folks trying to get the medical treatment that they should get, and not being able to get that because people had certain beliefs about who they were. For instance, we know that folks who look like me are sometimes believed to have superpowers, if you will, and not feel a certain level of pain. And so while folks can find themselves in a lot of things, we should be careful about impugning the motives of folks and assuming that what we believe because of our own individual experience is the motivation behind the bill. With that, I am very thankful, though, that folks are here to have a full conversation on this bill. So
Could I
thank you very
respond?
much. Sorry?
Could I respond?
I'm not asking a question. I'm clarifying for everyone what we are doing here. So with that, thank you very much for joining us here today. Leslie Wolfgang. I just want to say, because we have about a minute, good morning.
Good morning. I'm testifying in opposition to raised bill 1380 because it could lead to fewer doctors choosing to practice medicine in Connecticut. I have outlined in my written testimony what sections of this bill would require doctors to provide gender-affirming care. Gender-affirming care includes double mastectomies, puberty blockers, and cross-sex hormones for minors. Many doctors don't want to provide these services because it violates their training, their deeply held beliefs, or their conscience. Many more consider gender-affirming care to be inconsistent with their promise to do no harm. These doctors may choose a different occupation or leave the profession rather than face the litany of CHRO persecutions under this bill. This bill would invite a complaint against a physician who is capable of providing double mastectomies, but refuses to provide one to treat a gender dysphoric girl. Another complaint could be brought against an endocrinologist who prescribes puberty blockers temporarily for severe precocious puberty, but refuses to prescribe puberty blockers to a child with developmental anxiety. A physician will have to deal with a CHRO complaint and subsequent investigation, hearings, appeals to Superior Court, Attorney General investigations, and also injunctions, punitive damage, civil penalties in Superior Court, and independent civil causes of action. Some doctors could easily choose to leave the profession instead and exacerbate our physician shortage. Lines 13 and 14 do not require a doctor to violate any professional standard of care, but the bill still invites complaints. Also, what doctor can get a fair hearing when Commissioner Hughes has expressed animus against the sex binary and promises to bring the full weight of enforcement powers against those who do not buy into transgender ideology? No proposed hearing in CHRO on this matter should be considered fair. You might hear the claim that these procedures are not happening or are rare, but double mastectomies, puberty blockers, and cross-sex hormones are being prescribed to minors in Connecticut. to treat gender dysphoria. They are difficult to document, but there have been 96 kids under age 17 and a half who have had these procedures done. The state has paid for the breasts of minor girls as young as 15 to be removed to treat gender dysphoria. Children have started puberty blockers and cross-sex hormones in Connecticut, exposing them to permanent infertility. Physicians have been told they must provide this care or else the child will commit suicide, but that's
Wolf, yeah.
also not supported. Thank you.
Thank you. Comment or question from members of the committee? Comment or questions from members of the committee? Seeing none, thank you very much for being here again.
Thank you.
Patricia King.
Good afternoon. We now, I guess, progress to the afternoon to Senator Winfield and Representative Sastrom and committee members. My name is Patricia King. I'm the Corporation Counsel for the City of New Haven. I'm here to echo and support the comments of our mayor, Justin Elicker, who you heard a short time ago, regarding Senate Bill 1284 that would provide the city with additional tools in its efforts to enforce or enact and enforce ordinances regarding the use of dirt bikes and street takeovers in our city. We're grateful for the tools that we have, as the mayor indicated, and we, having had those tools with regard to dirt bikes and ATVs, we have a request to change the enabling legislation, and we're also asking for the proposed enabling legislation that would allow us to regulate street takeovers as well. I don't want to go into this in great detail, as you have already heard the mayor, but we are asking for the ability to destroy the ATVs and dirt bikes that are seized, because, as the mayor indicated, putting them up for public auction would most likely result in their being just put back on the streets again, with the possibility that the activity would just be reenacted and continued with the dirt bikes that have been seized once and been able to be repurchased. So we are asking for the ability to destroy those. One alternative would be to use the language similar to what we have in our in rem statute, which is General Statute 54-33G, subsection C, which would allow title to simply pass to the municipality, in which case we could then destroy them, or we have the possibility that they might be used, some of them, in law enforcement activities. As an example, our fire chief has inquired as to whether the fire department could use some of these ATVs in some of its search and rescue efforts in places like parks, East Rock Park, for example, where using motor vehicles or SUVs may not be practical, but an ATV might be more useful. So that language already exists, as I said, in our in rem statute, and may be something to consider, and I'd be happy to submit some proposed language if the committee would like. We also are looking, as the mayor indicated, for the ability to enforce street takeovers as well, and for the state to impose a penalty of license suspension for the offenders, which would be, I think, effective, and would also affect some of our out-of-state offenders here who may not feel the effects immediately if they don't come to court in New Haven, but in any event, their right to operate their license or right to operate a motor vehicle in their home state would also be suspended if it were suspended here in Connecticut.
Okay. You may not have heard, but the bell did ring. So let me check to see if there are questions for you. Comment or question from members of the committee? Comment or question? There are none. I will tell you that over a decade ago, I proposed the destruction of those bikes and was excoriated for it. But it seems like, given what has happened in the state, we may be coming around to a point of view that suggests that might be something to consider. Thank you very much for joining us today, and thank you for the work that you do.
Thank you very much.
Marcy Strange. Marcy Strange. Okay. Beth Bourne. Beth Bourne. Lauren Schwartz. Lauren Schwartz. Jiadi Chang. Turn the microphone on. Hit the button in front of you. Yep.
Sorry. Co-chairs Winfield and Staffstrom, ranking members Kissel and Fishbein, and distinguished members of the Judiciary Committee. My name is Jadi Chang, and I am the Government Affairs Associate at the Center for Policing Equity, a research and action organization that uses science to identify and reduce the causes of racial disparities in public safety. CPE has worked with several law enforcement agencies in Connecticut, including the Newington, Watertown, and Clinton Police Departments. Connecticut, like many other states, is facing crises of traffic fatalities, racial disparities in traffic enforcement, and limited law enforcement resources. HB 7132 is a focused and evidence-based approach to help address all of these challenges. This bill, based on recommendations by the Police Transparency and Accountability Task Force, will help police prioritize road safety by allowing officers to focus on the infractions that are the main causes of crashes. In doing so, police would maximize limited resources without subjecting drivers to the serious risks inherent to all traffic stops. Based on prior feedback, the bill has been pared down to 4 categories of infractions, such as lighting infractions that do not impact road safety, having minor objects hanging from your rearview mirror, and extending the grace period for expired registration from 30 to 60 days. The solutions proposed by this bill have already seen success in Connecticut's towns and cities, thanks to forward-thinking law enforcement leadership, such as in New Haven, Hamden, and Newington. HB 7132 would improve public safety while also reducing racial disparities in policing. Anyone who drives breaks traffic laws, but in Connecticut, Black drivers are 1.2 times and Latinx drivers are 1.3 times more likely to be stopped for an administrative offense than white drivers. Those disparities are even higher for equipment stops. Jurisdictions that adopted policies ending or deprioritizing non-safety stops, such as Philadelphia, Fayetteville, North Carolina, and Ramsey County, Minnesota, saw reductions in racial disparities and traffic crashes and fatalities, along with improvements in crime rates and contraband recovery. The persistence of racial disparities in traffic stops, the rise of traffic fatalities, and the ongoing shortage of enforcement resources demand the common sense, evidence-backed change that HB 7132 sets forth. I urge you to vote favorably. Thank you.
Thank you. Comment or question from members of the committee? Comment or question from members of the committee? Thank you very much for joining us. Steve Ward.
Hello, thank you for having me. My name is Dr. Steve Ward. I'm a board certified internal medicine physician. I live in Cheshire, been practicing for about 16 years or so. I oppose SB 1380, and there's already been testimony earlier about the medical harms of gender affirming care, and I agree with that. Senator Winfield had an excellent question a little bit earlier about the professional standard of care. So I wanted to spend my time helping clarify that a little bit. So here's an example. Let's say a patient slips on the ice, has an ankle fracture, comes in to be seen, and then there's a association that has an alleged standard of care saying that I'm required to amputate the leg. Well, I would disagree with those standards of care and say, well, we should just put a cast on or do something different, because the true or real or better, more evidence-based standard of care is to do that. Well, the same thing is true in the gender space. The real issue is that there's a disagreement about what the standard of care really is. WPATH, World Professional Association of Transgender Health, put out what they call standards of care. I have personally read through a lot of the literature that is being put forth by activists as the so-called standard of care, and I can tell you it's pseudoscience, and we know that. So for me as a physician, I simply disagree with what some of these organizations are calling the standard of care, and I want to be able to follow best evidence as I see it, as well as practice according to my conscience. So I hope that helps. My best advice is to put a carve out, so to speak, where there is conscience protection and to exclude gender affirming care. And I'm happy to take any questions, and I'll submit my testimony later today.
Thank you for that. Representative Howard.
Thank you, Doctor. So I didn't want to keep on Ms. Hayes earlier, but I want to ask you this. When I used to teach EMTs, we would teach standard of care, and in that context, I would teach them standard of care is if I took 100 EMTs with the same level of training and experience and put them in a room, would 95 or more of them do the same thing? Is that an elementary understanding of professional standard of care in the medical field?
Yes, I would say so.
All right. So are you telling me then that your colleagues in the medical field are divided on whether or not gender affirming care meets the standard of care, or however you want to word that?
Yes, absolutely. That is correct. I would say the majority of physicians do not support puberty blockers, hormones, and surgery for children. I think it's a minority, very loud view that is pushing this ideology.
All right. So what does gender affirming care mean? That's the other question that I have, because
right.
Some folks tell me that gender affirming care refers to, sort of speech therapy, changing of haircuts, etc. Others say gender affirming care has to do with surgery. So when we use gender affirming care, when you say gender affirming care, or your colleagues do, what does that entail? What does that mean?
Right. So the term is very broadly used, which is part of the problem. So even the language itself is problematic. So the claim in the language is that we need to perform some kind of treatment, whatever that is, voice or surgery or anything in between, in order to affirm or somehow approve or usher somebody through a process of transition. The discussion is really about whether or not that is appropriate and whether or not that is even possible, and it isn't appropriate or possible. But it is an umbrella term that I think is misused, and that's why sometimes we say so-called gender affirming care, because we really don't affirm gender. Your gender is whatever it is at conception. It's not open for changing, if that helps a little bit.
It does. So if I were to say, and these probably aren't the best terms, and I'm probably going to get criticized for what I'm about to say, but if I were to say to you that but I need to understand these things. These are complicated and sensitive issues. If I were to say to you that gender affirming care is a spectrum, right? So that, where on one end of the spectrum may be, complete surgery, and the opposite end of the spectrum may be changing your clothes, for example, or the types of clothes you wear that we generally assume to one gender. Would that be fair to say that the gender affirming care sort of falls on like a spectrum like that?
Yes.
All right. So is there anywhere on that spectrum that you think is appropriate for doctors to be involved in the context of this? So I would say, based on your testimony, that if you interpret this bill, and the Senator and Ms. Hayes went through this earlier, and I sort of touched on it as well, and I'm still working through it, but if you were to understand this bill, that it would require you as a doctor to surgically change my anatomy, you would be opposed to that, correct?
Correct.
All right. So if this bill were to say, okay, you as a doctor, if I come in and I say I was born a male, I have male parts, but I think I might be a female, but it requires you to give me some sort of health care to address that, are you in favor of that?
For children, only if it was mental health support, because to affirm a child through surgery or prescriptions or social transition and voice therapy and other things pushes them down a road that is harmful to them over time. So for children, I would not really support any, quote, gender affirming care other than mental health care.
And my last question for you is around puberty blockers, and please understand, I don't have much. I mean, like I said, I have an EMS background, which is limited at best. But I hear things and I need to understand from professionals. So can you talk to just briefly what puberty blockers do in the development of children? Are those effects reversible? And I hear some things about infertility. There's been in different committees on different things around this transgender issue where folks have testified and said that they took puberty blockers or did other things and they were irreversible. Other people tell me these things are reversible. So can you just speak to that as far as the puberty blockers, what they do, and if they're reversible?
Sure. Yeah, puberty blockers are not reversible, and the reason is that puberty occurs in a fixed window of time. So, for example, bone development, brain development occurs only in that narrow window of the years of puberty. So, to take a puberty blocker during that time period will permanently block the hormone activity in the brain that the individual needs for brain development, proper organ and bone development, and so forth. Once that window of opportunity closes, when the patient is older in their 20s, 30s, and beyond, you can't go back and undergo puberty later by giving them some other type of hormone supplement or anything else. The damage there is done. Again, because there's only a narrow window of time where your body can undergo that type of development. So to block hormone activity during that time has permanent effects.
Okay. Thank you very much. I appreciate being here, and I appreciate you loaning your knowledge and experience to us for this bill. Thank you. Thank you, Mr. Chairman.
Thank you. And I just want clarity on what I just heard. So, and the only reason I don't always ask these questions of everyone, but you are a medical professional. So are you saying that someone who experiences precocious puberty, for instance, should not have puberty blockers?
No, precocious puberty is a different category altogether. That's a specific disease state where a young child undergoes puberty at an abnormally young age, abnormally aggressively. Puberty blockers are FDA approved for that particular purpose. It is not approved for gender affirming care. So there's a big difference there. So gender dysphoria, kids who have gender dysphoria do not have precocious puberty. So we're using these drugs off-label experimentally for a different purpose. We're giving them harmful complications.
And I just want to be clear, at least on, because it's, and I want us to be having the same conversation. It sounded like you were saying, and I know that Representative Howard didn't bring up precocious puberty, but it sounded like you were saying that it's just true that those puberty blockers are problematic. So I wanted to say that. And you stated that your gender is what it is at birth. And I'm going to assume that you are talking about someone's sex when we all use these words both ways, but you're talking about someone's sex?
Correct. Yes, sex is determined at time of conception. Every cell in the body is either male or female genetically from the moment of conception.
And I don't really want to have this conversation, but we are.
It's okay.
What do you mean by that? What determines that someone is a man or a woman biologically?
Right. Biologically speaking, genetically speaking, we are all either male or female. There are genetic abnormalities where a child is born having ambiguous genitalia or variations of how their sex is expressed, but that's because of cellular dysfunction and abnormalities but it is still either based on being male or female. Those are not new genders. So I disagree with the concept that we assign sex at birth. Sex is determined at conception. When a child is born, we then discover what the sex already is. We don't just make some whimsical decision and declare the child male female or something else at that time. So that's kind of what I'm getting at. The language can be tricky and a little bit misleading when we say assign. We really never assign a child their sex or their gender.
And that is the reason why I'm exploring this, though I don't
Right.
really want to be having this conversation.
Right.
And when you are talking about one's sex, you're talking about what we generally refer to as um, the 46 chromosome XX or
Right.
X.
Right.
And as a medical professional, maybe you can help me to understand the variations of a
Yep.
45X0 or 47.
Yeah. Yeah, that's
XX.
Turner syndrome. So yes, sir. So there are genetic abnormalities, a variety, and those are called disorders of sex development, or DSDs. You might hear them called. So there can be differences in the genes themselves, where some of the genes are defective, and that can cause differences in how our body handles testosterone and estrogen, or how our bodies produce testosterone or estrogen. So there can be differences in how our bodies develop as a consequence of that, but still, genetically speaking, we are either male or female, but part of our male genes or part of our female genes might be defective and not functioning properly, but those are not different new sexes or different new genders. It's a disease state. Um, is that helpful, hopefully?
Well, I'm not sure it helps me all that much to talk about them as diseases. I think differences are in everything that we do,
Yeah.
particularly when it comes to human beings. We have panoply of ways that we show up.
Right.
There's a different way in which chromosomally we show up, given the conversation you and I just had. And if you were talking about those who are intersex who might have oval testes,
Right.
whole
Right.
conversation we could go into.
Right.
I don't want a medical expert to engage in this conversation and help us to feel as though this is a very simple conversation, because it's
Right.
not.
Right.
So
I agree with that. And I agree with the intent that you explained earlier. We don't want discrimination against anybody. Everybody should be treated with compassion. I'm 1,000% on board with that. But if I disagree with an activist organization's standard of care as they see it, and I believe the best interest of the patient is to follow the better evidence, what I consider to be the true standard of care, I want the freedom to do that without potential penalty. And it's coming from a good place because I want what's best for the patient. So I think we're all on the same team, but I think the bill keeps the door open a little bit to accusations against docs like myself, because there's a dispute in the culture about what the standard of care really is.
okay, Rep. Callahan.
Thank you, Mr. Chair, and I apologize for not being there in person. But Doctor, a couple questions to help me clarify. I've listened to this
Sure.
interesting discussion. At what age would you consider a person to be able to make decisions on their own, brain fully developed?
26 or older. Between 26, 28 or so is when the brain would be fully developed. That tends to be the consensus.
Thank you for clearing that up. And then also, you say activist groups. Have you personally or colleagues you work with, are you pressured via social media, emails to change your opinion on this?
Yes. So I've sat through formal training by endocrinologists and other specialists who promote gender affirming care. And that's what really started me on this journey of learning, based on a lot of the journals and studies that were given to me as evidence that we should be doing gender affirming care. I pulled them myself and read them, and I was really shocked to see how poor quality they really were. And that's really why I wanted to try to speak out, to try to help educate all of us that it's not a simple issue, and what you hear that is good evidence about suicide rates and everything else is just not true.
Well, your testimony has been very valuable to myself and hopefully to my colleagues. And my last question, Mr. Chair, and it's a quick one, is does this bill as written put you in a legal catch-22, do you believe?
Yes. I think if a patient came in to see me and asked to be prescribed hormones or puberty blockers, if I said no, that I didn't feel that was the appropriate treatment for their problem, I feel like I could be accused of discrimination when in fact I am trying to treat them compassionately and properly out of my care and concern for them. But I'm going to face potential ramifications because of this standard of care that is really not standard of care.
Well, I appreciate it. I'm sure it's hard enough to practice already with malpractice suits and other things that worry you on day-to-day basis. So I do appreciate you coming in and helping us make better decisions on legislation today. Thank you.
Thank you, Representative. Comment or question from other members of the committee? Comment or question? Seeing none. Thank you for joining us. Zachary Elliott will be next.
Hi, thank you. My name is Zachary Elliott, and I represent the Paradox Institute, an organization that educates the public on the biology of male and female. I strongly oppose SB 1380 unless it is amended to protect doctors from being forced to perform gender-affirming procedures against their professional judgment. I support equal treatment under the law and oppose discrimination. But this bill, as written, would compel doctors to administer interventions that cause objective harm. It must be clarified to ensure that no doctor is required to perform gender-affirming care. The bill already exempts doctors from providing futile healthcare, treatments with no measurable benefit. Gender-affirming care fits this definition. It uses puberty blockers, cross-sex hormones, and sometimes surgery to permanently alter the healthy, sex-specific physiological and neurological development of an adolescent or adult. This prevents the patient from developing or maintaining healthy anatomy and physiology, often resulting in permanent sterilization, impaired or permanent loss of sexual function, cognitive deficits, osteoporosis, cardiovascular disease, type 2 diabetes, strokes, and other serious medical conditions. And these procedures also harm mental health. A recent study of over 100,000 patients showed an increase in anxiety and depression from gender-affirming care procedures. And why wouldn't there be? Gender-affirming care permanently damages people's bodies to try and treat an issue that resides in the mind. This is futile healthcare. Our sex is fixed in the womb, determined by our genes, and cannot be changed. Unlike some species, humans are not sequential hermaphrodites. Attempts to alter one's sex lead only to irreversible harm. Doctors must have the legal right to refuse procedures they know will compromise a patient's long-term health. Doctors can refuse many other types of procedures that a patient believes they need. This is no different. Refusing to do these harmful procedures is not discrimination, it is ethical medicine. I urge the committee to amend SB 1380 to ensure that no doctor is forced to violate their moral obligation to do no harm. Thank you.
Thank you. Comment or question from members of the committee? Comment or question? Seeing none. Thank you very much for joining us today.
Thank you.
Catherine Valeda. Catherine Valeda. Okay. Chris Gallman. Gallman.
Goldman, thank you so much.
All right.
Co-chairs Winfield Strastrom, ranking members Kiesel and Fishbond, and distinguished members of the Judiciary Committee. I want to begin by thanking you for allowing me the space to provide my testimony regarding House Bill 7132. My name again is Christopher Goldman, and I'm a former law enforcement officer from South Carolina with over 15 years of experience in various agencies and roles. Currently, I serve as a senior implementation strategist at the Center for Policing Equity, a research and action organization that leverages science to identify and reduce racial disparities in public safety. Reducing the low-level traffic stops not only ensures that law enforcement resources are used effectively, but also mitigates the inherent risks associated with these encounters. Every officer, including myself, who has conducted a traffic stop understands the potential for volatility, regardless of its initial purpose, and it carries the risk of escalation. We also know that Black and Latino drivers are more likely to have use of force used against them at non-safety stops than during safety stops. This bill, which aligns with recommendations of the Public Transparency and Accountability Task Force, will allow officers to focus on infractions that directly contribute to crashes and traffic fatalities, enhancing road safety while optimizing police efficiency. Furthermore, these stops disproportionately impact vulnerable communities, often leading to fines, court fees, and vehicle impoundments that create financial hardships, and in some cases, escalate into more serious law enforcement interactions. Jurisdictions across the county, across the country, including Virginia, Philadelphia, Pittsburgh, and San Francisco, have enacted similar measures and have reported positive outcomes, including reductions in crime, decrease in traffic crashes and fatalities, and increase in contraband recovery. House Bill 7132 presents an opportunity for Connecticut to take a similarly data-informed approach, improving both public safety and the efficiency of law enforcement. Thank you.
Thank you. Comment or question from members of the committee. Representative Howard.
Thank you, Mr. Chairman. Thank you, sir. Where are you testifying from?
I'm currently in Columbia, South Carolina.
South Carolina. Thank you. Thank you for your service as a police officer. I certainly respect and appreciate it. Did I hear you say that the vehicles have been impounded as a result of some of the stops that are outlined in this bill?
Well, stops in general can lead to impoundment. Traffic stops, depending on the nature of the violation or the nature of the stop, yeah, it could lead to impoundment. Yes, sir.
Understood. But you're not, so just to be clear, the sort of things that lead to impoundment, DWI, driving under suspension, driving with no insurance, et cetera, you're not advocating that police stop doing that, right?
No, sir, not at all. Not at all.
So what you're basically saying is if these stops that are outlined in this bill lead to impoundment, then that means that these stops are identifying people who are driving suspended license, driving intoxicated, driving suspended licenses, no insurance, et cetera, right?
Yes, sir.
Well, isn't it important to get those people off the road?
Yes, sir. Obviously, anybody who's committing, any violation that causes public safety hazards, it's important to get off the road. My point was simply that non-safety stops that stem from usually non-moving violations typically provide inherent risk to officers, and that we've seen across the nation don't provide the type of outcomes. Like I said, in Virginia, Philly, Pittsburgh, and San Francisco, we've all seen reductions in crime, decreases in traffic crashes and fatalities, and increases in the contraband recovery, even after they even acted bills similar to House Bill 7132.
Are you aware of any police officers in Connecticut that have come to any elected official or anybody else and said, I'd really like to get around to the drunk driving and under suspension and stuff, but I just so tied up with the out plate lights, I just don't have time. Has any police officer ever said that to you?
No, sir, not to me personally.
And do you think it's important with your experience that vehicles have two headlights?
Yes, sir, I do.
All right, so have you read this bill that you're testifying on?
I have.
You have. So
Yes.
so this is making it, you would agree with me that what this bill does, it's not telling police officers, hey, don't stop somebody for an out headlight, but if you stop them for speeding, you could, write them an infraction for one of their out headlights if you want, but you just can't stop them. That's not what the bill does, right?
I'm sorry, repeat the question. You said,
In other words, are we in agreement that this bill changes the law and says that you're only required to have one headlight? You agree, right?
that you're only required to have one headlight?
Right.
I think my interpretation of the bill is that it will eliminate stops for non-safety and non-moving violations, and reduce the amount of footprint that law enforcement has on these type of violations. That's my interpretation of the bill.
Well, let's work through how you got there then, because you have a lot of experience. You come with a pedigree. So line 119 of the bill, under current law, it says at all times specified in subsection A of 1496A, at least two lighted lamps shall be displayed, one on each side of the front of every vehicle other than a motorcycle. That language is taken out in this bill. And now it says at all times, each motor vehicle shall have at least one functioning headlight located at the front of such vehicle. So how would a police officer like yourself interpret that to mean you still are required to have two, but you can only be stopped for one?
Yeah, I think it takes away, it gives more options to police officers in an instance where they see a motorist with one option, one headlight, and allows the motorist opportunity to get that headlight fixed without without the officer feeling, hamstrung to pull them over for not having two headlights. Obviously, I'm not in opposition of taking discretion of law enforcement away, having worked in the profession, but I do feel like lower level traffic stops, such as, what you're mentioning, can sometimes be remedied in other ways.
I appreciate that.
Yes, sir.
But my interpretation is not what this bill does.
Sure.
You have represented that it's your interpretation that these words, at all times specified in subsection A of 1496, each motor vehicle shall have at least one functioning headlight. I interpret that to mean that one functioning headlight would make you in compliance with the law. But you're telling me that you interpret that to mean you still have to have two, but can only be stopped, but can't be stopped if you only have one. That's what you're interpreting?
Yes, sir. That's my interpretation of the way it's written.
Well, I just, I don't understand how, I guess I'll have to ask additional speakers. I don't understand how, when the law says you only need to have one, that you could interpret that you need to have two. But you do acknowledge, and you've admitted with your experience, that it is important that all vehicles have two headlights, right?
Yes, sir. Obviously, it would increase visibility at nighttime to have two burning headlights. Correct. Yes, sir.
Thank you. I appreciate it. Thank you, Mr. Chairman.
Thank you, Representative. Representative Callahan.
Thank you, Mr. Chair. Just a brief comment, sir.
Yes,
I
sir.
hope my son is not giving you a hard time down at USC and at Olympia Mills over there on Haywood Street. So thank you for helping keep them safe down there. So hopefully he's not giving you a hard time. We'll see
Yes,
you.
sir. Well, I actually spent 11 to 15 years at the University of South Carolina. So, I don't recognize the last name, which is always a good thing in this profession.
Well, go Gamecocks. Have a good day, sir.
Yes, sir. You do the same.
Thank you, Representative. Comment or question from other members of the committee? Comment or question? Seeing none. Thank you very much for joining us today.
Thanks, sir.
R.J. Priest.
Hi, can you hear me?
We hear you.
Hi, I'm RJ Priest, an independent policy and media consultant, and I grew up in Connecticut. I am also a gay rights advocate, and I have been a classic liberal for 40 years. I strongly oppose SB 1380. It should exclude gender identity or expression entirely. Details on my position are in my written testimony, and I have timed my presentation at under 3 minutes. Also see the written testimony of Jeff Cleghorn, former board member of Lambda Legal. It was the gay ACLU. He supports my call for an independent state investigation into trans queer matters. So does Simon Price, who spoke earlier today. We are on the 6th attempted rollout to push transgender queer madness into Connecticut law in this session alone. Meanwhile, some other governments are rightly reversing course. Even Gavin Newsom is having rethink, but not in Connecticut with complicit media. Today's Democrats have no problem with kiddie cartoon porn for kids, enabling new pathways for predators and boys playing in girls' sports. So what's next in the genderqueer marketing plan? That may be MAPS, a new marketing term for oppressed pedophiles, and under the Queer Plus umbrella. And that's just for starters. As a historian of pro-Nazi Americans that were later celebrated by the left with a Connecticut angle, for example, New Canaan architect Philip Johnson, the aftermath of a crushed radical ideology is when the fun begins. Every bill, every vote, every comment are in the public record, and they are all material for history on you. There is no excuse. The shocking information is widely available, and history will note that. So who supported the eugenic-style mass transing of proto-gay and vulnerable kids for medical profit? And what about all of the legal puzzle pieces proposed in various legislation to prop up trans queer, like SB 1380? Who supported creepy cartoon books to soften kids up for the trans market and predators? Who did the politicians dish money out to? And what are the real remits of these orgs? The battle of genderqueer will define the legacy of every politician here today. In 1945, the U.S. Army defined the levels of radicalism. There were the diehards, in other words, the activists, some may be lobbying Connecticut politicians, then the opportunists, we know who you are, and the complicit. Complicit Dems should speak out right now on the record, because the complicit are also going down on the ship. In closing, Republicans here, I am with you. I deeply apologize for previously supporting now morally bankrupt Democrats, and I won't be taking any questions.
I will go back to I will go back to what I said earlier. The genesis of this bill is with me. And the reason for this bill has nothing to do with all of the testimony today. Not at all. Wasn't even a consideration. The consideration was that when folks like me show up in medical spaces, oftentimes we are treated in a way that doesn't comport with the reality of who we are. Having said that, I am happy to go on the record as having put this bill forward. I am happy to go on the record as standing up for folks who are others, because at one point, people like me were considered other to the point where we weren't treated as human. And if the record books want to record that, please record my name in those record books as standing with those folks. As the individual wasn't going to take any questions, if there's a comment, I will take the comment. He suggested he will not take questions. With that, we will move on. Kyle Probst.
Thank you. My name is Kyle Probst, and thank you to the Judiciary Committee for hearing my testimony this morning remotely. I am in the Atlanta, Georgia area, and I am here to testify against Senate Bill 1437 as drafted. Most specifically, I'm here to give you some information and answer any questions you might have about the release of medical record information to those parties who are authorized or required to have those records under both federal and state laws. First, I'd like to say that I am the Deputy General Counsel of Datavant, which is a release of information company, and I'm also the Vice President of AHIOS, which is an association of companies that are similarly situated to Datavant. We are all business associates under HIPAA, and we have obligations to protect patient privacy when we're disclosing records to any third party, to any other provider, to an insurance company, or to a patient themselves. And we have to comply with those privacy requirements when we're disclosing these records. Now, in this process, we're required to make sure that the request is both authorized under law, as well as the records that are being released are authorized to be released under law. We have to deal with things like highly sensitive information. We have to make sure that any of the records that we're releasing have express consent to disclose things like mental health records, substance use and abuse and treatment records, HIV/AIDS and STD testing records, as well as most recently reproductive health records. There's a federal reproductive health privacy rule, and in I think it was July of 2022, right after the Dobbs case, Connecticut adopted their own reproductive health privacy rule. So one of the things that we do is go through the record and go through the request and make sure that we have the express consent to disclose certain highly sensitive records. And then we have to check the record to make sure that that information is either in the record or not, and then determine how to handle that before there can be a proper disclosure. So this is a very time-intensive and labor-intensive process. We also have to make sure that the record that we are disclosing is the proper record for that patient. Believe it or not, we still, even in an electronic environment, have records that are transferred from one provider to another provider, usually for things like continuing care. And in that situation, those records have to be uploaded to the EHR file. So there's an opportunity for, say, John Doe's records to get commingled with Jane Doe's records. So we're making sure that those records are for the proper patient and that the records we're disclosing do not contain highly sensitive information unless it has been authorized, and also to make sure that those records are for the proper patients. Now, the reason I'm here to testify on these issues is to show you that there's a lot of labor and time and cost involved in this process. And imposing this $250 cap, I believe, is arbitrary. And the industry is willing to come to the table and talk about the fees that would be appropriate, but we would like to have that opportunity. Thank you for your time today.
Thank you. Comment or question from members of the committee, Representative Fishbaum.
Thank you, Mr. Chairman. Good afternoon, sir. Thank you for coming here today. As I was listening to you, I was thinking about which portion of the bill that you're particularly objecting to, and I think you got to that at the end. Am I to understand that it's the fee or the cap on the fee of $250 is the purpose of your testimony in objection to this language?
Yes, sir. That's correct. Yes, sir. 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 That is the primary objection to that specific bill, yes. But interestingly, that bill cross-references another bill that has statutory fees for the production of medical records. And I really think that the two have to be read in conjunction, although that other law is not the one that's being amended. It cross-references section 19A-490B, which is what establishes per page fees for the medical records. So Senate Bill 1437 actually only establishes a ceiling or a cap that can be charged for processing and delivering a duplicate of a record. And I actually would like to see the fees addressed as well.
Yeah, understood. You know, this has been an issue, and certainly the area has evolved with technology because, you know, 20 years ago, most of this stuff was paper. And, you know, you had copy charges and all of that stuff. Somebody had to sit by a copy machine. But, you know, today, most of this is electronic. What would you propose in place of the $250 so that the industry can recoup its costs, yet people aren't getting, we'll say, gouged by a very large fee? Do you have a proposal for us?
As I'm speaking for the industry, and we would have to collaborate on that with respect to the entire association, as well as the healthcare providers that would be affected by this, I don't have a proposal today that I could present to you. But again, I think one of our main concerns is that it cross-references 19A 490B, which establishes a 65 cent per page, which, just to give you a little background, that fee was established in 1993. And if we were to take a CPI adjustment using the U.S. Bureau of Labor Statistics numbers, that would be $1.45 today. So I think that if we look at the labor that's involved and the expertise that's involved in identifying highly sensitive information, we have to acknowledge that that 65 cents is likely inappropriate for the fees that we and the labor costs that we have in this day in 2025.
You would agree with me, though, that dealing with these records in an electronic form as opposed to paper form, as was at the time of the passage of the current rate, is probably cheaper for the industry.
I would disagree with that entirely. And the reason why is because the labor involved in searching a record through an EHR, you have multiple EHRs at most hospitals. You don't have one EHR. Usually it's through the consolidations. I believe we heard testimony on another bill earlier today about the complex web of ownership of hospital systems throughout the state of Connecticut. So what we have are a number of hospitals that when they consolidate, they don't force their other entities to go into the same EHR. So it's very common for us to work in one health system and have multiple EHRs that we have to go into. And then you used to, when you had a paper file on a shelf, you would be able to go over and pull the paper file from the shelf and then just make a copy of everything that was in there. Now you've actually got to go into separate files. You've got to go into separate software to find out a medical record number. And you've got to go in and pull the relevant records by the type of record and the treatment dates. It's not all just one file. This is not a point and click type of operation. Not only that, but you have the expense of the actual security that's involved. Back in 1993, you simply had someone at a desk and you had a file that was on a shelf, usually behind a closed door. Now, with computer hacking and people being able to access the records from all around the world, security is much more intense.
So what if this situation, what if by alternative, because we're talking about a third party receiving the records, how about if the individual themselves got the records directly, there would, you know, with some sort of, you know, there would be no need to review, right?
That is incorrect.
Okay, that's incorrect?
That is incorrect because HIPAA actually has provisions that if the medical provider determines that any information within the record could potentially, if received by the patient, lead the patient to possibly commit harm to themselves or harm to others, then the provider has the ability to withhold that information. And that is typical within usually your psychiatric records or mental health hospital records.
Okay. Thank you. Thank you, Mr. Chairman.
Thank
Thank
you,
you.
Representative O'Day.
Hello, good to see you again.
Thank you.
Yeah, we did that subcommittee on these medical records.
I recall.
Yes. So what state do you want us to mirror?
I don't know that mirroring another state is in our best interest.
Exactly my point. So tell us, it's been now a while, and you need to have some answer for us. I haven't had a chance to review your testimony, but I will tell you what's unacceptable is a $12,000 fee to get electronic medical records. Would you agree with me?
I will put my neck on the line and say I agree with you. A $12,000 bill for one electronic file should not be the case.
Exactly. Okay, so help me out here. Tell me what your group would be okay with for a flat fee.
I think if I may, I'd like to defer back to the group. And if this is just public testimony that we're receiving today, I will gladly confer with my group. And if the committee is willing to entertain counteroffers, we will gladly get you some. We will do it in a formal matter.
So yeah, so looking at line 74 of this testimony, instead of 250, so you're not prepared to tell us what your group would be reasonable with?
Not right now today. We learned about this hearing at a late notice, so I would like to confer with the industry, and also with the medical providers who are involved.
Okay.
So yeah, I think you have to understand that the way this bill is worded, this would affect all hospitals within the state of Connecticut. It would not affect private practice groups or independent doctors. So we do want to make sure that our hospital clients who we work with are comfortable with the fee as well. Because quite frankly, if we're going to talk about the industry a little bit, if our fees are not appropriate, typically we would have to go back to the providers and ask them for additional reimbursement to make us whole for any of the work that we're performing on their behalf to protect patient privacy.
All right. So if you're going to go back and talk to your group, that'd be great, and come back to us with a state that you would like us to mirror or come close to, or some revision, that would be great. Thank you.
Thank you.
Thank you, Mr. Chair.
Thank you. Comment or question from other members of the committee? Comment or question from other members of the committee? Seeing none, thank you very much for joining us.
Thank you.
All right, Christina Capitan.
Good afternoon, Senator Winfield, Senator Kissel, Representative Howard, and distinguished members of the Judiciary Committee. Thank you for allowing me to be here today. My name is Christina Capitan. I'm a resident of Broadbrook, and I'm the co-founder of CT Canna Warriors, a Connecticut grassroots cannabis advocacy organization. I am here today to express my opposition to HB 7065, a bill seeking to decriminalize small amounts of psilocybin. While I understand the intentions behind this legislation and fully support access for adults to psilocybin and other plant-based therapeutics, I think it's essential to consider the current legal landscape in Connecticut concerning both psilocybin and cannabis. As it stands, it is uncommon for individuals to be arrested or incarcerated for possessing small amounts of psilocybin in our state. However, we continue to witness charges such as drug factory and intent to distribute being brought against individuals for nonviolent cannabis-related offenses, at times for small amounts of cannabis that are for personal use but packaged in ways in which law enforcement officer may deem inappropriate. I wholeheartedly believe that this is in large part due to a lack of understanding of current state law by enforcement officers, as well as a lack of an effort on the state's part toward outreach and education for individuals in Connecticut on what is and what is not legal. People are still having their lives and futures negatively affected by arrests for cannabis, and vital resources are being wasted on these types of cases, although the repercussions they are facing are not in proportion to the real impacts these cases are going to have on our communities. Connecticut has already missed many critical opportunities to implement true social equity and restorative justice regarding cannabis, and taking valuable time in this committee to address decriminalizing psilocybin when the issue isn't currently having any substantial negative impacts on communities in our state is one less opportunity to do just that. I truly hope to hear HB 6377, an act concerning the reform of laws related to cannabis and equity, or a similar bill called for a public hearing in this committee this session to address the very real crisis we are currently facing in many already disproportionately impacted communities. Prioritizing psilocybin decriminalization while overlooking the ongoing injustices concerning cannabis is a little disheartening. Our state must place urgency and focus this session on rectifying the past harms of cannabis prohibition and ensuring equitable treatment for those still affected by cannabis related charges today. I also believe that creating a fine for possessing psilocybin may unintentionally incentivize police to seek out individuals who possess mushrooms to collect monies where currently there's no incentive to do so, as well as further criminalize those who are financially challenged. Thank you for your time and all your hard work. It is recognized and appreciated. I'm open to any questions. Thank you.
Thank you very much. Comment or question from members of the committee? Comment or question from members of the committee? Seeing none, thank you for your continued work. Christine Rebstock?
Good afternoon, Senator Winfield and honorable committee members. I'm Christine Rebstock, a 2024 state legislative candidate, and I happen to be a transsexual person. I oppose SB 1380. While I am grateful for the care I receive from my medical and mental health professionals, hormone replacement therapy has been good for me. I'm happy and I could live in the image that God had made me. But however, I don't like the idea of putting the proverbial gun to the head of medical professionals required to administer gender affirming care, which a term which I cannot stand. This creates more negativity for someone like me to live with. You can't go a day without hearing some negative stuff about trans people. And we're going to force doctors to perform gender affirming care. This just does not sit well with me. You know, they're the two biggest things why people hate trans people right now about kids, help out medical transition of kids. You know, interrupting a child's puberty is gambling with their long-term future health. Is the Connecticut legislature willing to do this? I'm not. And trans girls in high school sports, that's another sore subject. And when you look at the CIAC's website about transgender girls based on gender identity, that violates President Trump's executive order. I can, on the spot, offer a solution to protect girls' sports and not dehumanize trans girls as well. But right now, my life has become a political football. I am sick and tired of it. I'm sick and tired of gender ideology, which the Connecticut legislature likes to impose on society. It only accomplishes three things. It preys on children, it encroaches on women's rights, and it comes at the expense of transsexuals like myself who live with sexual dysphoria and just trying to live my life. Thank you.
Thank you. Rep Howard.
Thank you. Hi, Christine. It's always good to see you. You self-identified as transsexual as opposed to transgender. There's a difference.
Yes.
Okay, so I want to say this correctly. So, and you're a transsexual person, and you are opposed to this bill. Am I, based on your testimony, am I to understand that you are opposed to the gender identity or expression and sexual orientation portion of the bill?
If they're forced to administer gender affirming care to patients, when either they might not be adversed in that part of healthcare or it goes against their moral standards, what good does that do? It creates negativity.
Okay, so the bill does a few things, right? So, for example, it shall be a discriminatory practice and violation for a healthcare provider to discriminate on account of a person's race. You have no objection to that?
No, not
Color,
at all.
religious creed, sex, marital status, age, national origin, ancestry, disability, blindness, etc. No objection to that.
Absolutely not.
So your objection is narrowed to similar to the testimony you've heard before, which is just those sections, the gender identity or expression or sexual orientation, because you don't feel that compelling a doctor to do that is appropriate. Am I paraphrasing your testimony correctly?
Yes.
Okay, and you are saying that as a transsexual person yourself?
Correct.
And do you, it's probably not fair to ask in public. All right, thank you. Thank you, Mr. Chair.
Thank you, Representative Dubitsky.
Thank you, Mr. Chairman. Thank you for coming in. Very much appreciate it. you say you hate the term gender affirming care. Why is that?
I like it as trans healthcare. The problem is, especially with the young people, is that a lot of them have more mental health comorbidities that are passed over and are given a diagnosis of gender dysphoria. We need more mental health gatekeeping to confirm that someone has sexual dysphoria, not affirm it. The only thing affirming in my life is that good Lord has given me the ability to blend in and get treated like a woman in my everyday life. That's my only saving grace at times. But no, we need to confirm that someone has an actual medical condition, but we're affirming it and we're passing it over. And we're ignoring the real problems and mental health issues that these particularly young people have. That's why they detransition a few years later after they've gone down and they regret their medical transition because in the end they didn't have sexual dysphoria. And some professionals were too quick to put the label on that for them.
Okay. Tell me the difference between a medical problem and a mental problem. I'm not sure I followed how you were saying that.
The mental health aspect is dealing with your dysphoria. And if you get to a place where I'm in life, you're going to medically transition to change your body to, for me, my hormone replacement therapy. I look like a woman. I blend in as a woman and my breasts are real. My face is soft and we don't have as body hair has pretty much disappeared. So this stuff helps appearing every day. But, I can never be a biological woman. And I think that too many young people are told that you could change your biological sex. And that's impossible.
Okay.
And,
So,
the best thing I want people to know, I think our medical professionals need to know, the best thing is try to blend into to society as who are true self. And people are not being told that. And why we regret, and our representative, why I think we're seeing people regret medical procedures and surgeries is they think it's just a magic fix. It's not.
so is it your feeling that that children should be getting mental health treatment as opposed to medical treatment for these ailments?
I prefer more mental health gatekeeping, especially for minor age children, yes.
Well, thank you very much. I appreciate your coming in. Thank you, Mr. Chairman.
Thank you. Representative O'Day.
Thank you very much, Mr. Chair, and thank you, Christine, for coming in and testifying. If the chair would give me just one little brief a bit of leeway, I read your testimony. The line says, "I can offer an on-the-spot solution that would comply with the EO and not break existing Connecticut law." Can you give me a brief, quick on-the-spot solution?
Sure. Well, first of all, I got to remember Connecticut state law that Attorney General was on NPR radio, and I confirmed it with him when I called into Gary Byron's Talk of Connecticut. Says that trans girls are girls. So language that biological boys be prohibited from CIAC sports violates Connecticut state law. When I played sports, I needed to have a medical provider send my testosterone level results to my rules organizations, which the United States Bowling Congress, that would be in Arlington, Texas. But a month ago, to comply with President Trump's executive order, we're no longer able to compete in any elite level or recreational level women's event. So my proposal, this is one that I sent to Glenn Lungarini, who is the executive director of the CIAC, and he rebuffed me downstairs in the rotunda, was I submitted a proposal for all trans girls or anyone assigned male at birth to play girls' sports. They would have to have a medical provider send a record of a testosterone level of under 144 nanograms per deciliter for a period of 48 months. Does that say that trans girls can't play? No, they have an actual guideline that needs to be followed. There's no loopholes around that, and that should not be demeaning to them. And this bill, if they ever enacted this, it should be shielded from court injunctions and lawsuits too.
Thank you for that. Christine, to the extent you're willing, I looked at your testimony to see if there was a way to reach out to you. There's not, but if you're willing to reach out to me, I would greatly appreciate it, the ability to buy you coffee and just talk to you on how we can do better in the state of Connecticut for you and others.
No problem. I'd be glad to do that.
Thank you.
Thank you, Representative. Comment or question from other members of the committee? Comment or question? Seeing none, thank you very much for joining us.
All right, next up will be David Reynolds.
Co-chairs, ranking members, it's on, and other members of the Judiciary Committee. My name is Deacon David Reynolds. I'm Associate Director of Public Policy for the Connecticut Catholic Conference, and I'm here today to address Bill 1380 and our concerns about that piece of legislation. First, I'd like to say that I think the underlying intent of the legislation is laudable. Studies have shown differences in race and even in the disability, that people facing barriers to healthcare because of that. So the underlying bill is laudable, but we think the bill actually overshoots itself in a target. And that's why today we have many people on here talking about the gender identity issue before us. The conference, so what I'd like to do is highlight briefly some of the concerns we have with the bill. One is the discrimination statutes that it would go into, the CHRO discrimination statutes, are full of religious exemptions for religious organizations. This legislation does not contain similar religious exemptions for hospitals or Catholic healthcare providers. And of course, when we talk about gender identity, that's one of the big issues that Catholic healthcare does not follow. So first statement is, as we look at this, your committee is trying to incorporate this in the CHRO discrimination statutes. Religious liberty protections are lacking where they are contained in other parts of that statute. Also, additionally, in this bill, besides the gender identity issue, we have a concern about the word sex being included in this bill too. And that's only because as we look at changing definitions of sex, we're not going to be sure what that actually means anymore. I mean, we have right now a bill that came out of the GAE for a constitutional amendment that defines.
Sir, I'm just going to rein you back in. We're on this bill before this committee today, not on bills out of other committees.
I'm not going to comment. I'm just relating the definition used. Yes, 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 sir. But and then it's not just changing the language of sex in that proposed bill, but nationally, there's looking at that sex would include access to abortion. Sexual Discrimination Act would include denying an abortion. So we have concerns about the word sex being used in that language, in that area. We also have in here raises serious concerns about including the word age within the definition, because medical providers, medical situations are given, or cures are given based on age many times. And sometimes it's up to the individual doctor to decide what's appropriate, what's not appropriate. And people could, again, bring more discrimination lawsuits against this if age is included, especially if the child wants age. I think one of the big issues is how passage of this legislation would impact parental consent by the inclusion of age, and that's not addressed in this bill. Also, as you've heard before, the phrase professional standard of care, can I just wrap up?
Yep.
Is not adequately defined in this legislation. So we actually do have international organizations dictating standards of care. And the other question, final comment I would make is the CHRO the actual body that should be concerning reviewing these complaints, since medical care is a very complicated situation. So the conference feels that if somebody's going to review these complaints, it should be some type of medical organization.
Okay. Thank you. Questions or comments, Representative Jablonski?
Thank you, Mr. Chairman. Thank you for coming in. You say you have a problem using the word sex. up until fairly recently in the English language, sex was the difference between male and female. Now, are you suggesting that we should no longer use that? We should use the word gender instead of sex?
Well, what I'm relating to is as our society's evolving or moving about here, there's been a push to include under sexual discrimination, which this would be, right? It's a discrimination bill, sexual discrimination, to include sexual discrimination, the denial of an abortion or medical, abortive abortion care. So, and that is why earlier in my testimony, I brought up a bill considered in another committee. I'm not making comments on it. That bill does, within our own building here, redefine sex to include discrimination based on termination of pregnancy. So that's my
Okay,
concern, yes.
So it's your feeling that using the word sex here might conflict with the language in another bill, which is not yet law?
Yeah, or that CHRO, based on what's going on in other states and other considerations, other court cases would say, okay, yeah, denying somebody an abortion or termination of pregnancy, as they call it legally, is discrimination based on sex. So I mean, it's a far-flung idea to get around, I think, because even I had trouble dealing with that. But it's a concept being floated out there. So that's part of what I'm saying about this bill. It has laudable intent, but I think the language could be more finely tweaked so we can leave out these highly controversial areas and possibly address the issue of race. And again, disability community has studies out showing that disabled people do encounter discrimination in medical health care.
Okay, all right, thank you. Thank you, Mr. Chairman.
Further questions or comments? If not, thanks for being with us.
Thank you.
Cynthia Brahani.
Hi, thank you for having me. I'm testifying today in opposition to SB 1380. This bill is a direct attack on medical ethics, forcing doctors to perform irreversible procedures under penalty, even as emerging research reveals their inefficacy. Sex is determined in utero and by genes. It can't be changed, despite my belief growing up that I could change mine. The conditions labeled as intersex that were mentioned earlier are actually a plethora of sex-specific disorders that require accurate sex determination for their successful treatment. Attempting to change sex is futile healthcare, yet gender giving no limits allows for the objectivity of futile healthcare to be vulnerable to the subjective definition of gender. You mentioned that this bill was not intended for this, but you allow for it. You should reconsider your allotment for gender if you in fact want to represent people like yourself with it. As a child of Cuban immigrants who faced racism because my grandparents didn't speak English and relied on state programs like Medicaid, I can sympathize with your intent. I urge you to rewrite this bill to strengthen its integrity and ability to support the intended groups and not leave itself open to dismissal because of ideological exploitation and the potential to thereby cause immense harm. The state would be remiss in its duty to serve the people if it refuses to review the mounting evidence that has led other nations to abandon these practices. The fact that you hadn't fully considered the weight of the current language of the bill should give you pause. It should make you, as a policymaker who wants to support vulnerable members of the public, tighten up the language and make this bill as strong and as thoughtful as possible. Now, thanks to all the testimony you've received today from my colleagues, you have the ability to do that and become a more effective legislator and representative. That's what you should go on record for, not someone who didn't think things through or listen to people. I'm open to questions.
Thank you very much. Questions from the committee? Seeing none, thanks for being with us. Mark Tezaris. And what's your name, sir?
James McGinnis. I'm later on in the sequence, but I was actually going to do the bulk of the testimony here.
Okay,
You
perfect.
got his hand up,
You
yeah.
guys could just together 3 minutes and happy to take you together.
That's
Okay,
you're good. Okay. Good afternoon, Chairman Winfield, Chairman Staffstrom, Ranking Member Kissel, Ranking Member Fishbein, and members of the committee. I am James McGinnis, the Executive Director of the Criminal Justice Information System Governing Board, known as the CJIS Governing Board. Our organization oversees the Connecticut Information Sharing System, which I'll refer to by the acronym CIS, and we'll use that in today's testimony. The purpose of this testimony is to support SB 1387, which clarifies the executive director's authority on the governing board and also clarifies that the criminal justice information technology system should not be restricted to sharing only offender-based data. And that's the key issue, the information sharing clarification. That's in section 54142S. CIS was designed to facilitate secure data exchange among law enforcement, courts, and criminal justice agencies in Connecticut. Historically, agencies have shared with CIS both offender and non-offender data, all of which are essential for public safety and judicial processes. A recent legal interpretation has restricted the sharing of some non-offender data in CIS, impacting system efficiency and potentially delaying access to critical data and requiring users to use different systems to get to this data. Bill 1387 corrects this ambiguity, ensuring continued sharing of non-offender data in CIS without expanding CIS's scope. Next item, the Executive Director Authority, that's in section 54142Q. The bill formally defines the role of the CJIS Executive Director, ensuring clear oversight of policy implementation, system security, and interagency coordination within CIS. This structure enhances efficiency, accountability, and data security in CIS while maintaining governing board autonomy. Furthermore, the CJIS Governing Board is committed to collaborating with stakeholders to annually increase adoption of electronic workflows using CIS. This ongoing effort will enhance efficiency, reduce manual processes, and ensure greater accuracy in criminal justice information exchange. So why this matters: without these clarifications, authorized users may lose access to essential non-offender data in CIS. Judicial processes could be delayed as CIS is used to electronically send case updates to authorized agencies. CIS is also used to distribute clean slate erasure notices. And finally, adoption of electronic workflows may stagnate, preventing the full benefits of automation and data sharing efficiencies originally envisioned for this system. Conclusion, I urge you to support SB 1387. Thank you for your time. I welcome any questions, and my colleague Mark DeZaris can testify to any original system development process questions.
Questions from the committee, Representative Fishbein, Stern.
Thank you, Mr. Chairman. Good afternoon.
Yeah.
So the underlying, what we would potentially be doing here is the governing board of CJIS will be hiring an executive director. Well, let me ask you this way. In lines 38 through 49, how is that different from the present?
What's been done with the markup here, and some of this is maintained with the update. This part is not any different. The board has hired executive director. I'm third such executive director in the history of the board, who is not a member of the board, and so forth. What we're adding, and this really more or less starts, on 50 and proceeds down through 74. It's just really adding a lot more of the detail about the duties of the executive director. We will periodically, in kind of our daily execution of our tasks, we'll get questions about, what's the authority of, and I'm a municipal police department now. Why do I need to connect to CIS? What's the authority? Where is it coming from? And then the fact that we are APO'd to DES. There's a little bit of ambiguity about, who's making the decisions on the board in terms of, hiring staff and folks of that nature. I've gone to hire staff, and I've had DESP HR tell me, well, the commissioner has to approve this. The board is supposed to be independent. The APO relationship is focusing more on back office tasks as opposed to actually staffing the board and having, the commissioner oversight of hiring on that. And so we decided to add some tasks and duties of the executive director in consultation with my board's co-chairs. I've also had recently some.
I asked you a very simple question.
Sure.
Okay.
Yeah.
So I just asked you about lines 38 through 49. And I believe what you've told us is that doesn't change anything.
38 through
49.
49. Yeah, that does not change. It's,
Okay, so
yep,
can we just move forward from there?
Yep,
I just,
absolutely.
okay.
Yep.
So hiring an executive director, which we've done in the past, we're on our third, got that. But now one of those additional duties is, and I'm looking at line 70, we're going to allow the executive director to appoint a designee essentially to do things that we're expecting the executive director to do, correct?
That is correct, yeah.
Okay,
We're adding.
why would we be doing that?
In the event that, say, we have to have a governing board meeting, the governing board meetings are held quarterly, and the executive director is not available to participate in the meeting. Just by having some clarification in the statute about the ability to appoint that designee would help facilitate the smooth processing of that meeting.
But why wouldn't the board have the power to do that? So you hire me to be the executive director, right? You have, interviewed, you've gone through the time, you said, this is the best person, right? But under this language, you're saying that I can designate Senator Kissel, who you haven't interviewed. You have nothing to do in the choice to do my job. That's what this says, right?
That's a fair point, and we're certainly willing to work with the legislature to clarify this section to make it more specific to tie the governing board into that selection process.
Sure, I mean, clarify is one thing, but changing it, I mean, it doesn't make sense. I mean, quite frankly. In line 75, the executive director may employ staff as deemed necessary. Once again, you're saying to me as the executive director that I have the choice to hire whomever I have without any override or control by the board. That's what this says.
I think isn't this legacy right here? Yeah. Go ahead, Mark.
Hi, good afternoon, Mr. Chairman.
Speak in the microphone, please.
Good afternoon, Mr. Chairman, and the rest of the members of the Judiciary Committee. Mark Tezaris, I'm a CJIS Program Manager. And bottom line here is basically things. Okay. The intent on the language that you indicated for designee, that's just if he's out on vacation. That was the intent. If the language basically is indicating something different, and I see your point, we can definitely change that. All it is if he's on vacation, if he's out sick, he can designate somebody else. In the past, there was no executive director for over 2-3 years. I actually did that role in addition to the program manager. So all we want to do is just basically have some language to allow that to happen formally, not informally.
Okay, I got that. It's absolutely not what this says.
Yeah, I think we need to change it.
Yeah.
Your point is valid. I see it.
Okay.
Agreed.
So we were, at the time that you were given the microphone, I was asking about line 75, where it talks about
Sure.
the executive director can employ staff, but once again, it appears that there's no fetters. The board has no part of that.
I'd like to clarify that a little bit more.
Sure.
All right, so we have the CJIS Governing Board, which is basically mostly the commissioners of the CJIS agencies. Senator Winfield is also part of it. And we also have an action committee. It's a smaller committee. And basically, we meet once a month. And in that action committee, we have the executive director and the 2 co-chairs. If we're going to hire anybody, it goes through that action committee. So we basically make the case. that we need an extra developer given everything that's going on and the work that's coming and so forth. We indicate that the budget is sufficient. And we basically indicate the specific class and the salary and so forth. And then we get an okay from both co-chairs and the other members of the CGIS Governing Board, including Mark Raymond, who's the State Chief Information Officer. Once we get the okay, we work with OPM to move forward. And then we inform the larger committee on a quarterly basis of that decision and that movement.
Okay, so you're not happy with that situation as you
I
presently
think what's happening is that the original language in the legislation did not indicate those specific abilities of the executive director. They were assumed. And some of the issues, as Jim indicated earlier, was that, we're under for administrative purposes only. We're a small agency and basically under DSBP, and they provide HR resources for us and other resources. And it's not clear to them, it's not clear to us a lot of times of who gets to make the decision on the number of people that can be in that agency. That's where we got the glitch. Okay, the SPP has a certain number cap for hiring, and then we are trying to hire in parallel, and we hit that cap, and then we needed clarification, and we understood basically that we are not within the cap of the SPP for number of employees for that agency. So we just want to clarify somehow that basically there is a difference. So if we're under APO, under DSBP or another agency, that the cap is specific to CGIS, the total number of state employees.
Okay, so I'm looking at, in my mind, a hierarchy chart, right? So the top of the chart is the board, right? And then we have the executive director, and then we have the subordinate staff. Okay, that's basically how this is.
Yes.
This lies out. So under this language, should it become law, the board can create duties and determine priorities for the executive director and the staff, okay? So that's the top coming to the bottom, okay?
Yes.
Hiring, though, under this language, has nothing to do with the board. The executive director makes all those determinations under this language. Is that the structure that you're asking to have adopted?
Yes.
Okay,
And
so the board would have nothing to do with removing an employee?
correct. That is correct. That is correct.
Why-
That's what, okay.
Why
that's-
would that be?
Sure. That has been the way we have basically worked with the board historically for the last 15 years. All right, we kicked off somewhere, we started off in 2010 when the contract was signed, and the kickoff meeting was 2012. And basically, the executive director worked with the board to stay within budget, go through the proper requests. The board would give a thumbs up, basically a yes, move forward, given everything that we understand. And then from there, we would work with OPM and do the hiring. But the board is involved. We do get permission from the board to do every single hiring.
But that's not what this language does. This gives unilateral power. That's what I'm trying to figure out. We have the dynamic of what is going on now. We have legislation that's before us that says, we don't want to do this anymore. We want someone else to do it. I'm trying to figure out why.
We should include the other part that happens that's not here. That
Okay,
is
well-
with approval of the CGIS Governing Board. I think that's what's missing here, and that's what the point I think you're making.
Well, I'm just inquiring as to
I-
why it's not there. Maybe
It needs
maybe the
to
board
be
doesn't
there,
want to do it. I
so
don't
it's
know.
not
Well,
ambiguous,
I'll,
right?
I'll just, yeah, and thank you for that, Mark. A lot of the staff that we employ are consultants, so we will retain consultants through a, kind of a state, common contract we have with DAS BITS. We review overall headcount against our budget with our governing board on a regular basis. The state employees that we hire all go through the proper DAS HR processes. The governing board can certainly remove the executive director. We have, certainly are willing to clarify some of this hiring and firing piece here and make sure that the board is as they are. We do review, as Mark said, every month, our human resource posture, our head count, and performance against budget with our governance committee. So we can certainly add some language around that, clarify it.
Well, thank you.
Yeah.
So in this paragraph, which begins at line 75 through 82, there's another line. And it says the Department of Emergency Services and Public Protection shall provide office space and such staff, supplies and services as necessary for the executive director to properly carry out his or her duties. So we've talked about individuals. You see where I am? I'm specifically at line 80.
Yep.
Okay. We talked about individuals that under this language are unilaterally employed by the executive director as deemed necessary. But then I've got a mandate on DES to provide such staff as is necessary for the executive director. What's going on there?
Representative, that part is not new. It was simply moved down from 44 through 47.
I recognize
Yeah.
that, but it doesn't make sense, right? So you have a body of staff necessary for the executive director to do their job, right?
Sure.
In line 75, it says that the executive director employs that staff, right? And I take it that employ, the utilization of the word employ here could have two meanings. It is use that staff, and it is hire, right?
Sure. Yeah.
I think what is intended there is hire, okay? But then we have other staff that is being required by DESP to be provided that I would think that DESP is hiring. So I understand it was existing language,
Sure.
but
Yeah.
do we need it?
Well, I'll tell you, it's, CJIS governing board is interesting from the state employee perspective. Most of our state employees are IT staff, and these folks are actually organizationally part of DAS BITS, the central office. And so on paper, they report up to them, but they're deployed to us for resources. The non-IT staff on the CJIS governing board, state employees, there's three of us, myself, Mark, and I have a physical analyst. We are all DESP employees. That's how this has been set up for many years. So that's probably what this language is just getting at, just mentioning, those folks.
All right, the last area I want to ask you about is lines 142 through 144. And this is an action item. It comes under sub C of section 2. It talks about what's included in the database. What is meant by any other relevant information collected, managed, or maintained by an entity having cognizance over matters related to law enforcement and criminal justice? And this is totally new language. There's got to be a need for it.
Sure.
What's meant by that?
Sure, absolutely. And we're actually working with the governor's office and OPM's criminal justice policy and planning folks to clarify this section a little bit and make it very specific around non-offender based data. And we'll tell you why we want to add that. And I'm going to ask Mark to tell you a little bit about the history of the system and the data that's shared in it.
All right. Let me see if I can just clarify. What's happening is that we built the Connecticut Information Sharing System, and it has a Google-like search. We brought 14 criminal justice source systems in one location. They're cross-index. Law enforcement can do one-stop shop instead of going to 14 different separate areas. Okay. And it has a workflow. Police officers don't have to drive every arrest to the court systems. Takes hours and minutes. Minutes and hours. It goes in seconds, okay? And we agreed on what data is going to go in the system when we put it together. There was a contract through an RFP that the state basically signed with Xerox. And the data that was going to be used in this system was going to be both offender and non-offender data available to law enforcement at that time. All right. And we basically have built the system that way. And specifically, the weapons database, for example, and the wanted file from a DSPP are really where we're having a glitch here. We agreed with DPS, Department of Public Safety at the time, now it's DSPP, but it's larger, to share that data. They agreed that basically we will share that data in the system. We built it, we deployed it, everybody's using it. They like it. It helps officers go into a certain event like domestic violence to understand are there weapons there, to avoid, walking into a situation that could be dangerous and handle it differently. As administrations within DSPP changed, we get different commissioners, we get different technical folks, different legal folks. Recently, we're understanding that their interpretation of the original legislation language was that it should be offender only. Okay. And nobody else understood it that way prior, including the Assistant Attorney General who signed the contract to build the system at the time in 2010. So we're at an impasse. We're trying to basically continue getting the weapons data inside the Connecticut Information Sharing System for sworn law enforcement. And that data has been discontinued because their legal folks are interpreting that it should be offender only. Now, we went to the Assistant Attorney General's office and they interpreted that, well, look, on the top of the legislation, it says offender data. And then under it, it says and other data, including non-offender data. So from the hierarchy, they're thinking basically their interpretation today, which was different then, is that it should be offender data or the legislation needs to clarify. All right, because the legislation is ambiguous enough so that a lot of legal folks are interpreting it this way, we need to help clarify that for the future. Whatever decisions are made to include offender and non-offender data today, as other administrations come in, other commissioners and legal folks come in, we're not the same problem. The other big problem is that if we're forced to take out this data that we put in there, we're going to break this thing. It costs like $100 million to put together over 10 years. So we'd like to get some clarification that the original intent was to include both offender and non-offender data that is currently available to law enforcement. We're not looking to go beyond those parameters. And, the same data, the weapons data, for example, and the wanted data are available to law enforcement from other systems, not this central system. It's available in the collect system. So the ask here is, can we clarify that the intent is to basically allow the use of offender and non-offender data for the Connecticut Information Sharing System that's available, that's normally available to law enforcement. That is the gist of the whole thing here. That's what we're looking for. And somehow we need to clarify the language to reflect that. And that's the ask.
Understood. And of course, George Orwell wrote about such things prior to his death. I'm a little concerned. I mean, if you're representing to me that law enforcement doesn't know about whether or not there's possibly a firearm in someone's home prior to them going to a scene, that is not true. I mean, they can run everybody who's known to live in the house. They could find out whether or not they have certain firearms permits. But ultimately, you don't know about all the guns that are in this state. People get arrested all the time in our cities that shouldn't be possessing firearms, and there's no way for an officer to know if they go to that house whether or not a firearm is there. But, one of the things that I've been concerned about is the government tracking individuals through like license plate readers. Now, and I recognize that there is no statute that mandates the retention period for that information. So, that's information that would go into the system because we don't know what the word relevant means. Relevance only happens at the time that the information is utilized, right? So when we say any other relevant information collected, maintained, managed by an entity having cognizance over matters related to law enforcement and criminal justice, what it really means is all information collected, right? As written. So, I'm all in favor of police officers being safe, but, if that's the cover under which we say that all information collected by law enforcement is going to be put into the system for non-offenders, life, liberty, and pursuit of happiness, I got problems with that. So I look forward to whatever language the governor crafts to clarify this. I understand the representations here today, but I'm a little concerned. Sure, if you want to
Can I add
respond.
something? real quick,
Absolutely.
just to clarify a little bit more. All right. All we're basically trying to do is make the information, the data that current law enforcement have access to from various different systems, but they have access to it today, put that in one location. That's all we're saying. One-stop shop, go in there. Yes, you can get it from all the other systems. No new information. We're not adding anything new that they don't have. We're taking the existing data that they currently have today, that's dispersed and siloed, put it in one location so that a dispatcher, for example, who's basically dispatching law enforcement to some kind of a event, can do a quick search in CSS search, look at it, and basically provide a lot of information that would not be, that person would not be able to do by going to 14 different systems, logging in, taking notes, and basically trying to correlate the information. We're not adding anything new that law enforcement does not have today. And the second thing is the same exact folks that have access, for example, to the weapons database. I'm making the number up. If there's 1,000 of them that have access to it, those are the same exact folks, no more, no less, that will have access through the CSS. All it is take all this siloed systems, put them in one location, give access to folks so they can get it in one-stop shop like a Google-like search. That's the essence of what needs to happen.
I understand, but just to come back to license plate readers, right? You have 169 different municipalities with no direction from the state as to how long they should retain that information, okay?
Yes.
Tonight, a license plate reader picks up a plate in Colchester, and based upon this legislation, that information would be returned over to the state. You have the state, you'd have that information in Colchester and the state. Now, Colchester may say what's reasonable in our community, and their town council may take it up, for us to retain this stuff for 6 months, right? Because that's what we think is the appropriate thing. But meanwhile, it's with the state also, right? And the state is keeping on to that for whatever they think is necessary of non-offenders. And, the concern is ultimately not to get, when people start to get tracked as far as who they're meeting with, when they're meeting with certain people, and they're doing it on an innocent basis, let's say political organizing, right? Tracking license plates is one way to tell where people are and who they're meeting with and all of that stuff. So I look forward once again to seeing clearer language. I don't want to handcuff law enforcement that's going after the bad guys, but certainly I have a lot of concerns about big government. So
We share those concerns as well.
thank you, Mr. Chair.
Further questions or comments, Representative Lemonier?
Thank you, Mr. Chair. Thank you for your testimony. Glad you're here today. I have a couple questions. Does CJIS have any other functions besides officer workflow?
Well, CJIS governing board oversees several applications. The primary one is the Connecticut Information Sharing System, which is what we're discussing here today. And that sharing system has both the, as Mark calls it, the Google-like search, and then also the electronic workflow. They're both within that one system. We also support some other initiatives, primarily with IMRP, Connecticut Racial Profiling Prohibition Project. We are the technology behind the scenes between Ken Barone's team and the RMS vendors at serving various police departments. We also do some data analytics with the Sentencing Commission and OPM and prison bed population.
So in statute, there's quite a bit of information that police officers collect that the state legislature has decided that OPM should track and report on that for policymaking purposes, budgetary purposes, and to just understand what the priorities should be for the criminal justice system as a whole, right?
Sure.
Okay. So it's not just workflow, it's not just police officers accessing the information. And when that information is used for research purposes, it's not based on unique identifiers, correct? Right?
Should I speak
So
to
it's
it?
aggregate data,
Sure.
right?
You're correct. What's happening is these 14 source systems, they're one location. In addition to that, we're getting all the arrest information. Instead of paper, we're getting it electronically. All right, so we have that all in the Connecticut Information Sharing System. And there seems to be a strong demand by various agencies within the state government to get access to anonymous data, as you were indicating, so they can basically test hypotheses and ultimately provide evidence of policies working or not working, or any changes that need to be made.
Right.
So we're making that available, and we're actually going to improve it quite a bit. And the data is anonymous, and OPM is, and the Sentencing Commission and so forth are some of our main users.
Right. So when the legislature says, for example, that the OPM, the state should track, let's say, use of force data or car pursuit data, that data has to go and they have to issue a report. That report has to be made. It's not a list of each offender who was involved in an incident with a police officer. It's an aggregate analysis of what it looks like across the state between state police, local police, right? Correct? Okay.
Correct.
So that's a function. That was the original intent of CJIS, correct? Many years ago,
It was to
like
share
30
the
years
data,
ago?
And this is one way
Yeah.
to share that data.
Right.
Yes, the answer is yes.
Correct. So the other question I have, and you were talking about how CJIS is one-stop shopping, as opposed to going to all those different databases. And I'm sure my colleagues who are or were police officers can agree that more information is always good when you're responding to an incident or a scene. And if you can get that information quickly, is even better. So my question is, what are we going to do with all this duplication? Let's assume CJIS gets up and running, all of your issues get straightened out, either statutorily or however. And now we have CJIS that's one-stop shopping, but yet we're still funding and utilizing, and I'm going to use your number, these 14 other databases. Is there a long-term goal that there's no duplication in effort, so that if I run something in CJIS, I don't have to turn around and run it and collect?
Take that? Go ahead, Barr. Okay. All right, so there's such a thing as a system of record. All right, that's the original agency by statute or in Connecticut that is responsible for getting that data. The Connecticut Information Sharing System is not a system of record. What we do basically is we collect that information from the various agencies, and I can name some. It would be judicial, it would be DOC, it would be DCJ.
Right, collects,
Yeah,
EMS,
yeah,
all
collect
that
as
kind of,
well,
yeah,
that's
yeah,
right,
yeah.
that's right. So we're not the system of record. Now, yes, there is some duplication, okay? But we are receiving the data from the folks that actually entered it in.
Okay, I get it. So the agency, that's,
Yeah.
CMS
So-
would be basically judicial's file cabinet, and they're just sending it up to you for
Yeah,
then
they send it
broader
electronically now.
uses.
Yeah.
Right, so then you take that data and you use it for research purposes, policy purposes, workflow purposes. Okay, I get that. So then,
I want to add something to
Yeah.
just to kind of answer your question a little better, if I may.
yeah, sure.
All right, look, it does make sense to ultimately, in the future, move in a direction so that it does make sense so that ultimately in the future, we move in a direction where we don't have that duplication. It
Mhm.
does make sense, okay? There was a vision once upon a time that when we're putting all this together, that we would move in that direction. And, we would look at it as a state, as CJIS agencies, CJIS community, and figure that out. There's nothing tangible there, okay, at this point, but it does make sense. And I think a lot of folks are looking at that way down the future.
Okay. And then I just wanted to go back to line 142 through 144 for a moment. And I understand the concerns that my colleague had. I share those concerns about privacy. But in terms of this, looking at the other functions of CJIS for specifically research purposes and policy and budgetary purposes for OPM and the governor, and as well as the legislature, shouldn't it be matters including to but not limited to law enforcement and criminal justice? I mean, I'm just thinking, for example, and just for the record, I was a criminal justice policy researcher for a while. Some of the questions that I was asked to answer by this body many years ago, for example, was how many people who are involved in the adult criminal justice system at some point when they were children were involved in the foster care system. So was there a nexus between foster care and people ending up in the adult criminal justice system? Is there a nexus between educational achievement and ending up in the criminal justice system? So there's lots of information that we know now that comes from research that used all of this information, right? So if you're limiting it to law enforcement and criminal justice, and a researcher was going to come to CJIS and say, I want to know if there's a nexus between, again, foster care and criminal justice, or public health and criminal justice. You would be you'd have to go, I know the hoops that you'd have to go through to try to get for example, DCF in my example, DCF to share the data with you. But if this said, including but not limited to, you would at least be opening the door to agency data. And I understand agencies have proprietary, our government is siloed. They have proprietary feelings toward their data, but it is all state data. So if the legislature, for example, wanted to have a study on that, it wouldn't be, there should be no fighting over how the data could be used. Again, it would be unique identifiers. You couldn't track it back to who specifically it was tied to. So I'm glad to hear that you're working on that, but I would encourage you to think a little broader, that it's not just workflow, that CJIS has been around for 30 years. Yes. And it's been going through different sort of evolution, and the state has spent well more than you mentioned on this project. And again, just for the record, I was one of the original people who sat on the group that conceived of CJIS. And so it was conceived as something to be broader, really to be a research tool. So it's evolved into this workflow. So I would just encourage you not to forget that, and to realize that CJIS, because we have all these other databases available to police officers, and I really like CJIS being available to police officers, CJIS was really intended to serve some other functions that the state needs. So, let's not throw the baby out with the bathwater on that one.
We agree with you on that. Great points. I just made some notes from this conversation. And you mentioned use of force. We are also working on that project with IMRP and DESP as well. So, and we're getting more and more inquiries from the OPM, criminal justice policy planning folks, on data analytics and research and so forth. So we are continuing to improve our processes there, and we definitely want to think bigger. And we're more or less a kind of a servant leadership organization. We don't own any of this data. We basically build all the pipes so it can be shared, and we're happy to work with anyone in the state that has appropriate, legitimate access to this data and help you do your jobs better. So absolutely.
Thank you.
Great. And I just think one other point is that, going back to the language about being APO'd to the Department of Environmental Service and Public Protection, I think you're encountering some of the other problems that or entities or organizations have with APO. I mean, it's not statutorily defined. And so there's ambiguities there. And then it's implemented by different agencies in different ways.
Absolutely.
So that desk staff is really there to provide you with administrative, like they provide you with budgeting and like your budget goes through their budget. So
Mhm.
you don't have to hire those staff. So I think it's the onus is sort of maybe on the legislature at some point to figure out what APO actually means.
I agree. APO is a very challenging position to be in, frankly, because there's the theoretical of the services they provide and the actual of what you get. And, we're trying to execute our mission and we're not getting appropriate services. Like, for example, we don't have an in-house counsel. We rely on attorneys in the Attorney General's Public Safety Unit to provide legal opinions as required, but not for FOIA requests. So we had a FOIA request. We had no attorney to help us out with this. We did work out something with the governor's office to get some support, but it took me weeks and weeks of dialogue to try to get the appropriate support on that. It was just, that's just one example of some of the challenges around the APO.
Thank you. Thank you, Mr. Chair.
Thank you. Further questions or comments? Just super quick. You guys obviously are under the auspices of DESP. Was this bill reviewed by DESP before it was submitted to the committee?
This, we did review the proposal in a governing board special session and it was voted on there.
Okay, that was my question. My question was whether it was reviewed by the administration at DESP before it was submitted to us.
Not specifically, although they were copied on this. We did not get any feedback.
Okay, because I went back on my notes and it looks like when you submitted to the committee, you represented to us that it had been, you at least consulted with member agencies, including DESP. So I know they've submitted testimony with concerns on this bill, so I would highly recommend you talk to them sooner rather than later.
Sure.
Okay.
And
thanks for being with us today.
Okay.
Next up will be Werner Oriana.
Good afternoon, co-chairs Senator Winfield and Representative Staffstrom, ranking members Senator Kissel and Representative Fishbein, and esteemed members of the Judiciary Committee. My name is Werner Ollanadel, and I serve as the Latino and Puerto Rican Policy Director with the Commission on Women, Children, Seniors, Equity, and Opportunity here at the Connecticut General Assembly. Given the time constraints, I will not be reading our full written testimony, but I want to highlight for the record that our agency has submitted it in writing for the committee's review. I am here to express strong support for the bill that your committee raised, Senate Bill 1436, which is essential for strengthening the integrity of police data reporting and reinforcing public trust in law enforcement. This bill was first introduced by Governor Ned Lamont in response to concerns about the accuracy of law enforcement records. Last year, it actually passed the House with bipartisan support, but did not advance in the Senate. In August 2022, Hearst, Connecticut media broke the story that 4 Connecticut state troopers had been investigated in 2018 for misreporting traffic citation records. This led the Connecticut Racial Profiling Prohibition Project, or the CTRP3, to conduct a comprehensive audit uncovering tens of thousands of inaccurately reported traffic stops records between 2014 and 2021. These findings were deeply concerning, not just because of the sheer scale of reporting errors, but because they skewed racial profiling data in troubling ways. The inaccurate records disproportionately inflated traffic infractions for white drivers, while underreporting stops for Black and Latino motorists. If these discrepancies were simply random errors, we would not see such clear racial patterns. Even more troubling, the CTRP3 Advisory Board, where I serve on behalf of CWCSCO, was never notified by the Connecticut State Police about these inaccuracies. Had researchers been informed earlier, immediate steps could have been taken to protect the integrity of the data. Instead, it was left to independent investigators and the media to uncover the full extent of the problem. The bill does a couple of things. It makes the misreporting of law enforcement records a Class D felony, um, allowing for the revocation of police officer certifications, requiring timely notifications to the state's attorney when an officer is suspected of misconduct. Finally, amending the Freedom of Information Act to limit disclosure of unadjudicated complaints against officers. And I just wanted to highlight for just 1 second that the FOI amendment is a critical safeguard that upholds due process and protects officers from premature public judgment. The constitutional principle of innocent until proven guilty must be preserved. Thank you for your time.
Good timing. Questions or comments from the committee? Seeing none, thanks for being with us this afternoon. Eleanor Sterling?
Good afternoon, Chairman Winfield and Staffstrom, ranking members Fishbein and Kissel, honorable members of this committee. My name is Eleanor Sterling. I'm here testifying on behalf of the Connecticut Trial Lawyers Association, and I'm also a partner at the law firm of Koskoff in Bridgeport. I'm here to testify in support of Senate Bill 1437, the act concerning medical records, and in particular, the portion of that bill directed to 19A25G. That amendment provides a strong framework for resolving the problems that we have with the provision of medical records to patients and their representatives, those problems being expense and delay. Before I knew I was going to testify before this committee on this issue, last week, I was at a meeting in my law firm where we spent an hour talking about what are we going to do when we have medical requests that run over 60 days. And we were talking not about one, not about two, but over 20 requests in that position. The issue being that we have the potential, we need to send those records out to be reviewed by physicians. We may run up against limitations periods. We want to make sure that those physicians who are reviewing the records have plenty of time to review them. So that's the delay component, and I'm bringing that up. I know the members of the committee are familiar with that problem. I'm just giving that example to say that it's current. The other example, and I did pull from our records recently, I had a lot of potential choices, but just in the last 2 months, we had several bills over $2,000 related to medical records requests. And again, these are people who have suffered terrible injuries. I mean, you know, a young woman who almost bled out in the operating room, who wants to understand what happened. And so part of getting those medical records is trying to supply her with answers. So for all those reasons, we strongly support this bill. It provides a 20-day deadline. That would be a significant improvement, a $250 cap, and it maintains the 65 cents a day. If there's any questions, I'd be happy to take those.
Senator Kissel.
Thank you very much, Chairman Staffstrom. My first time for today. Attorney Sterling, thank you for coming to testify. I am very sympathetic to the plight that you guys are in. I can't imagine 10 cases, let alone 20. I don't know, I'm guessing you were here in the audience listening to the gentleman from, I believe, Atlanta, Georgia, sort of taking the position that, well, we need to have experts because we have HIPAA. We have to make sure that there's nothing provided in the copies that might get us in trouble and be a violation of person's privacy and may have a redounding negative effect on their mental health. He had all sorts of reasons why it's a cumbersome process. It's a time lengthy process, and a reason why he couldn't Representative O'Day's question, proffer a proposed cap that might be reasonable until he went back and consulted with a bunch of folks. How do you respond to his sort of like giant litany of reasons why they can't go down this road? Because it's my sort of understanding, we had the working group, we had a proposal last year, and I think this big group out there that sort of has a lot of this interest as far as dollars and manpower, people power, I guess. They seem to be the roadblock. And what's your response to their, you know, parade of evils that we have to overcome?
Yeah, I heard Mr. Probst's testimony from Datavant. So the response is, multiple layers. Number one, we've moved from paper to electronic, right? So I think in all of us who are familiar with just computers and simple copying mechanics understand the difference that makes. So that's number one. We're dealing with electronic systems. Number two is that these are systems that get provided between medical providers and to patients on shorter timelines. So the idea that they can't be provided to representatives doesn't make sense. Number three is that really these systems, as best we understand it, are very well automated. Number four is that the records that we get are full of duplications. And so we're not seeing a beautifully curated, complete medical record that gets produced. Most often what we see is an incomplete record that we have to follow up and request more information. So the product that we're seeing does not align with the description that Datavant is giving us of their process. I hope I've answered your question.
Yeah, you did, and you gave a lot of great examples. The proof is in the pudding. The product that you're receiving doesn't match the description that was proffered earlier, and I think it's dollars and cents really. And not only that though, but above and beyond the dollars and cents, this is time sensitive, and you're exactly right. When you're like watching the statute of limitations, or when you have made an agreement with an outside medical provider that are in and of itself is hard to come by, and you want to turn over this information quickly to get a review, was there medical malpractice? Was the extent of the damage that can be ascribed to that, if there was some? All these other ramifications in the court of law. This is something that I really hope we can get our arms around. I hope we don't have to lock everybody in a room and wait till there's white smoke coming out of the chimney. But I think that they say justice is delayed as justice is denied. The ability to obtain justice, if that is delayed, that is justice denied as well. Thank you, Mr. Chair.
Representative Fishbein.
Thank you, Mr. Chairman. Good afternoon. Nice to see you again. There's an area of this bill that I'd like to ask you about. Maybe you know the answer. Lines 56 through 59 exempts DEMIS from the requirements, and it talks about residential treatment facility units of Albert J. Slotkin Children's Center. Do you know why they are exempted from having to comply?
I don't know why. I can speculate a little bit. So 19A 25G was originally specifically about transfers between hospitals. It's a different statute than the statutes where the 65 cents provisions occur, which are 19A 490B and 20-7C. So but I'm not really answering your question is the truth, because I don't know where that historically comes from.
As written, one would think that looking at 19A 490, that they would be included, because otherwise there'd be no need to exclude them. So, but I just want to move forward from there. The other, because I agree with you on, you're paying for product that you don't know what it's going to look like when you actually get it, in your email, right? And we heard this morning about There could be a subjective analysis as to what gets redacted out. For instance, the example I give you is where the gentleman talked about information that the recipient may receive that as a result thereof, they may do harm to themselves.
Right.
That is a rainbow, right? Various people could think, so at the end of the day, the documents that you receive may have that redacted out. That may have been the stuff you were looking for. You didn't know they were going to do that, right? So, but you've already paid for it. So a way to deal with this, assuming that we can deal with the cap, is that you don't have the payment beforehand. You have the payment at the back end, which and maybe you write it up that it's some sort of lien against recovery, like an LOP, a letter of protection, right? And that way you're getting the records, you do your case and all of that stuff, and you pay for the stuff afterwards. That's a way to deal with this also. What would you think about that?
My reaction to that would be that it would streamline the timing. Because right now, one of the things that happens is we do, in some requests, we get a bill and then we have to pay it and then we get the records, right? So if we didn't have to do that transaction on the front end, then that would save us time, and time is one of the big issues here.
And
So-
also when you pay that bill, you don't really know when those records are coming to you either.
No, yeah, I mean, depending on the provider, you hope, but you don't know for
Through
sure. That's right.
experience.
That's
Yeah.
right.
I mean, when I used to do personal injury years ago, I had a case where I sent the client for an evaluation by their treater. They had experience with the individual, but then the treater disappeared, and I'm getting ready for trial. I need this stuff, right? And I had to go out and get a new evaluation. I'd already paid $850 for the first one, and I'm just trying to get records, right? So maybe if you didn't require payment by statute at the front end, cases are going to settle quicker. You're going to be more apt to get the stuff quicker because the check's going to get there quicker. So I just posit that at this point. So thank you, Mr. Chairman.
Thank you.
Further questions or comments? Representative Blumenthal?
Thank you, Mr. Chair, and thank you, Attorney Sterling, for being with us today. I just had a couple brief questions, which, as far as other members have stated, I don't think have been surfaced yet. When a lawyer or representative for a patient obtains the record on the patient's behalf, who pays for those records ultimately?
When a lawyer obtains the records, the patient ultimately pays for the records. And the reason why is because that's treated as a cost of the case.
And I think that's a very important point to note, because I think the whole point of the federal regulations around medical records, and particularly ones that govern the cost of medical records, was designed to give patients relatively inexpensive access to their medical records. And obviously, if they want to give it to somebody else or they want a representative to get them, that's their business. But ultimately, it's going to cost them, and it defeats the purpose of the regulations. And I had one more question, which was, have any of your members ever gotten discovery responses or answers in depositions or anything like that, indicating how much work it takes to actually produce an electronic medical record? And you don't need to answer that question if you're worried about betraying confidences or anything like that, but I was just curious.
We do take depositions on these issues, and typically the answer is you push a button and you access the record. Sometimes for very specific information, it's not part of that record, but the way these systems are designed, they're designed to efficiently produce the electronic medical record back.
So generally a couple minutes, is that roughly around the answer you've heard?
I'm not going to be more specific, Representative Blumenthal, but it's a simple process.
Fair enough. I appreciate your
summarize.
answers and your
Yeah.
testimony, and thank you, Mr. Chair.
Further questions or comments? further questions or comments? If not, thanks for being with us.
Thanks very much.
Brian Donahue?
Yes, hi, Chairs Winfield and Staffstrom and the members of the Judiciary Committee. I am Brian Donahue. In my off life, I run an organization or a group that connects all members in communities and leaders and organizations throughout the state of Connecticut. We advocate on behalf of individuals and students of families of color, LGBTQIA, disabilities, foster and adoptive, Native American, and lower socioeconomic incomes. What we do is we have virtual and in-person events. One thing that keeps coming up at these events is something that is the reason why I agreed to testify to House Bill 7132, the stopping of cars with dice in the drivers and the minor things such as wrong or false license plate. And there's other states and communities across the nation that have done this, and police have been able to focus on distracted driving, impaired driving, as opposed to something with the car. The fact that I am a white parent, I have 3 children. One is white, she drives. 2 are biracial and would be children of color. They are afraid of the police. We have to always acknowledge, and my brother was a police officer, and, is the fact that the histories that white families have, as well as black families. If people are afraid of the police if they get stopped for things that have nothing to do with crashes, impaired driving. We need to work together to make sure that all drivers are not impaired, not distracted, but we should not be pulling over people for minor. The license plate has expired or anything like that. We should be coming together and looking at the bigger issues, the bigger crimes, the bigger situations to keep people safe. And I thank you for your time.
Thank you. Appreciate you being with us today. Next up will be Daniel Boda. Turn the microphone on for me. There you go.
Good afternoon. Thank you. My name is Daniel Boda, and I'm a senior program associate at the Vera Institute of Justice. Vera is a national research and policy organization that has worked over 60 years to advance policies that promote public safety while reducing harm to communities. I'm here today in strong support of House Bill 7132, which would refocus traffic enforcement on true safety concerns while reducing unnecessary stops that do little to keep roads safe, waste police resources, and disproportionately harm drivers of color. Every year, police stop over 20 million drivers nationwide. A significant portion of these stops are for minor infractions like a broken taillight or expired registration, issues that rarely cause accidents or increase crime. Research from Connecticut itself shows that these stops do not make roads safer, yet they contribute to deep racial disparities and ineffectively prevent crime. Furthermore, studies across multiple states have also found that minor traffic stops rarely lead to recovering weapons or solving serious crimes. Critics of this bill argue that eliminating non-safety related stops will make it harder for law enforcement to prevent crime, but the data tells a different story. Studies from Tennessee, California, and North Carolina show that when police make minor traffic stops, they rarely recover weapons or solve serious crimes. So in California's 8 largest police departments, for example, firearms were confiscated in only half of 1% of all stops. Additionally, reducing unnecessary stops actually improves public safety by freeing up police to focus on dangerous driving behaviors and serious criminal activity. Connecticut's own data shows that minor equipment violations are not major contributors to crashes. Defective lighting, for example, and that's all types of defective lighting, accounted for 9.4% of all Connecticut traffic stops, but only 0.1% of accidents where it was even a contributing factor from 2015 to 2019. This bill does not prevent police from stopping drivers for dangerous behaviors, nor does it interfere with law enforcement's ability to investigate crime when they have reasonable suspicion. What it does do is ensure that traffic enforcement remains focused on keeping roads safe rather than serving as an unnecessary source of harm and racial disparity. Lastly, this is a widely popular reform among constituents. Nearly 70% of voters across party lines support policies like HB 7132 because they want police to focus on serious crime and dangerous driving, not minor infractions. Connecticut has the opportunity to become a national leader in modernizing traffic enforcement by ensuring police focus their time on dangerous driving behaviors that actually save lives. I urge you to pass HB 7132. Thank you for your time. I'm happy to answer questions, and I would refer you to my submitted written testimony as well.
Thank you. Representative Howard.
Thank you, sir. Thank you for being here. Just to your data about traffic crashes.
Yes.
You grabbing that from DOT, from the PR1s?
I'm sorry?
Are you grabbing that data from the PR1s from DOT?
That data comes from DOT data through reporting by the Racial Profiling Prevention Project. So that's Connecticut-specific data, and it's data about, so when there's a crash, the DOT collects that data about contributing factors, which is reported by responders to the crash, right?
Correct.
And they list all of the factors that have contributed.
All of them?
Yes. There are numerous factors that can be considered contributing to a crash. So if somebody is intoxicated and they're also driving too fast and the roads are wet, those might all be contributing factors in the crash. And so those factors are all collated, and the frequency of those factors in the data is what I was referring to.
So I think you're right. In an ideal world, that would happen. But I will say this to you. If police officers are investigating a crash at so we'll talk about this bill in 1 second. And I think you may have been here earlier when I was talking to somebody else about the headlights.
Yes.
If I'm pulling out of a private drive and I look to my left, I don't see a vehicle because perhaps they're coming from my left and their left driver's side lamp is out, and I don't see them, and I pull in front of them, I would wager to you that the police officers in this state overwhelmingly will put the contributing cause of the accident as my failure to grant right of way and nothing more. Because first off, they would have to somehow know that headlight was out before the crash, which they could know if they did a recon, which they don't for minor crashes or non-fatal ones. And the perception of me as I pulled out in front of them was I never saw them, right? But there's no way to know that headlamp was out. My point is, I don't think the data is accurate because I think police officers are putting the main cause because we've made that action report a 12-page document and give them a million other things to do. So would you agree with me or disagree with me?
I would disagree with you that the data is inaccurate. I think that the data may be not always filled out completely correctly. Certainly that's a problem with any kind of data. I do think, though, that the more important point really is that, we all have instincts, especially those of us who drive, right, about what's dangerous or not on the road. And, at Vera, we're a research institute. First, that was our, sort of founding function. And rather than sort of decide what is a safety factor for driving, we take a data-informed approach. So we look to data about things that cause crashes to decide what kinds of things are safety related or not. So when we show up to speak about these kinds of policies with police chiefs around the country or to legislatures around the country, we do so from a perspective of trying to provide information that's based on, the best data that we have to understand what are the dangers on the road. So we know the kinds of infractions and the kinds of behavior and factors that contribute to large quantities of traffic deaths. And we know that we're experiencing we're coming off of a peak, sort of a historic peak of traffic fatalities in this country, countrywide as well as in Connecticut. And we know that there are 5 main contributing factors to that. There's a whole huge field of people who work on traffic safety, and there's uniform agreement that, you know, that's distracted driving, that's excessive speeding, that's intoxicated driving. Those are, you know, reckless driving, failure to wear a seatbelt. A lot of people die who wouldn't have otherwise died because of that. So these are factors. We don't think those cause crashes as much as they cause fatalities in crashes. But, you know, we don't advocate for policies that would remove those as infractions or that would remove police from focusing on those. In fact, we think under a bill like this, this is a situation where the result of a bill like this should be that there can be more traffic stops, that those traffic stops can be for the kinds of behaviors that we know contribute to death every day on the road.
So I would agree with you that more traffic stops would lead to less crashes, less fatalities. I think we're in agreement about that.
It depends on the kinds of stops, yes.
Okay. So I asked the previous person, and you work in this field, right? So that's why I'm asking folks who do this every day. I'm not trying to engage with every single person. Have you had a police officer ever tell you, I'd like to go deal with the distracted driving. I'd like to go deal with the drunk driver. I'd like to go deal with the speeding, but I'm so bogged down without plate lights and out headlights, I just don't have time.
I haven't had a lot of conversations with police officers about traffic, like what traffic enforcement is a distraction to them or not. I have had officers tell me that they know that these kind of stops are bogus. I've had a police officer who I'm acquainted with tell me that that she was a supervisor and she talked about how she had certain officers who would focus in on administrative violations, things like an expired registration, to get their numbers, to get really good numbers and look good. And she was very upset about that because she saw that a lot of officers would get rewarded on the job for behavior that she didn't think was really advancing any benefit to the community.
I would agree with her. Hopefully as a supervisor, she took action. But jumping to the bill now, you know, the representation has, and you've made it, you know, and we just talked about, the representation continues to be made that we're helping police officers by stopping them from having to stop these trivial violations, and then they can do more important things. And I just don't have a police officers telling me that. I just don't. But jumping to the other representation that continues to be made is that we're identifying stops that we don't want people pulled over for. But that's not what the bill does, right?
So there are two things to say in response to that, if that's okay.
Yeah, please.
Yeah, so first off, last session, there was a bill before the legislature.
Familiar with it.
That this is a modified version of, and that bill would have set up a secondary enforcement system.
Mhm.
And law enforcement were concerned about how it might be difficult to administer and understand, that it would be confusing to have a system. That was the feedback that I heard. I know a lot of other people who were interested in the bill heard this as well. And so the bill was redrafted, and that was in response to concerns raised on the committee, concerns raised as well by law enforcement, saying if you don't think that police should be making stops for these things, then why don't you amend the law so that these things are not infractions anymore? And so there was a lot of careful, thoughtful work to sort of very precisely amend the law in a way that would accommodate those concerns and, you know, give voice to them, at the same time continuing to address the underlying issue of trying to improve traffic safety and trying to improve the kinds of outcomes that drivers experience.
So back to my original question, and thank you, that I would agree with the historical information as to how we got here. I was involved in much of it, and I would agree. But so we've moved away from that. Now we're actually changing the law, right?
This bill would redefine certain infractions, yes.
So I have a vehicle, right,
Mhm.
that I drive here, and it has two headlamps. And if this bill passes and one of the bulbs goes out and I'm driving, am I in violation of any laws?
Does your vehicle still have two headlights?
Well, there's two housings.
Right, it still
But
has.
one of them, but the bulb burned out. So I'm
The-
driving with essentially one lighted headlamp. Am I in violation of law if this bill passes?
If this bill passes, you would not be in violation of the law because your car would still be equipped with 2 headlights. So there's a provision in Connecticut, the Connecticut code that requires that you have 2 headlights on the car. And that would still be a requirement under this law. If one of them was not illuminated, one of them had burnt out, you would not be committing an infraction of that code. If you only had 1 headlight housing, if you had a vehicle that had been modified to only have a single headlight on it and was not a motorcycle, then that would be an infraction still. Yes.
Correct. So we're talking about 1 burnt out bulb as
That's right,
opposed to
1
2.
burned
So
out
if
bulb.
I'm driving, so if I, again, back to my scenario, I have 2 housings, 1 bulb burned out, this bill passes, I'm not in violation of law. Why would I be incentivized to even replace that bulb?
Well, I would assume that you would want to maintain your car. I know that, I drive and I've been having trouble with headlights burning out on my car recently. I don't know why. I've gone to the shop multiple times over the last 6 months. I've never been pulled over for it, but I still go and get it fixed. And it's not really because I'm afraid of being pulled over for it. It's because I want to have that light when I'm driving at night.
Why?
It's easier for me to see. It's easier for people to see me.
Mhm.
I see a lot of cars when I'm driving that have a headlight out.
Yeah.
It's very common.
Yeah.
Especially since I started working on this issue, I've started to notice it everywhere. And pretty much every day I see multiple cars with a headlight burned out.
Okay. Yeah,
I've never
I just
been
wanted,
in a crash with any of them.
as somebody who clearly has worked on this bill, I just wanted to get your take on that and make sure that we're understanding each other appropriately, that we're actually changing the law and telling people driving in Connecticut, you don't have to have 2 working headlights by law if this passes. That would be an accurate statement?
Yes,
Okay.
the accurate statement would be that you are not committing an infraction if one of your headlights is burned out.
Right, but your position is if the housing is there, you're still in compliance with, you still technically have 2 headlights.
That would be what the law would say, yes.
Right. And if I had two flashlights in the dark and neither one of them had batteries in them, I'm still in the dark, right? I mean, if a headlight that's not illuminated is useless, isn't it?
I believe so, yes.
Okay,
Yeah.
thank you. Thank you, Mr. Chairman.
Senator Chicarelli.
Thank you. I just have a couple of quick questions. I think it was already clear that we said this does not stop an officer from pulling someone over. It just doesn't make it illegal. Specifically, we'll talk about the headlights first. Is that correct?
Yes, there are about 700 different reasons you can be pulled over in Connecticut in a vehicle. So there's, just numerous violations. And there are about 6 different types of infraction that would be affected by this bill.
Got it. But yeah, we'll put aside the reasons why someone could be pulled over or an infraction. This is just simply just saying there'd be no penalty at all. And you could essentially drive around with 1 headlight and you could do it for as long as you'd like.
I'm not
No.
certain that that's the case. I think that you would probably need to have the headlight repaired to pass inspection. I'm not familiar with the nuances of Connecticut inspection law, but generally there's, a stop every year or so for inspection when any kind of equipment defect like that would have to be repaired.
Okay. I'm not aware of that. Putting that aside, if there was an inspection or you go in for service and you're made aware it's not working, you could have that opportunity. But if you just chose not to fix it, everything's expensive these days. Say, listen, I'll get it next time. Technically, they could do that, and they could, take the same route every single day, drive by an officer who's just sitting at a post, and that person's going to go by, and they're never going to be able to be not only pulled over, put that aside, but it isn't at all against any laws, any regulations. That's what this is doing now. I think we kind of clarified that before. I just want to make sure I'm asking my next question. We're on the same page.
Yes, they wouldn't be committing an infraction under this legislation.
Got it. And again, people that don't want to pay for a few dollar light bulb probably aren't doing it because they don't want to. It's probably because they can't afford it. And I understand that. And I totally get that. But some of the concerns that I have with that is, I don't know if anybody's ever done this. You have the automatic on your light, so it goes on automatically. If your knee hits it, it goes off. And sometimes I'm driving, I'm like, oh my goodness, I drove for like 5 minutes, my lights weren't even on. I turn them on. If I didn't, no one told me my light was out, I would never know, right? And that's kind of the challenge and why I think it's somewhat relevant that they, fix it. And why they fix it is, I think you may have said earlier in your testimony, 10% of the accidents are due to a lack of lighting. Was it? Did I hear you say that?
No. No, all lighting violations of any kind. So any defect in lighting, whether that be a blinker, a tail light, a running light, a headlight, all of that is lumped together in the data. So all lighting defects in the aggregate account for 0.1%. So a tenth of 1% of as a contributing factor to accidents.
So are you speaking lighting that's fixed to the vehicle or ambient light and light, like foot candles coming off of a street light? Because when
Lighting
we would-
effects to the vehicle.
just to the vehicle.
Yeah,
But-
vehicle lights that are defective. Yeah.
Sure. So my concern isn't that, and I know that like a broken blinker, it may, cause someone to get rear-ended or something along those lines. But it provides light on the road. And I think there's a fair amount of accidents due to a lack of general lighting, not just the ones that are fixed to the vehicle. That's why sometimes there'll be some accidents in an area, they'll put up stop signs, or maybe they'll put up more lighting or street lights. Because, even if there's slip and falls, people are in an area, they get hurt. An attorney might say, oh, there wasn't adequate lighting. It was contributing to the accident.
Yeah, I think I'm sorry. Yeah,
Go ahead.
the DOT, I believe, collects that data separately, as
Yeah.
a separate category, yeah.
And I think it is a cause of accidents and driving. Specifically, driving home, I think it was Thursday, it was pouring. I'm sorry, not there, Tuesday. It was pouring. And driving home, and I'm going down back roads with not a lot of light. And with my headlights on, it was hard to see someone. Now, if someone's driving down the road and you see one light, you may think it's a motorcycle, and I know it's crazy to drive a motorcycle in the rain, but people do it. And you get closer, you think it's a motorcycle, you go down a tight road. It was a specific one, right off of my street, and it's a dark, windy road. I could see where that would definitely cause an accident. And I just don't want there to be a negative repercussion from this. I understand the intention that the officers really shouldn't waste time, really shouldn't give a ticket to someone for something like that, because simply it's they have other things to do, right? But we just want to make sure that people will take that corrective action. And if there's no momentum to do that, they may not. And I just hope something like this doesn't contribute to more accidents. When there is a car accident and you get into litigation and attorneys hire investigators to look into what may have caused the accident, maybe there's a dispute, who went over the line, who didn't, if you're violating a law, technically you're going to be held at fault. So someone could make an argument, well, my person wasn't at fault. They don't have to change. They just need one working light. He's not at fault. There's a lot of other factors that come into play. And I was just curious, in your work, if you take that into consideration when thinking that this, may be the right move. With those comments, do you have any comments to that?
I mean, we do think a lot about traffic safety. We speak with, I speak on a regular basis, at least weekly, with traffic safety experts. They are in agreement that these kinds of infractions are not priorities for enforcement, and that that enforcing them takes away attention and time and resources from the enforcement of infractions that we have abundant evidence cause serious injury and death on a regular basis.
So can you repeat that again? What causes the serious injury and death? Being pulled over?
No, what causes serious injury and death is high rates of speeding, driving while intoxicated, reckless driving, and distracted driving, driving, with a cell phone, something
Sure.
like that. Those are, the major factors involved in traffic crashes that result in injury and death.
Okay.
And so those are the key focus of traffic safety efforts. If a police officer pulls somebody over for a headlight that's out, it's what you say is true. It's possible that that car could be involved in an accident because of that headlight being out. We know from the data that that's extremely unlikely for that headlight to contribute in any way to a crash. We just know that from the data.
What data? I'm sorry. What data?
I'm sorry, that's the Department of Transportation safety data about the factors that contribute to crashes.
Okay.
And so when there's a crash, the contributing factors are collected, and it's 0.1% of crashes where any kind of lighting defect of any type on the vehicle is a contributing factor.
Wow, I got to check that data out.
So it's very rare.
Yeah, I got to really look at that data because that's something that's really interesting. I'll definitely take a look at it. And data is interesting sometimes because if the main reason was maybe it's a little slippery, so they mark it as weather conditions, but the person that was driving a little too close maybe, and that may be another reason. But the person didn't have any taillights, they didn't see it, they hit them. I'm sure that would, could be a second reason or a third reason which contributes. So it's just interesting how data is collected. It fascinates me really how it's collected and how it could be, sometimes misinterpreted. But anyway, I appreciate you answering the questions on that.
Sorry, don't you wrap it up?
Almost. Just one more, and I'll be really quick. I apologize. The rear illumination for the license plate. What is the intended purpose for that?
So the most cars are equipped with a. I'm sorry. Are you asking me why license plates are illuminated?
Them doing, yeah.
Most cars are equipped with a light that shines on the license plate. It makes the license plate easier to view. The license plate can still be seen when that light is not illuminated. It might be a little harder.
Got it.
Yeah.
And the reason why I'm asking that, and I won't go through the back and forth of saying when would somebody have the opportunity to fix it if they weren't aware of it. But just some of the concerns that I have, and again, maybe just coming from like my day job, not doing this every single day, there may be an incident, there's a hit and run, there's something that happens, and we got to look at a Ring doorbell to see the license plate. And again, it's just those small unattended consequences that I get concerned about when we see legislation like that. It's put on there for a purpose. Do I think somebody should be ticketed for that? No. Should they be aware if it's not there? Yes. And when you have the opportunity, you can afford it, fix it. But people just will turn them off. They'll take them off. And the individuals that may do that may be doing it for a reason. We just had Chief Jacobson in a public safety meeting talking about street takeovers, and they intentionally modify the car so you can't see the plate, or they'll switch plates. They'll put them in the rear view of the car, and then they'll put other one in there. And the chief was saying how common that happens. So those are just the concerns that I have, and I'm just curious if they were taken into consideration when writing, when coming here to support the legislation before you.
Yeah, we certainly think about those things a lot. Yeah, and the ability to identify the vehicle, especially with like switching license plates and things like that. There's a reason that that's not included in bills like this generally.
Well, it kind of is because it's allowing them to now keep it in the rear view of the car in one of the sections in the mirror. And I know that is good. And I know people are stealing license plates. People are doing bad things. So they want to keep it safe and protect it. And I get that. But it just makes it a little easier for individuals that Chief Jacobson was referencing to switch those plates quickly if they were doing something wrong. So I understand your intentions for doing this are different than the concerns I have. I just hope that we take that into consideration when deciding how to move this forward. I really do appreciate you taking the time. I'll take a look at those statistics. And again, just thank you very much.
Thank you.
Thank you. Further questions or comments? Seeing none, appreciate being with us.
Mr. Chair.
Thank you very much.
Sorry, Representative Callahan.
Thank you, Mr. Chair. I'll be brief. Sir, thank you for coming in. Did you drive here today?
I did, yes.
Before you got in your car, did you walk around and make sure your lights were working?
I did not turn the car on and check to make sure all my lights were working now.
So then how would you know if you're driving at night or at any time, if your brake lights or headlights are working, if a police officer didn't stop you and say, just letting you know, for safety, you should have all your working lights. It's happened to me twice. And I said, I had no idea. I'll get them fixed. Thank you. And you don't want that to happen?
I have no objection to people being notified or informed that they have a defective light. I think the point here is to reduce what can be very harmful interactions when they're not necessary. I have had my brake lights not work. One of my brake lights was not functioning for a while, and I had in one night 3 or 4 different drivers pull up beside me and mention it to me, to the point where when the last one happened, I said, "Yeah, thank you. I already know."
But then
and
again,
I-
if you're on the highway, it'd be tough for someone to pull up next to you at 65 miles an hour to say, "Hey, you're." I think back to planes, trains, and automobiles. Someone's screaming the other way, but it'd be difficult to do that. So if it's a highway driver and they're driving, 300 miles that night, there's certainly not the opportunity for someone to pull up and do that. It's a safety issue, and I just think that you're a couple premises here. You're saying that police officers should be doing other things. I don't think police officers are in the midst of telling someone that they should get their lights fixed and saying, "Gosh, I'd really rather be out there doing DWIs." They're doing both, and as many people have mentioned before, they are. It may be not written as a reason for an accident, but that doesn't mean it could have been recorded improperly. So, I thank the officers in the 2 times that I've been pulled over for that, and they were pleasant. Most police officers are. There's bad apples in every profession that we have in this country, but for the majority, they're all very good people who just want us safe on the roads. And I think this an initiative like this is a bad initiative. It makes us less safe on the roads. Not to mention, smoke billowing out of cars. But I think this is a bad idea. I think you have good intentions, sir. But I certainly, at this point, I've heard nothing to help me support the bill. So I appreciate you coming in.
Thank you. Comment or question from any other members of the committee? Representative Lamarck Muir.
Thank you, Mr. Chairman. Hi, thank you for your testimony. I appreciate it. In Vera's research, do you have any research to suggest that there's racial disparity in terms of cars being pulled over for violations such as this, infractions, violations?
Yes, there's extensive research about that.
And what does it show?
It shows that there are far greater racial disparities in non-safety related infraction enforcement than in safety related. And our interpretation of that data, and this is an interpretation that many academics are led to when they look into this, is that when there's less discretion for an officer about pulling someone over, so if they see somebody speeding or driving really crazy or showing obvious signs of intoxication, they're going to make that stop if they can. But if they see a blinker out or a headlight out, they really, they may not enforce that depending on their priorities at the time. So in those high discretion types of stops, racial disparities frequently, and the numbers vary from place to place around the country, and we don't have great data for everywhere, but we see them every single place that we've looked, right? So we're talking like the whole state of California, every jurisdiction in the state of California. We're talking North Carolina, Connecticut. And what we see is that generally, Black Americans who are driving are pulled over at about twice the rate of white Americans. And that is even when you control for driving behavior. So it's not that Black Americans drive more recklessly or violate the law more often, but there is a disparity in those stops. And we see that disparity can leap threefold, fourfold when you separate out and look differently at administrative violations like expired paperwork and equipment violations as opposed to moving violations. So the disparities are often concentrated very heavily in equipment violations and in administrative violations. And so that's an indication that when there is a high discretion enforcement environment, that officers are pulling over Black drivers at a far greater rate.
And did the research did you look at the research and see whether or not, because there's that disproportionate action, with the black drivers, do those stops for for violations or infractions, do they escalate more frequently than they do for white drivers? In other words, do the white drivers just say, yeah, I'll get that fixed? And with minority drivers, it escalates to a greater degree of action by the police officer?
Yes, absolutely. The evidence is really, really clear that the disparities increase at every phase of intervention. And so when stopped, so black drivers are more likely to be stopped, all things being equal.
Mhm.
And then when stopped, they are more likely, far more likely to be searched or to have to be asked for consent to search. They are less likely to be found with contraband, which is a clear indication that there's a lower threshold for suspicion to search them, being in practice, not legally. Legally, it's the same threshold, but in practice, they're searched more on a lower threshold of suspicion, and are less likely to have anything. And then when force is used against a driver, and this is not a very common occurrence, right? That force is used in a traffic stop, but when it is, it's highly disproportionate by race.
And my last question, and it might not even be fair because I know you're not a police officer, but in your reading of this bill, do you see anything in here that prevents a police officer from exercising her care function?
No, absolutely not. There's nothing in this bill that would stop a police officer from intervening if there's signs of somebody in danger, some threat to life
Or just
safety.
notification, hey, your headlights are out?
Yeah, and some places have actually used license plate readers, or even officers when they type in the plate number, if they see, an expired registration, or if it was a light that was out, they can, from their digital terminal in their vehicle, they can send a letter, a notice letter to the person.
But even if they didn't want to go through that, there's nothing to say, stopping someone and say, hey, did you know your headlights out? And this bill doesn't talk about taillights, right? It talks about headlights.
I don't know off the top of my head.
Okay, that's not a fair
There's a
question.
number
That's
of lighting infractions,
thank you
and
for
I'm
your
not
time.
sure which are covered.
Yeah, thank you for your time.
Thank you.
Thank you both. Further questions or comments from the committee? Further questions or comments? Rep. Fishbein?
Thank you, Mr. Chairman. Sir, I'm just trying to figure out, there's representations made that more minorities are pulled over for, we'll say, the one headlight situation. That's the data that you've seen. Of those matters, how many does the data show that the officer was incorrect?
I'm sorry, I don't understand what you
Well,
mean.
the
Incorrect
represent-
about what?
Sure, the representation is being made that merely because somebody has a certain hue to their skin that they're pulled over, right? That's the representation.
I don't know if the representation is not that the cause of them being pulled over is the hue of their skin.
Okay, well,
There is some evidence that suggests that is factor.
okay, and I'm just trying to drill down on that because certainly I don't want somebody pulling over someone if, the officer, like we had a case we talked about the other day where the officer lied, right? You probably don't know about that, but I'm just trying to figure out, is it that more minorities have one headlight, or that police officers are making up that? What gives rise to, because, if a car is driving down the street and somebody is black, let's say, the officer, and they have one headlight, the officer has a choice, pull them over or don't. And the representation is being made to this committee that based upon the person being black as opposed to white, we'll just say, that officers are taking the opportunity to pull those particular individuals over.
I'm sorry, I was not trying to speak to it from, I think you're coming at it from a different direction than I am. What I'm trying to represent to the committee is that when officers have the discretion to pull somebody over for a headlight being out or not, that it's about twice as common for the person they pull over to be black as to be white.
Okay, but there's a lot of variables in there, right?
What's in the heart and mind of that officer is something that is very difficult for state legislation to reach. and has to be, adjudicated in an individual case. I represent an organization that thinks a lot about policy and broad policies that impact lots of people's lived experience and lives. We know that Black people are far more likely to be the recipients of those kinds of stops. And that has a number of harms that are attendant with it.
Sure, any decision that's made based upon somebody's race, when there's discretion, is in my mind inappropriate, right? But we're talking about public policy here. So I'm just trying to get, we've heard a lot about that if we did these things, we passed this legislation, that it would cut down on racial disparity in traffic stops. And I'm just trying to figure out, there's a lot of components to the representations that have been made here today. So I've looked at a lot of data. There's holes in data. For instance, about the contribution of light to accidents themselves. I mean, when you say that one headlight being out is a fractional portion of all motor vehicle accidents. And I think you even took it a step further and you said a substantial factor in creating that accident, right? I can understand there are very few, well, I wouldn't say very few headlights that are out, but I'm just trying to unpack the stats here. So, but I thank you, sir, for coming here today.
Further questions or comments? Appreciate being with us.
Thank you very much.
Kimbrough?
Good afternoon, Representative Staffstrom, Senator Winfield, Senator Kissel, nice to see you, Representative Fishbein, distinguished members of the committee. I'm here on behalf of the Connecticut Racial Profiling Prohibition Project in strong support of Senate Bill 1436, an act concerning police data reporting requirements. The Connecticut Racial Profiling Prohibition Project Advisory Board is about 20 members, from law enforcement to community representatives to state agency heads and other important stakeholders. The board has unanimously endorsed Senate Bill 1436. The bill would make intentional falsification, intentionally entering false information into a law enforcement record a Class D felony. We firmly believe that the intentional falsification of police records, especially those required under the Alvin W. Penn Act, must be prohibited. Such misconduct demands thorough investigation and a review for decertification. Additionally, ensuring the timely notification to the appropriate state's attorney is essential for accountability. At the same time, we as a body acknowledge that the expanded data collection efforts and requirements over the last several years may occasionally lead to unintentional mistakes or misreporting. The bill does not, nor should it, penalize honest errors that may occur from time to time. This bill will further strengthen public confidence in the integrity of the data collection that we're responsible for, and we remain committed to continual improvements to enhance our program. In addition to SB 1436, there have been a number of technical questions related to House Bill 7132, and if I could try to add any clarity based on the information I've gleaned, I'm happy to. Thank you. Thank you.
Thank you. Questions, Rep. Fishman?
Thank you, Mr. Chairman. I'm glad that you're here on 7132. So
I'm happy to speak to it
that's
if
what we're
I
going to
can.
talk about.
Before you ask, I just want to be very clear. The Racial Profiling Prohibition Project Advisory Board has taken no position on 7132. I will try to provide context based on my own personal experience if I can.
Can you tell us why there's no position? It seems like an area that the group was in favor of previously.
The board has never historically taken a position on this bill, or even the last 2 years, a similar version of the bill. We're a group, we have a diverse group of stakeholders, and we operate on consensus, which means all of our stakeholders have to agree before we endorse a piece of legislation. So we're very limited as a body when we do endorse legislation.
Okay, no, I appreciate that. Well, can I go through the sections and ask? Well, let me ask it this way. Did the body address each of the sections or address the legislation in its entirety? I take it that there was a vote. It wasn't unanimous, so therefore we end up where we are.
The body has reviewed all the sections of the bill before us, and I think as you'll hear later from the Chiefs Association, for example, who are on our body, they have a different position than maybe some of the advocacy groups, but we have reviewed the sections and certainly have had dialogue around the different sections, and I'm familiar with them as well.
Okay, section 6.
Yes.
Which has to do with extending the period of time
Failure to
on
renew.
the suspension.
Failure to new registration.
Yeah, from
Yes.
30 days to 60 days.
Yes.
Why, public policy wise, does that make sense?
This was generally a provision that was, I think, in the bill the last 2 years. During COVID, the rules around registering your vehicle got expanded because of COVID and the availability of DMV offices. It appeared to be an appropriate practice to maybe give people a little more time. Right now, currently under statute, if you're operating where your registration has expired within 30 days, that's failure to renew. Over 30 days, you're now operating an unregistered vehicle. That means the vehicle can and will be towed. What this bill does is it expands the failure to renew period, which would still be an infraction. You could still be stopped from 30 days to 60 days, but your car couldn't be towed unless the registration was over 60 days expired instead of over 30 days.
I thought that if the owner of the vehicle previously, okay, so it would still be an infraction.
Correct.
Even though it's not registered, but could not be towed until 60 days. Okay, I got that. In section 1, which has various subs, we're having to do with license plates.
Yes.
And in particular, well, withdrawn. Let's start at the end of that section, okay? And I'm gonna read the change in lines 52 to 55.
Sure.
Because it doesn't appear to make sense to me.
Okay.
It says substantially obscured means that the number plate is not significantly blocked or concealed by an obstacle or obstruction to an extent that allows for a reasonable person to read the numbers and letters of such plate. I would think that what you're looking for is the obstruction prohibits a person to read the plate.
I can explain, I think, the thinking, because I also worked for the Police Transparency Task Force that started these conversations, so I can explain their thinking. And then certainly if language needs to be clarified, I'll leave that to the authors of the bill. Today, if you have a vehicle, and I think I've used this example before, and you have something around your plate that say advertises the college you went to, and part of the word Connecticut is blocked, or part of the phrase Constitution State is blocked, the plate is not entirely unobstructed. The current statute says the plate must be entirely unobstructed. We have seen a few thousand people every year in Connecticut stopped because the plate is partially obstructed. Now, I think as we discussed with law enforcement a number of years ago, the intent of that statute was to ensure that people didn't put a plate cover over the plate, a tint cover, so that the plate couldn't be easily read, didn't cover the plate with a piece of paper, as an example, right? We've seen in New York, for example, some people have tried to cover their plate when driving through red light cameras. So this is not removing the obstruction of plate statute from the statute. The goal of this section is to try to clarify to officers to say, look, the plate has to be substantially unobstructed, or sorry, substantially obstructed in order for you to pull them over. If you can read the letters and the numbers on the plate, then don't pull them over. If the letters and numbers on the plate are obstructed, so what they're attempting to do, and this may need clarification, is they're then attempting to define what is substantial, right? So the change in the statute is to remove the word entirely obstructed, replace it with substantially obstructed, and then they needed to attempt to define, well, what is a substantial obstruction?
Well, and I guess the problem with substantial, if you have one letter that is blocked on the plate, yet you have 6 other letters, is the block substantial?
I would argue that this bill still leaves that to the discretion of law enforcement. But the bill also requires that a reasonable person must read the numerals and letters of such plate. So again, if we're talking about the letter C from Connecticut being blocked, I think a reasonable person would say that's not substantial. If we're talking about a C in my actual registration, right, my license, that is substantial because I can no longer ascertain who the owner of this vehicle is.
And I think we're having the exchange, I was having the same thought process, because I think the term that should be utilized is registration numbers and letters.
Yes, and I think last year, that's not in this version, they had inserted the word registration, numeral, and letters. And I think that that would provide for the clarification, which is that those registration numbers need to remain visible, unblocked to a police officer. But if part of the word Constitution state is blocked, that's really not important to the function of what law enforcement need to do.
Well, we'll get there in a moment. But just coming back to where I started with this, I think it English-wise lays better.
Mhm.
Because the intent of 52 through 55 is you're defining substantially obscured. You're dealing with something on the plate that prohibits the plate from being read, right?
Yes.
What this says is that to an extent that allows for a reasonable person to read. So it should say prohibits a reasonable person to read. You would agree? I mean, that seems to make English sense to me.
I think I would agree. It seems to make sense to me based on your, again, that's why I tried to articulate what was the intent. And if there's a way to clarify the language to ensure that the intent, which is, look, somebody driving around with that frame around their plate, it's probably just not that important to pull them over. And I think your language still gets to the intent of why they're trying to clarify this language.
Yeah, because you're sort of dealing with a double negative
Yes.
as drafted.
Mhm.
Now, why is it not? So I don't know that there's any police training as far as colors of plates for all 50 states.
Correct.
So why is it appropriate for one to, let's say, totally block out what state it is on the license plate and just going by the color? Because that would be lawful,
Yep.
right?
Yeah, so I think 90%, according to the 2024 data, 90% of drivers stopped in Connecticut are Connecticut residents. So we're talking about 10% of drivers who live outside of the state. The vast majority of those drivers being stopped have plates typically from bordering states, which I think our law enforcement officers are generally know what they look like, right? Because we see them more frequently. And so we're talking about really there has been, and maybe the chief can talk about this later, there's been this sort of strange uptick in cars in Connecticut being registered in Texas, and that's maybe another problem we have to deal with. So we're seeing more Texas plates on the road than we typically may have seen in the past. But I think the number of sort of out-of-state plates, right, that police are engaging with outside of the immediate surrounding area of Connecticut is very limited.
Okay, so I still haven't heard
Yep.
the answer. So we don't want to preclude law enforcement from doing their job, right?
Mhm.
So a car just left a jewelry heist. The license plate is, I don't know, white and blue, and but they've blocked out the state. why would we preclude a police officer from being able to ascertain what state it was?
Understand the scenario. With all due respect, I think in that scenario, the police officer could make an investigative stop, and because the right, it's a robbery and the car fits the description. I also would just, my response, I understand your point. I think we may disagree a little bit. My response would be that there are 700 legal reasons to stop a car in the state of Connecticut, and it is virtually impossible for police officer, for an individual not to be violating multiple uh, uh, of those statutes at any given time. And if a police officer is, say, looking for a pretext to stop a vehicle because they may suspect them to have been involved in a crime, it wouldn't be very hard for them to find another statute to stop them for.
Would you be more comfortable? I mean, I agree, Constitution state
Mhm.
has nothing to do, you
Yeah.
know, but I think having the state unobscured, is that right?
The name of the state is what you're.
Yeah, not blocked is appropriate, but I'll go on.
Yeah, I think I understand your point. I don't have a position on that personally.
Understood. In line 17,
Mhm.
we are once again talking about plates. So if we read the clause, this deals with the rear window.
Yes.
So you can take the plate and put it in the rear window, provided the numbers and letters on any such number plate are plainly legible. So what's the intent? What's the difference between legible and plainly legible? Because it's undefined in here.
Yeah, that's language that was put together, I think, by LCO, so I'm not sure. Again, I can just tell you the intent of that language, that's similar language has been added in previous years. There were members of the Police Transparency and Accountability Task Force representing more urban communities. There was a feeling that oftentimes some people in some of these communities, there's a culture to occasionally place the plate in the rear window because they're trying to prevent the plates from being stolen. And so this language was part of a discussion around, look, if somebody doesn't have a tinted rear window, they're still trying to clearly, let police officers know the car is registered and here's the plate, but they're trying to prevent, say, the plate from being stolen. They occasionally put it in the rear window and wanting to allow for that, assuming, again, what's the goal? The police officer still has to be capable of reading the plate.
Okay, I mean, I think a plate in the back window is a problem on many planes when you're dealing with just plate in the back window, because there could be tint in the back window, right?
That would make it, under my estimation, if the window was tinted and the plate was no longer, say, I don't know, legally plainly legible or legible, the police officer would still have a legal right to stop you. Under my understanding of what the intent of this is.
Okay, but we're playing with discretion, we're denigrating discretion at one point, this whole aspect of legible at what distance? Legible given, I mean, a tinted window in the middle of the daylight may make that license plate legible from a certain distance. In the middle of the night, probably not even going to show that there's a plate there at all. So, I don't know. I mean, I understand where you want to be. I'm just having a lot of problems with how this is drafted. So thank you, Mr. Chairman.
Thank you.
Further questions or comments from Mr. Brown? Representative Howard?
Thank you, Mr. Chairman. Hi, Ken. So can we jump back to 1436, the bill you came here on first, and then we can go back if it's all right? Thank you for coming. So you said, and I would agree, in section 1, you sort of made a high bar, right? Like, in other words, it says, it has to be intentional with intent to mislead. You've taken out, and I think, I don't want to say, misquote you, but you said something to the effect of, look, it's data entry, mistakes happen. That's not the goal here. The goal is, in the impetus says was the few that were intentionally doing it with the intent to mislead,
Yeah,
right?
I'd have to prove intentionality in this bill.
Not only intentionality, but intent to mislead a public servant.
Correct.
Right, a high bar. In line 121 or 120, right thereabouts, we have come down from intentionally to knowingly, and we've taken out with intent to deceive. So I didn't notice this last year, but it's been brought to my attention from some union attorneys that there's concern there that the accidental stuff could be used against an officer in a decertification process. Did that come up at all? Do you have any objection to adding that same bar in there with intent to deceive somewhere in line 120? This is for the decertification part, I think.
Yeah, I have no position or
Okay.
opinion on that.
And then the last part on this bill is the governor's bill that came last year got an amendment that added the last 3 lines.
Yep.
Any record pertaining to a formal complaint against police officer, it's an FOI exemption. You're familiar with it. I don't need to read it to you.
Yep.
And I assume that as this bill is drafted now, the board endorses that section as well.
The board agreed to support the bill as it was amended on the House floor last year, which would include this language.
Okay, do you personally have, because you work in this field, right? This is.
I don't have any opinion on section 4. I have stronger opinions on sections 1 through 3. Section 4 to me was something I chose not to have an opinion on even last session.
Right, like whatever you guys work out, you work out, right? I got it. All right, can we jump back to 7132? And Mr. Chairman, I'll be fairly brief. I just want to say, you've mentioned several.
I don't mind brief or long or whatever. I just want to make sure we're not retreading ground that's already been well tread, if that makes sense.
It does. I
Thank you, sir.
appreciate it. But I think there's a couple of points to be made here that have yet to be investigated. Because Ken, you mentioned several times the police see the plate, the police see the plate, the police see the plate. But it seems that there's been no attention to witnesses seeing the plate. And the ranking member touched on this briefly. And you said, he said, well, if there's a heist and somebody reports a blue and white plate, you said, well, the police can stop and then they could stop it on the reasonable suspicion. I would agree. But what happens if they don't find the car, right? That's sort of my concern. If we allow the state to be obscured, which this bill would do, regardless of what state they come from, and a witness sees a plate and can't get the state because they're not familiar with it. Certainly if it's Connecticut, Rhode Island, Massachusetts, New York, the ones we all see, I get that. And they give a number, assuming they had the numbers correct, an officer could feasibly sit there and run 50 different plates, right? Theoretically, and try to see a car that matches. But if they get one letter off and we don't have the state too, the odds of finding that are significantly worse. Has there been any consideration to the witnesses in providing information for the follow-up investigation, not the on-site stop? Does that make sense?
Yeah, I don't know what consideration's been given to that. I will say that, look, this happens often, right? In that there are a variety of different scenarios or anecdotes used to sort of, make a point about which I think are perfectly valid. I think what the body is being asked to do is to weigh those potential scenarios, the frequency of those potential scenarios, the benefit of those scenarios to public safety versus, how we've historically seen, for example, those statutes used. We've historically seen those statutes being applied more frequently in communities of color, not because they're more frequently to have those violations, but because police are more likely to look for those violations in those communities. When police do look for those violations in communities that maybe are whiter, for example, they find violations at a similar rate, sometimes at a higher rate. And so I think what we're grappling with is needing to balance the degree to which some of these laws have been applied over the course of the last many, many years, the disparity that they may have contributed to, and is that still worth, the scenarios that you're outlining? And look, the body being this body may decide, look, that is still, the reality is the disparity may need to be an unintended consequence of that benefit to the enforcement community or not.
All right, so let's talk about that for a second, because I had questions about that as well. Look, people say to me all the time, hey, if a car has an out headlight and it's dark, you have no idea what race of the driver is, and that's true.
Yes.
But you make the point, and I agree with you, you can racially profile simply by where you're choosing to do enforcement. That's your point, right?
Well, I have to be careful, right? When we talk about racial profiling, right? Look, we actually don't, we've been at this a long time. We don't have any I think, strong evidence, not the way we frame it, that a department or a person is engaged in racial profiling as defined by statute. That doesn't mean that the application of the laws doesn't disproportionately contribute to racial disparities. And we know, for example, I've got examples of departments setting up license plate readers, for example, and running plates in a predominantly Hispanic neighborhood
That's my
based
point,
on
right?
an assumption that they're more likely to be unregistered. And when in fact we went in and looked and we applied the same enforcement technique to other parts of the community, registration violations were found at a higher rate in areas where they weren't looking. So sometimes an unintended consequence, that's how I'll try to frame it here today, of certain enforcement techniques is a disparity, is disparate treatment. And not because the police wake up in the morning and decide, I don't like group A and therefore I'm going to target them, but because the reasons for enforcement decisions are complicated, they're driven by lots of factors, and sometimes we just don't look at it the way that we try to look at it.
Well, I would say to you that if you put an LPR in a predominantly Hispanic area and just there, regardless of the definition, I think that that's a degree of racial profiling, but that's just my opinion. You have testified in this bill multiple times, and what you have said to me in the past, and I want to make sure I heard this right years ago, and there was a question in the previous speaker. The data supports that Black and brown drivers are more likely to be stopped for these low-level offenses, but they are no more likely to have them, based on your research, correct?
Based on our research, police will generally find what they're looking for where they look for it. And so we know we have not found differences in violation rates across racial groups, meaning we have no evidence to support a claim that Black drivers are more likely to drive around a vehicle with a headlight out than white drivers. We do have evidence that police are more likely to look for those offenses in areas where they're more likely to be. And the reasons for that are, I'll give you an example. I've used this example publicly before, so I'm not outing a department because I've shared this publicly, but Newington for a long time stopped cars for low-level lighting offenses in areas where Black and Hispanic people were significantly more likely to be, because those were the same areas where the bars were in town, right? So as you got closer to a main road and where the drinking establishments were, the driving population got more diverse because of the way the infrastructure of the town was built. And so they were looking for drunk drivers by stopping lots of cars for low-level lighting violations, hoping to speak to drivers to determine if they were intoxicated. Did they set out to disproportionately stop Black and brown drivers? No. Was that a consequence of their enforcement strategy? Yes. And then the question was, well, is it effective? Look, if you're getting more drunk drivers through that enforcement technique, then you may be able to go back to your community and say, we understand this is happening, but look at how effective it is. Our data told us it wasn't effective. They weren't finding more drunk drivers, right? And people in that area weren't more likely to have a headlight out, but they were more likely, because of the strategy police were using, to be exposed to that type of enforcement because of the roving DUI patrol police were doing in that area.
I appreciate the fact that you dig deeper into to tell the story, not just what the data says, but all the circumstances. And I'm grateful for that PD. But in previous iterations of this bill, when you testify, my recollection is that you have expressed to me that the data supports that Black and brown people, for a variety of reasons, whatever they may be, in the state of Connecticut, are stopped at a higher rate for these low-level violations, but are no more likely to have them.
That is accurate statement. Yes.
Okay. And then you and I discussed it further. And I asked you 3 years ago when this bill first came out, because of socioeconomic reasons, are Black and brown people more likely to have unregistered vehicles, misuse, no insurance, suspend a license? And my recollection is your answer was yes, they are statistically more likely to have those violations.
We've specifically looked at it related to registration. We have not found a disproportionate likelihood that Black or Hispanic drivers, as an example, are more likely to be driving unregistered vehicles. We have found a marginal difference in the rate of uninsured drivers based on socioeconomic status. So insurance is complicated, but registration, we're seeing violations across racial groups evenly.
How about misuse of marker plates?
It's such a small fraction of what is in our data that there's really not any substantial information on that.
And what about suspended licenses of folks in that community?
Suspended licenses, we have found a disparity. Again, it's a very small number of the overall outcomes of stops. You're typically not stopped for a suspended license. It's a disposition of a stop. They stop you for X reason, determine who the driver is, and determine that the individual is driving under suspension. And that does contribute to some of the disparity around some of our arrests that result from traffic stops and misdemeanor summons.
And my last question is, you and I discussed this again in its first iteration. And I suggested to you that police officers, because they need a reason to run a plate, right? They can't just run plates. They need a reason. That they may run plates for low-level violations, and when the plate matches, there's no warrants, the person's got a valid license, because they want to do more targeted enforcement on these more major issues, they choose not to stop those cars, and they only stop the cars that when they run that plate, something pops up like no insurance, suspended license, etc. Then,
but just to clarify, a police officer can run a plate to determine if your insurance meets the state requirement.
They can't just sit on the side of the road and run license plates. There's case law. They can't do that. And on top of that, collect an NCIC prohibited. My point to you is, if police officers are running plates for low-level violations and triaging to make the best use of their time to those higher-level violations, then they would stop, assuming what you said, that people that are of that community are more likely to have insurance issues and whatnot that are going to pop up when they run the plate. That would explain it. And I asked you, we've talked about this 3 years ago, and I said it'd be interesting to poll police officers and see how often they operate under that premise.
Well, I think we would see, apologies, I think we would see in the data a higher arrest rate then, or a higher misdemeanor summons rate for those violations, and we don't, for registration in particular.
I thought you said that you do see a higher arrest rate on those.
We see a higher arrest rate for suspended license.
That's what I'm talking about.
Yeah, no, I thought we were talking about registration.
So has the data that you do and the research that you do, have you taken the opportunity in those last 3 years to poll police officers to find out how many operate on that, or is that not data that you want?
Sorry, can you just clarify the question?
Sure. In other words, poll police officers, say, how many of you operate on this premise? Like I said to an earlier speaker, I would love to poll police officers and say, how many of you put 2, 3 different degrees of accident, or you're going through that accident report, hey, this guy's at fault, 14,245, fair grant the right away, bam, bam, accident report, done. Because I bet you most of them do that. But anyway, my question to you is, how many have you polled police officers or police chiefs to say how many officers operate in this premise when they're doing motor vehicle enforcement? They run plates for low-level violations. When something pops, they choose to stop that car.
We have not polled police officers.
Because that data could thwart this notion that there's racial profiling.
Again, I think we talked about sort of the complexity around the definition of profiling.
Sure. All right. Thank you. Thank you, Mr. Chairman. Thanks.
Further questions or comments? Representative Lamamier.
Good afternoon. Thank you for being here. I just want to go back to 1436 real quick. I know it's listing a police officer intentionally entering false information as a Class D felony. Why do you think it needs to be a crime as opposed to just say grounds for decertification?
The recommendation that it is a crime was a recommendation that came out of Attorney Daley's report to the governor last year and her investigation of the state police. I don't know that we ever actually specifically weighed in on whether it should be a crime or something else. I will say, though, that we have a limited number of examples of both municipal police officers and, in the case of the state police audit we did, of a number of individuals that did intentionally falsify. There is a statute on falsification of a record. It was the state's attorney's assessment that that statute didn't apply to those circumstances. And so this was really, I think, their ask as well to say, look, the current fraud statute may not apply. Let's make sure that if there's intentional falsification on a police record, that a similar penalty would apply.
Okay, thank you for that explanation. Thank you, Mr. Chair.
Further questions or comments? Seeing none, thanks for being with us, Ken. Next up will be Kelly Moore.
Chair Winfield, Chair Staffstrom, committee members. I'm Kelly McConney Moore, Deputy Director of Legislation at the Policing Project at NYU School of Law. I'm here to testify in support of HB 7132. As discussed extensively, this bill would free up police to spend their time on the most impactful traffic enforcement. In Connecticut, 67% of roadway deaths in 2022 were a result of alcohol-impaired driving or speeding, the kind of serious safety-related offenses that officers should focus on enforcing. Focusing on stops for these kinds of behaviors rather than non-safety offenses could make a real difference, since according to the Connecticut Data Collaborative, about a quarter of all traffic stops in Connecticut are for administrative or non-safety offenses. Jurisdictions that have put similar restrictions in place have seen traffic accidents and deaths fall. HB 7132 also has other benefits. Low-level traffic stops, as you've heard, contribute to racial disparities in policing. In Connecticut, as you know, Black and Hispanic drivers are stopped more often. And in the past, several Connecticut jurisdictions have attempted to address these disparities. Scholarly analysis of these efforts show that the reforms led to a 30% reduction in the average number of stops of Black and Hispanic drivers and a significant decline of unsuccessful pretext stops. In other words, those stops where no evidence was turned up. HB 7132 would help ensure similar progress statewide.
Thank you. Questions or comments? Seeing none, appreciate you being with us. Elizabeth McElhaney.
Good afternoon. I would like to thank the chairs and distinguished members for the opportunity to provide testimony in opposition to Senate Bill 1437 as written. I've also submitted written testimony online. My name is Elizabeth McElhaney, and I'm a health information professional with over 15 years of experience in ensuring that patients have secure and convenient access to their medical records. I currently serve as the regulatory chair for HEOS, and I'm also the Director of Compliance and Government Affairs at Burisma Systems. I hold certifications from multiple professional associations in healthcare privacy, release of information, security, and cybersecurity. I've been listening to previous testimony, and I wanted to provide additional information about the complexity of medical records requests. I believe that there's a misconception that newer technology has radically decreased the expertise and effort needed to process medical records requests. I would suggest that that is not the case. The adoption of electronic medical record software has resulted in more data being captured than ever before. EMR technology has also increased the risk of highly sensitive information, including HIV/AIDS, and reproductive health information being released when not authorized. This highly sensitive information is now inextricably intertwined throughout an electronic medical record due to the use of templates and reports which reference test results and prior medical histories. There is not a button or option to remove this especially protected information. Quite simply, there are more places for sensitive information to hide, if you will, in EMR records, and the risks of inappropriate disclosure have never been higher. I would like to offer a recent example for the increased size of responsive records. One request that was recently processed by my own company resulted in over 225,000 pages being released. This was not a complete chart request. I would also like to clarify that I know that there was not duplicative information in this record request because the software developer itself had to assist us in generating the information. But every page still had to be reviewed to ensure that it was the information requested and no more. To process a request, this procedure must be repeated for every EMR application and record source a provider has. I think this is a very important point. An individual has to review each page, whether that's a page in a PDF file or a paper page. The HIPAA privacy rule does not reduce our privacy obligations to patients based upon the format of records. I want to thank you for the opportunity to provide this testimony today in opposition to SB 1437 as written.
Thank you. Questions or comments from the committee? Seeing none, thanks for being with us. Josiah Schley.
Yep.
Good afternoon, respected members of the Judiciary Committee. My name is Josiah Schley. I appreciate the opportunity to speak today. My testimony is based on my personal knowledge and publicly available information, and non-malicious and is truthful as much as it can be. I would first like to oppose 7065, the psilocybin bill, and I would substitute in its place a public hearing for HB 6377. The cannabis injustices have not been addressed. And within that, I would like to offer support for SB 1436 regarding police data reporting. Currently, there are police codes being used, such as operating a drug factory, intent to distribute, and there are individuals who have been arrested and charged with multiple felonies for possession of 6.425 ounces of cannabis, yet 6.5 ounces of cannabis is allowed due to 5 ounces in a secured place and 1.5 ounces on your person. I urge you to urge the judicial system to research these cases and because rendering cannabis justice reform untraceable, and it's not right. I would also like to comment on HB 7072, the antitrust bill, and suggest that this go through some kind of government oversight review as opposed to the Office of the Attorney General. And I would also like to offer an amendment to that bill to include not just stocks, but to address the cannabis licensing system. That is a very clear monopoly that has been set up in Connecticut. I think it's the silent elephant in the room that everybody knows. And then amendments for Raise Bill 1436, I would amend to not only cite, but provide the entire statute used to justify the stop, arrest, and search, and provide that to the arrested persons. I have been arrested for 0% VAC, 0% THC, charged with the DUI, and spent 13 months in court fighting that, even with zero evidence against me. So I do think this false reporting should absolutely be a felony and or serious crime. I also want to amend potential retroactive justice for people like me who lost employment for months and 13 months and had to pay lawyer and court fees that I can never recover. And I've gone really fast here because I'm worried about time, but I would like to refer you to 3 documents of testimony that I've submitted.
That's
and
that's the
I
ballot.
appreciate your time.
Thank you, sir. Seeing no questions, appreciate you being with us.
Thank you.
Freeman.
Good afternoon, members of the committee. And I'm here to speak in support of proposed bill 1437. I am the executive director of the Connecticut Center for Patient Safety, and we represent patients and people and all people who are involved in healthcare in the state of Connecticut. I've testified here before on this or the similar preceding bill. And I have a few points. I did submit testimony, so I'm not going to repeat what was submitted in writing. I think it's important to know, I have come here and become involved in this cause because my husband experienced severe medical error that led to very critical healthcare situations and ultimately to his death. We went through the hospital system. It took many years. And our experience was that initially hundreds of dollars were spent when we went to attorneys and people professionally to find out like what the hell happened. We had to pay for the records, as was stated earlier. And we, even at that, with the attorneys requesting them, full records were not initially turned over. A judge had to get involved. As patients, I hear all the time when people call our organization that they're not getting complete records. They're getting stonewalled. They're getting charged what seems like ridiculously huge amounts for things. And yet there are other times where the federal guideline of $6.50 for a disc is what's charged. And we're going to say that we would like to urge you to look at that. It's working in many, many places. And if there can't be a $6.50 flat charge, at least a very reasonable cap. Patients who are involved in medical errors are bewildered. They don't know what's going on. They need to find out. They have to be able to get on with their lives. So I ask that the records that are actually theirs about them, HIPAA wasn't written to protect the medical establishment. It was written to protect patients primarily. I ask that it be honored in the way that it was written, with the intent in the way that it was written. The difficulty that we had getting our medical records, that I get calls weekly from people who are trying to find out what happened, what they can do, everything else, and they cannot easily get their records. Also, when you request medical records and they're electronic, sometimes one page is 5 lines of text because they are. Well, I thank you for listening to me. I'll be happy to answer any questions that y'all might have.
Thank you, ma'am. Thank you for sharing your story with us. Appreciate being with us today. I don't see any questions. Thank you for taking the time and sticking with us till almost 4 o'clock on a Friday. Almost 4 o'clock on a Friday. Try to keep it moving. All right. Aaron Doolittle.
Hi, good afternoon. Thank you to the committee for hanging in there until almost 4 o'clock on a Friday. I'm not going to make this super long. I did submit written testimony. But my name is Erin Doolittle. I am back here once again to support decriminalization of small amounts of psilocybin, HB 7065. I'm not going to repeat too much of what I wrote about, but essentially I have been a trauma therapist for over 20 years. My belief in treatment is that patients shouldn't be strapped to a therapist for decades at a time. We should be able to provide efficient, effective treatment that allows them to improve their quality of life in as little time as possible, and as low of expense as possible. So I did meet with an amazing veteran group in February, and these were combat veterans. These were Marines. I'm also the ex-spouse of an Iraq war veteran, so I've been through a lot of deployments and the PTSD that can follow. And they pointed out to me something that had not occurred to me, which is that in order for them to get the treatment that they really needed, they had to go to a nonprofit, get accepted by this nonprofit, receive funding to fly them across the country or wherever they're from to Oregon and put them up for a few days, in a hotel so that they could get psilocybin treatment specifically. They were offered ketamine by the VA. They said it was okay, but they all, as a group, roundly said we prefer the psilocybin. And some of them had even gone further to go to South America, Peru, Mexico, to continue with psychedelic treatment. And they found it very frustrating that they had served their country, again, combat veterans, but they had to leave the country to get the treatment they needed. And none of it was covered. They had to fundraise for all of it. So I just wanted to share that story with the folks today because I've spoken about psilocybin as to the efficacy and the safety of it plenty of times. I know you've heard it all from me before. But I mean, the truth overall is that it's remarkably safe. It's well tolerated and virtually impossible to become addicted to. It doesn't work if you use it too much. If you have the greatest experience of your life on a Tuesday and you try to do it again Wednesday, it's not going to work. So, you know, there's a lot of talk about psychedelic treatment right now. It's all over the news. And, you know, once again, Connecticut does have the opportunity to decriminalize. There is a bill submitted by Connecticut for accessible psychedelic medicine that had gone through. It was HB 5456 that actually has a medical tier plan that would involve essentially a mushroom card that you would be evaluated by a mental health professional to ensure that you would be a safe choice. And that card would allow you to consume and grow your own and treat yourself. We have no interest in a retail market whatsoever. And we just want to get people what they need. So thank you.
Thank you very much. Questions or comments? Seeing none, appreciate being with us.
Thanks.
Neil Drift.
Good afternoon, honorable members of the committee. I fear we'll have to resurrect this 7132 horse so we can beat it again. So I'll try to be very brief. I'm not going to read you my testimony. I've submitted it in writing. It's the verbatim. I'm here in spite of the fact that I've been a member of the Racial Profiling Prohibition Project Advisory Board for about 13 years now. I'm here today to represent the Connecticut Police Chiefs Association. We have two concerns, as you can see from our written testimony. The first is that we respectfully disagree that the lack of two working headlights on a vehicle is not a safety concern. We believe that it is. We stated some reasons there in our testimony. Again, I think it's been brought up by a number of the people testifying and through your questions. Again, happy to discuss it further if you would like. We also have some concerns with the section on the display of license plates. Again, those things have been discussed kind of extensively here. We wanted to point out a slightly different take on it. This body passed legislation recently allowing speed and red light cameras. And our position, somewhat anecdotally, from the school bus cameras, which in Cheshire we were early adopters of, is that the placement of license plates in the rear windshield and with obstructions around them that obstruct other information on the plate has, in some cases, made it more difficult for our officers to identify a vehicle that has had its photo taken passing a standing school bus. And I think with the advent of these speed cameras, which I don't think anybody's quite gotten through the process and have them up and running yet, but I know that there are a number of communities looking to do that. And I think there'll be a level of frustration on the part of your motorists who see people commit blatant violations that are captured on these cameras that are being used as the community and the legislature has intended, but you're unable to take the appropriate enforcement action because you can't identify the driver because of an obstruction on their license plate. So look, those are the two main things that the Police Chiefs Association wanted to bring up, and I certainly am more than willing to answer any questions that you might have.
Chief, quick question for you on that last point. So my wife recently was in an accident, had to get a new car. Not by choice and not her fault, but anyway, be that as it may. So I got her, when we got the car, I got her one of those little things that says Fairfield University Go Stags on it, right? And put it on the back. Based on the testimony I heard today, I guess I got to go home and take that off this weekend because that's grounds to pull her over. Is that your understanding of current law in Connecticut?
Yes. And again, I would just offer that I don't think that happens as much as some people would have you believe. And again, I think when the officer, I agree wholeheartedly with some of
no matter how
right.
often it happens, though,
right? Yes.
Right? I mean, will you agree with me that we should not be pulling cars over in 2025 in the state of Connecticut because somebody has a, Fairfield University alumni frame around their license plate, and that we should change the statute so that that is not an infraction that is not a reason to pull somebody over.
I can agree that if it's still clearly legible that it's a Connecticut license plate, that yes, you shouldn't be pulled over for that.
Okay.
But I've certainly seen some of those license plate frames that completely obstruct everything on the license plate except the letters and numbers.
So how about the other thing we hear all the time is, look, you know, the fuzzy dice or even the easy pass kind of affixed to the window is technically a violation under Connecticut law.
Yep.
That's true, right?
It is, but again, the Police Chiefs Association did not take a position on any of the things related to the windshield.
So you guys are okay with, so, you know, if we took out, essentially, if we took out the provision of this bill that was related to the headlights, and if we changed the license plate display so that it's clear that as long as you saw the numerals and you knew what state it was, you guys, no opposition to the bill after we make those two changes?
Those are our two main concerns, yes.
Okay, all right, good enough. Representative Howard?
Thank you, Mr. Chairman. Thank you, Chief. In all your experience as a police officer and a police chief in this state, I know you've worked in other agencies. Has a police officer ever come in your office and expressed to you that they're frustrated because they would like to stop more drunk drivers, but they can't because they're bogged down with out license plate lights?
No.
And how many years have you been in law enforcement?
35.
And it's never happened.
Never happened.
Because representations get made here that police officers are not making good use of their time. They can't because of these low-level violations, but you would disagree with that.
I would.
And as to license plate readers, so license plate readers managed by the government, whether it's your agency or the state police or DOT or anybody else, are one thing. And you touched on speed cameras, and you touched on the bus cameras. Or do you know, and maybe you don't, maybe I should ask this before, I'm sorry, but do you know that there's a product on the market right now that you could put over your license plate? It's transparent to the naked eye, but it blurs it out when a camera catches it. Have you heard about this?
Yes.
So if this legislation passes as it is, that would be legal, right?
I don't know, to be perfectly frank
Well,
with you.
let's just take a little walk through it, because in the bill, it says that the license plate, and I know you talked about placement, and I do agree with you, placement's important, but it says that the license plate has to be provided the numerals and letters on any such number plate are plainly legible. So if I took a transparent, if this bill passes and I took something that's transparent and it only blurs it out when a camera sees it, it would be legal, right? And if it helps you, this language is line 16 and 17.
Yeah, I concur with what you're saying, yes.
Right, so if this bill passes, I can do that. I can put that transparent tape over mine, and no speed camera, no LPR, no school bus camera protecting our kids will ever catch my plate.
That is conceivably correct.
And no police officer can do anything about it.
Yeah, I would agree with that.
Yeah, I would
As
agree.
long as the police officer can see the plates, the
Right.
numerals on the plate when,
Right.
when
And
they're
then-
directly behind you.
Were you here earlier when we talked about accident reports and the way officers complete them?
I was.
Do you, in your review of accident reports, do you find that officers are generally putting secondary and tertiary contributing factors?
Not only do I agree with your premise that they are not doing that, I also think that it's extremely difficult in some of these cases for a police officer with their level of accident training to make that determination in the first place.
So in all your experience, let me just say that back to you to make sure my colleagues understand, the data may say that that very limited number of accidents are caused by, say, an out headlight. But in your experience, well, you would expect that even if 10% of accidents were, you would expect the data to reflect a much lower number because of the way that accidents are investigated and reported, correct?
Yes.
Okay. And I think that's all I have. Chief, you're always great to have here, and thank you for your continued service to the state. Thank you, Mr. Chairman.
Thank you.
Thank you. Questions? If not, Chief, appreciate you sticking with us. I
Thank
know
you.
it's been a long day and probably had other places to be today, but it's important to hear your voice. Appreciate you
Thank
being here. Gregory Baylor?
Good afternoon, Chairman Winfield, Chairman Staffstrom, Ranking Member Kissel, Ranking Member Fishbein, and members of the committee. My name is Greg Baylor, and I serve as Senior Counsel with Alliance Defending Freedom. Thank you for the opportunity to offer our analysis of Senate Bill 1380. Our primary concern with the bill stems from its inclusion of, quote, gender identity and expression, close quote. Let me state at the outset that no one should be denied healthcare based simply on who they are. It would be wrong, for example, for an emergency room doctor to refuse to treat a patient's broken ankle simply because he or she identifies as the opposite sex. And our concern is not with such potential applications of the proposed law. Instead, we anticipate that enforcement officials will interpret SB 1380 to require healthcare professionals to respond to gender dysphoric individuals in particular ways, by injecting children with puberty blockers, by administering cross-sex hormones, and by performing irreversible and often sterilizing surgeries. Our expectation that SB 1380 will be interpreted this way is based in part on how Section 1557 of the Federal Affordable Care Act has been construed. It bans sex discrimination in the provision of federally funded health care, and both executive branch agencies and courts have interpreted it first to reach gender identity discrimination, and second, to require these particular responses to gender dysphoria. So this likely interpretation of SB 1380 raises at least two potential problems. First, many healthcare professionals object on conscience grounds to performing such interventions. A number of federal courts have agreed that federal ACA Section 1557 violates the consciences of these providers and cannot be legally applied to them. Second, mounting evidence indicates that so-called gender-affirming responses to gender dysphoric children often do not accomplish their goal of ameliorating the distress that accompanies gender dysphoria. Moreover, the multiple downsides of these interventions are becoming more apparent. For example, England's National Health Service stopped prescribing puberty blockers for gender dysphoric children because there is, quote, not enough evidence to support the safety or clinical effectiveness, close quote, of puberty suppressing hormones. Thank you again for the opportunity to testify, and I would be happy to answer any questions you might have.
Seeing none, appreciate you being with us. Lorraine Nolan.
Hello. Hello, and thank you for the opportunity to testify in opposition to SB 1380 as written. I have concerns about including gender identity or gender expression as a protected category in law. Therefore, I am asking you not to include this subjective and in some cases changing feeling, and instead allow the category of sex, which is an unchangeable physical status, having medical and social consequences to remain. SB 1380 would prohibit discrimination in healthcare based on the incoherent category of gender identity, making it a protected category in law and policy. Because the category is incoherent, the bill is incoherent. As an example, the American Cancer Society has an initiative to conduct research on the effects of cancer on the Black female population. Their goal is to improve health outcomes for Black women and cancer. However, those assigned male at birth Black men who claim to be Black women were allowed to participate in the research simply because they claim to be women. When I wrote to the organization to ask about this, they said they did this in order to be inclusive of women claiming to be men, but I received no explanation of why men were included. Cancer is a very serious and often deadly disease, sometimes more so for Black women. How on earth can any medical professional not take this seriously, but would rather appease the sexual fetishes of men by including them in this research, instead of prioritizing Black women's health as they claim to be doing? So what if one Black male or any male participant felt discriminated against and if not allowed to participate? I also submitted written testimony, but I'm not going to go into that. I know we've been in here all day. But I just thank you very much. And I just please ask that you just to consider what I've brought forth. Thank you.
Further questions or comments from the committee? Seeing none, thanks for being with us. Sharon Brian? Sharon Brennan, okay. How about Amy Chai? Amy Chai?
Hello?
Okay.
Hi. Hi, thanks you guys. Been a long day. I guess I'm the last person, so that's good for you all, I guess. I'm Dr. Amy Chai. I'm board certified in internal medicine and also in addiction medicine. And I am speaking in opposition to SB 1380, but not for the reason you're thinking. Because I get what you're saying. I run a methadone clinic. So yes, I do get what you're saying about discrimination. And I changed my testimony today because I can fix the problem, but probably not with this legislation. And I'll explain that just briefly. So Title VI of the Civil Rights Act is what ended discrimination on race in healthcare providers. Then the ADA added extra language for disabilities, and then non-discrimination in healthcare, which is item number 1557 of the Affordable Care Act, added religion, sex, age, disability, and gender expression to the non-discrimination laws for healthcare. So this includes all of us who accept any Medicare or Medicaid. So the provisions that we're looking to put in place in SB 1380, they are already codified at a federal level. So this bill duplicates federal legislation that's already on the books, and it would only encourage legal action against medical providers for perceived or unintentional injustices. And that probably isn't going to be healthy for us. So, because we can't really legislate good cross-cultural communication. So we have disparate impact bias under Title VI, and it disproportionately affects minorities and immigrants who have trouble getting access to care. And this has already been litigated at the Supreme Court level. The case Alexander versus Sandoval ruled that nobody has the right to sue for disparate impact bias unless they can prove that the bias is intentionally designed to harm a certain group. So in access bias, the problem is that doctors are paid a lot less for Medicaid patients, which disproportionately affects Black and Brown people. And these patients are a lot sicker, they're a lot harder to care for. And so we are working twice as hard for half the money when we see a Medicaid patient. And if we actually want to stop disparate impact bias, pay doctors fairly for Medicaid patients, because money is the reason for that bias. And that's a full stop on that. But if you want to prevent like perceived or perception bias, you really need to work on cross-cultural communication, because the threats of lawsuits or prosecution, it creates a hostile environment. And what that's going to do is create an adversarial relationship. So what we want to do is we want to create relationships that actually work and bring people together and build like a therapeutic relationship with the healthcare providers. And so there is a huge difference between these two approaches. So how we fix this is with mediation and communication. And I could explain how to do this, but that would take more than 3 minutes. So I yield my time.
Good timing on the bell. Questions or comments from the committee? Seeing none, thanks for being with us. I will declare our public hearing for today closed at 4:04. All right, for planning purposes, so folks know, there's an agenda out for Monday's public hearing, and there's also an agenda out for Wednesday's public hearing. So we will be back here both of those days. Good news, we got through a lot of bills in our first 3 public hearings. It looks like at this point we will not have a hearing on March 14th. So Monday, Wednesday, unlikely to be here Friday. So a little bit of reprieve for folks after what we anticipate will be another couple long days, Monday and Wednesday.